Every day in the USA, people find themselves in court.
It's way out.
Mustang.
Arraignment.
One arraignment and one Wild. Who's the arraignment? Mr. Thompson. Jeffrey.
Sí, sí. I think they were.
It's all right.
Back in 73, which would have been Smiley High School. 50 years.
I guess YouTube's messed up again because it's not working like it should normally. I don't know.
Yeah.
But it's not, again, it's not working. So I'll mess with it later. Let's get started so we don't keep people waiting. All right. Ready, nerds? All right, Jesse.
Yes, Judge.
Hey, good morning.
Manzano is on your docket, Judge, second DWI.
Okay, come on, bring him up.
Manzano, come on up. You didn't say let's roll.
Happy Friday. Good morning. This is Manzano. Good morning, Mr. Manzano. Sir, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney. If you cannot afford one, one will be appointed to you, sir.
On July 6, 2024, officers conducted a traffic stop on a truck with a very low truck bed that was spraying heavy sparks towards other drivers, causing them to take precautionary matters by changing lanes. The driver was ID'd by his Mexican driver's license. Officers observed red glossy eyes and a strong odor of alcohol on the breath. Standard field sobriety test was conducted, 6 of 6 on the HGN, 3 of 8 on the walk and turn, or yes, 3 of 8 on the walk and turn, and 3 of 4 on the one leg stand. DIC was red, breath was a 0.126 and a 0.134.
Tell me about the prior DWI, please, and how many other ones does he have, if more than just one?
He has one conviction on June 5th, 2024 in the court number 4 in Montgomery County, and then a third DWI out of county also in Montgomery County.
That's the same one, Judge.
It's a true second.
Mr. Manzano, you don't have a Texas driver license, do you? You are not allowed to drive. You will be signing an affidavit. This is a document that you're going to swear to me that you're not going to drive. I don't care what's going on in your life. I don't care what you have to do, where you have to go, who you have to haul. No driving. If I find that you drive, I will have a contempt hearing. I will find you in contempt, slap you with up to 180 days in jail and a $500 fine every time you drive, because it's an offense in and of itself. You drive 5 times, I'll have 5 different contempt hearings. Do you understand? Do not drive. There's no justification you can give. Because it's a second offense, I'm ordering you to obtain a handheld interlock device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol.
Yes, sir.
If I find that you consume alcohol and any kind of dope, you will go to jail. You will not get any more PR bonds. Do you understand?
Yes, sir.
Now you've got Jesse representing you. Listen to him. He will take care of you. If he comes back to tell you that you're playing games, you're not responding to phone calls, text messages, I will issue a warrant. Do not pick up any new cases. All you have to do is stay out of trouble, don't drive, and don't drink. So, I'm gonna have you come up here, swear to us that you're not gonna drive. I'll get you to Victoria, sign a reset. You'll get retraced for your bond conditions, and after that, you're free to go.
Okay, thank you, Judge.
Thanks, guys.
Judge, did you want to start with the Spanish arraignment?
Do we,
Right here, Your
do you
Honor.
have one, Mike? Come on. Where's, I don't see Luis.
He's right
Right
here.
here.
Oh, he's hiding. Ah. Morning,
Minutes
Luis.
for Herman. I'm appearing for Herman. I'm here for, yeah.
Wararez Chavez, come on up. Page 12.
Thanks.
Extra, right this way.
Your Honor, here are the interns.
Wait, wait, wait.
Arraignment, and this is Herman's case. I'm here
Okay,
for him
that's it.
because he's out of town.
Got it. All right.
Okay?
Are you Mr. Wararez Chavez?
Yes.
Mr. Wararez Chavez, you're charged with driving while intoxicated. Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
On July 6, 2024, at approximately 1:14 a.m., officers conducted a traffic stop on a truck crossing the lane divider. The defendant was ID'd by his Mexican consular card. Officers observed red bloodshot eyes, slurred speech, an odor of alcohol on the breath, unsteady on his feet, and the defendant was swaying. Standard field sobriety test was conducted. HGN was a 6 of 6. Walk and turn was an 8 of 8. One leg stand was a 3 of 4. Before securing the defendant in the backseat of the patrol vehicle, they discovered 0.35 grams of a white powdery substance, cocaine, in a small plastic baggie in his right front jeans pocket.
So they have,
DIs,
I don't see that they've charged him yet with it, I guess, huh?
They,
And then,
PCS and, Rivera.
This is Jocelyn Wararez Hernandez, right?
Yes. Yeah, the PCS case.
Angel Juarez, I got Angel Juarez Chavez.
Oh, okay.
Yes.
Sorry, I'm looking at Wararez Hernandez. This is Wararez Chavez. Sorry, I see it. Okay. Yeah, please.
DIC was read. The defendant consented to breath, and it was a 0.243 and a 0.237.
Ready to be honest. Okay. Mr. Wararez Chavez, I'm going to find that there's probable cause to go forward with your case. Tell me, are you a United States citizen?
No.
Are you in this country with or without permission?
Without.
What happens if you go to jail?
I don't know.
Think,
Can't say.
what happens if you go to jail?
Go to Mexico.
Do you know how long you will sit in jail for immigration to do whatever they're going to do? You will sit there for about 6 months at a minimum, perhaps 9 months, perhaps a year, waiting for immigration to do whatever they're going to do to you. You were lucky to get out of jail one time. If you press your luck, you go back for any extended time whatsoever. Immigration will put a detainer on you. You will be stuck like Chuck in jail until all these cases are over with. And I'm going to tell you now, nothing fast happens in Harris County except resets. Do you understand? I'm putting conditions on your bond now. You violate these conditions, I'm going to put you in jail. And if you're unlucky enough, you're going to be there for an extremely long time. You do not have a Texas driver license, so I'm ordering you not to drive whatsoever. You will be signing an affidavit with me today, promising me that you're not going to drive, and I don't care what your excuse is. I don't care if you need groceries. There's a burning building and you have to save a cat. I don't care. You drive, I'm going to put you in jail. and you may be there for a long time. I'm also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. You will be called upon to come and provide a sample to us at some point. If you blow us off, you will go to jail, Mr. Wararez Chavez. Don't push your luck again. Now, you have a lawyer. It's your responsibility to stay in touch with them. They will tell you when you have to come back to court. If they tell me that they can't get a hold of you because you're playing games, I will issue a warrant for your arrest. You understand me? Do not drive, do not consume alcohol, illegal drugs, and stay in contact with counsel. You will not get another warning from me. So take it how you will. We'll have you come up here, swear to us that you're not gonna drive. I'll get you to Victoria to sign a reset. After that, you'll get with Trace for your bond conditions, and after that, you'll be free to go. Thanks, Mike.
Also, I want to ask you a question. How do you translate from English to Spanish, stuck like Chuck?
Ask him. I don't know, but that's why he makes the big bucks.
Thank you, Your Honor.
I will.
Do you say it?
Hey, you ready?
Do you have another Spanish arraignment?
Yeah, come on.
It's not my client. I have one, Spanish arraignment.
Hey, let me just, and then I'll hit you next. Okay, come on, man.
Kosh Tambre. Kosh Tambre.
Page 5.
Morning, Judge.
Hey, Mr. Gallegos, what's up?
Just trying to make it.
I feel your pain.
Yeah. Just escuchen las instrucciones de juez, okay?
Franklin Kosh Tambre.
Yes.
Sir, you're charged with driving while intoxicated. You're facing up to a year in jail because of the high blow. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On July 4th, 2024, officers were dispatched to a crash call. They spoke with a witness who advised that the defendant ran the red light and struck her. Witness observed the defendant get out of the driver's side door after the collision, and officers made contact with the defendant and observed bloodshot.
It's too loud, please.
The officers observed the defendant to have bloodshot eyes, slurred speech, and a strong odor of alcohol on the breath. The defendant admitted to drinking 2 Modelos. Standard field sobriety test was conducted, 6 of 6 on the HGN, 2 of 8 on the walk and turn, 3 of 4 on the one leg stand. GIC was read, breath was consented to, and it was a .168 and a .160. The defendant was ID'd by his Guatemalan ID card.
Do you have any priority to BIs?
No, Your Honor.
Any other criminal history?
No, Your Honor.
Okay. Mr. Kosh Tambre, I'm going to find that there's probable cause to go forward with the case. What happens if you go to jail?
I wouldn't like that.
What do you say?
I wouldn't like that.
Don't tell him. I want him to think, Robert. What happens if you go to jail, Mr. Kosh Tambre?
I have family.
Look at me. What happens if you go to jail? Piense. What happens if you go to jail? Right. Any idea how long you will sit in jail waiting for immigration to do what they're going to do? Take a guess. How long you'll sit there?
I don't know.
You will be there for a minimum of 6 months. So if you have anyone here that depends on you, it's not going to happen. They might look to other people, other places that you may not like for support if you're gone for 6 to 9 months in custody. I'm putting conditions on your bond now, Mr. Kosh Tambre. Do not violate these conditions. This is the only warning that you're going to get from me. You violate these conditions, I'm going to put you in jail. And if you're unlucky enough, you're going to be there for an extremely long time. Do not drive. You do not have a Texas driver license. Therefore, you may not drive. I'm also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. It is your responsibility to stay in touch with Mr. Gallegos. He will tell you when you have to come back to court. Mr. Gallegos tells me he can't get a hold of you because you're playing games. I will issue a warrant for your arrest likewise. Do not drive, do not drink, and stay in contact with your lawyer. You understand? There's no excuse. All you have to do is show up and don't drink and don't drive. And good things will happen for you. I'm going to have you come up here. You will swear to us that you're not going to drive. After that, I want to get you to Victoria to sign a reset. You will then go to Tracy, where we will have you sign your bond conditions, and then you'll be on your way. This is the only friendly warning that you're going to get from me, sir. Take it how you will, but you will not get another one. Come on.
Thank you, Judge.
Thanks, Robert.
George, do you have a Spanish speaker?
Yes,
Last name?
Ricardo Landaverde, but Landaverde.
Okay, page 13, Judge.
Okay. Good morning, Mr. Reyes.
Paloma.
Landa Verde. Yeah.
Landaverde, Ricardo.
Okay. 251, 186, 35.
Good morning, sir.
Good morning.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On July 6, 2024, officers were dispatched to a traffic hazard regarding a stalled vehicle on Broadway. Upon arrival, officers met with a witness who stated he called 911 as he found the defendant passed out behind the wheel of a vehicle. The witness advised that the defendant was in the driver's seat and the sole occupant, and the keys were in the ignition and the car was on. Officers woke the defendant, and after the defendant exited the vehicle, officers observed a strong odor of alcohol on the breath. The defendant stated he drank 3 Coronas. Standard field sobriety test was conducted. HGN was a 6 of 6. Walk and turn was a 0 of 8. One leg stand was a 0 of 4. PIC was read, breath was refused, and a blood warrant was executed and blood was drawn.
Sir, I'm going to find that there's probable cause to go forward with your case. Tell me, are you a United States citizen? Are you in this country with or without permission? What type of permission do you have?
President?
You are a resident.
Yes, sir.
Do you said, but you still don't have a Texas driver license? You do have a license. Do you have liability insurance in your name?
My father.
Okay. Before we allow you to drive, Mr. Landaverde, I want you to 100% be sure that you have insurance. Mr. Reyes, do you mind checking to make sure that he is
Absolutely,
covered?
Judge.
If you are covered under the insurance, I will allow you to drive. Understand, you are not a citizen. The more criminal cases you pick up, the higher likelihood you have of that residency being revoked. They can revoke it at any time. The more criminal cases, the more likelihood that's going to happen. I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If I find that there are, or that you're consuming alcohol or doing anything you're not supposed to, I will put you in jail. You're not a United States citizen, and I don't know if you're a resident or not. But if there's any problem with your paperwork and you go to jail and immigration finds you, they will put a detainer on you, sir. So I would be very careful. I will waive your appearance, but you must stay in touch with Mr. Reyes and he will tell you if and when you have to come back to court. You understand? If he tells me that you're playing games, that you're not responding to phone calls or text messages, I will issue a warrant for your arrest. Okay, I'll have you go to Victoria, sign a reset. After that, you'll get with Trace for your bond conditions, and then you're free to go.
Thank you very much, Your Honor. Have a great day.
You too.
You too, Ernest.
What happened to?
Judge, page 11, another Spanish speaker, Wararez Hernandez.
Are you Jocelyn Wararez Hernandez?
Yes.
Ma'am, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during any questions and interviews with the state of Texas if you cannot afford a lawyer. A lawyer will be appointed to represent you, ma'am.
On July 6, 2024, at 1:51 a.m., officers conducted a traffic stop on a vehicle for running red light. Officers made contact with the driver, who identified herself by her Mexican passport. Officers observed a strong odor of alcohol on the breath, red, glossy eyes, spraying while steaming. She said that she had 2 Michelob Ultras before driving. Standard field sobriety test was conducted, 6 of 6 on the HDN, 2 of 4 on the one-leg stand, and she refused the walk and turn. DIC was red, BAC was a .165 and a .165.
Guys, no criminal history or what?
No criminal history.
Mr. Hernandez, I'm going to find that there's probable cause to go forward with your case. Tell me, how old are you, man?
23 years old?
What do you do for a living?
Cleaning houses?
Are you a United States citizen?
Still in the answer?
No.
No,
Are you in this country with or without permission, man?
no permission.
What happens if you go to jail?
Si va a la cárcel. What do you mean, what would happen?
What happens if you go to jail?
Pasa si usted va a la cárcel. I don't know what happens.
I'm going to ask you again, are you in this country with or without permission? What happens if you go to jail?
They would send me to Mexico?
Right. You will get an ICE detainer. You will sit in jail until immigration is done with you. It will take 6 to 9 months for them to do anything that they're going to do, and you sit in jail waiting for that to happen. If you do not want that to happen, do not violate these conditions that we put on you now. If I find that you're consuming alcohol, I will put you in jail. You are not allowed to drive. You do not have a Texas driver license. I am now making that a condition as well. Do not drive. You will be signing a promise with me. This is an affidavit, Ms. Wararez Hernandez, that you're not to drive. I don't care what's going on in your life. Do not drive. There's no quicker way for you to go to jail. You understand?
I understand.
Okay. Did you want to apply for an appointed lawyer, man? Okay. And we will give you an application for an appointed lawyer. I will have you speak to a lawyer today. First, I will have you come up here, swear to us that you're not going to drive. You'll get to Victoria, sign a reset, and then she will give you an application for an appointed lawyer, and I will take a look at it.
Spanish speaker.
Ay, ay, ay.
18, Oliverio. Oscar Alejandro.
How many more Spanish speakers do you have?
Three more.
Okay, I'm going to do this one, and then I'm going to stop with Spanish for a while. Okay. Are you Mr. Oliverio? Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On July 6, 2024, at 8 a.m., officers were dispatched to a suspicious event call.
Did you say 8 a.m.?
Yes, Your Honor.
Okay.
Upon arrival, they observed a vehicle disabled in a moving lane of traffic with the defendant sleeping on the pavement next to the vehicle. The defendant had an odor of alcohol on the breath and bloodshot eyes. He had a calm demeanor and slurred speech. There were 2 beer bottles in the back right passenger floor, one unopened and the other one had approximately 8 ounces remaining. The vehicle was registered to the defendant and the defendant was ID'd by his California driver's license and El Salvador passport. The defendant admitted to driving the vehicle and stated he was driving home from a friend's house in Rosenberg and had been driving approximately 30 minutes before parking his car and falling asleep. The defendant stated he had 5 beers at his friend's house. Standard field sobriety test was conducted, 6 of 6 on the HGN, 0 of 8 on 4 of 8 on the walk and turn, and 0 of 4 on the one leg stand. DIC was read, breath was a .138 and a .133. No, Your Honor, just one possession out of California with an unknown.
Possession of what?
Just as controlled substance.
Okay. Sir, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any kind of dope, I will put you in jail. You will not get any more PR bonds. Do you understand? Are you a United States citizen?
No.
Are you a resident? Do you have permission to be here or no permission?
Not yet.
So are you in this country with or without permission?
No, por el momento no tengo.
I don't have any.
You go to jail and immigration finds you, they're going to put a detainer on you. You will be stuck like Chuck in jail for the next 6 to 9 months, waiting for immigration to do whatever they're going to do to you. Behave yourself while you're out in the free world, otherwise I will take it away from you. Do not drive. Do you understand? Yes or no?
Yeah.
You will be signing an affidavit with me today, promising me that you're not going to drive unless we know that you have a Texas driver license. You're not allowed to drive. Do you understand, sir?
I understand.
Okay. We're going to reset your case to give you time to hire a lawyer. I'm going to have you come up here, swear to us that you're not going to drive. After that, you'll get to Victoria. We'll have you sign a reset. You will meet with Tracy for your bond conditions, and after that, you'll be free to go. Show up, come back, because if you do not come back, I will issue a warrant. Do you understand? All we're asking you to do is don't drink, don't use drugs, and do not drive. Understand? Come on. Okay, you ready? Okay.
Cases, one is an arraignment.
Let's do the arraignment first.
Jeffrey Thompson.
Okay.
Page 29.
Hey, what's up? Good morning, Mr. Thompson. Mr. Thompson, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On April 15th, 2024, complainant and defendant were arguing at their home in Myriad, Texas. When complainant confronted defendant about taking her car keys, defendant immediately shoved a complainant, so complainant said that she was going to call the police to report that, as well as defendant's past violence towards the complainant. Defendant told complainant he'll be sorry for doing that and then left the scene. Complainant told officers that earlier in the day, complainant threw a rock at defendant's vehicle during an argument. Defendant responded by grabbing complainant by the hair, dragging her up the stairs into the home and throwing her to the ground. causing her to feel pain. Complainant stated that she didn't initially report for fear of retaliation and is now requesting a protective order.
Any alcohol mentioned? No? Okay. All right, Mr. Thompson, I'm going to find that there's probable cause to go forward with the case. So she does want a current protective order.
We have completed the RIP this morning, Your Honor, and she
Okay.
wants him to come back home.
What do you think? What's your position?
I would like him to be able to come back to the house, but he has no prior assault cases. This is his first domestic violence case. It happened back in April, Judge, 3 months ago, and there hadn't been any issues since then. I'm going to tell him and her to go into some counseling. I think that might be beneficial to the couple. But I do think.
Mr. Thompson, the problem is that I don't know what kind of relationship you have with this person, but if it's a volatile relationship where both of you are constantly at each other's throats, you know.
What?
I don't want to talk about the case, right? My only concern is I don't care about past. I care about the future. And if you're someone that loses your temper easily and she knows how to push your buttons, is it a wise decision to go back? I don't know. I'm going to leave that up to you. I am telling you now that I am going to issue the protective order. The protective order is such that she is now labeled as a protected individual. You cannot commit family violence and assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is a stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You're not going to be in possession of a weapon. This usually also comes with a residential restriction, meaning that you cannot go back to the house in question. I will take this off if she's okay with you going back, but everything else in the protective order, stuff that you shouldn't do anyways, right? And understand though, can words violate this statute? Can conduct violate this statute? If I go like this, is that threatening or harassing? It most certainly is. So conduct alone in and of itself can violate this protective order. That's why I'm saying, I don't know what kind of relationship you have with her, but if it's a kind where you're constantly butting heads, I would be very careful. She knows how to push your buttons and she knows how to contact the DA. All she has to do is say something. Guess who goes to jail? Be careful. That's all I'm saying. So we'll just do no threatening, no harassing contact, no weapons, and that's it.
MOAC will need to be amended.
I will.
Just want to make sure. Okay.
Right. So I'm going to issue the protective order. We will take out the residential restrictions so you can go back. Just be careful.
So you're amending the one that they have already?
When was that granted?
7-1.
What's today? Sure. Yeah. You have a lawyer. I will waive your appearance so you don't have to waste your time coming to court, but stay in touch with him and he'll tell you if and when you have to come back. Okay. If he tells me he can't get a hold of you because you're playing games, I will issue a warrant. So just be careful, stay in contact. And that's it. Do you have any questions? Okay. Thanks.
Thank you, Judge. I do have one other case, Mr. Stewart.
I know. I'm not ready to do that yet. That's going
Okay,
to
I'll
take,
come back. I've got a few other things going on.
please, that's going to take, where's Mr. Stewart?
It should be pretty, it's an address violation, but it happened during the storm and he had no power or AC, so he went to his sister's house. And that's the address on the protective order. I'm not sure why it was a restricted address, other than that's where.
I don't know. Can you go do your other stuff?
Yeah.
Let me blow through this and
Thank you, Judge.
yeah, for sure. Andrew. Hey,
Adrian Buskanga, USCANGA.
okay.
Page 30.
Come up, Mr. Skanga.
We're probably going to resolve both cases today, Judge. I just need time to talk to him.
So let me get this right. You're on a diversion program and you've now picked up a new case. Am I right?
Yes, Your Honor.
What is the one thing we asked you not to do, Mr. Buskanga?
Got in trouble.
Right. And did you do that? we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You're now charged with another misdemeanor, evading arrest. You're facing up to a year in jail and or a $4,000 fine. Please.
On June 30th, 2024, officers were dispatched to a club where a man and woman were denied entry because they were too intoxicated.
A club. A club.
I was going with the group.
Stop.
Don't say anything, just wait until it's done.
I don't care if you're with the Pope, Mr. Buskanga.
And the man and woman got into an argument. The female fell on the ground multiple times and eventually bit and kicked a police officer. While all this was happening, the defendant kept interacting with her, causing her to be more agitated. Officers asked the defendant multiple times to get back, but he kept encroaching. Due to him being uncooperative, uniformed officers attempted to detain him, and he fled on foot approximately 100 feet before being detained.
He actually came back of his own accord, Judge. They yelled at him and he turned around and came back. But he did run off at first. And I'm representing the co-defendant, so I kind of have an idea what happened there.
Mr. Buskanga, I'm going to find that there's probable cause to go forward with your case on the evading arrest case. Guess what's happening to the first case? Stephen. Mr. Buskanga. He goes with you.
Back to work.
So I have to.
If you want to talk, we can talk. Okay, whatever you want. And I don't know if that's something that they're going to want to do. What, if they're going to want to keep him on?
No, they've already told him to get off.
Is he off? Okay, so,
He's just gonna plead guilty.
okay, I'm going to do it today?
Yeah.
Okay, just let me know.
Judge, the co-defendant is not with us because she picked up assault with these officers.
Is that the one that did the biting?
Yeah,
She's in felony court, Judge.
yeah.
But there's no evading. That's just an assault of a PO?
Yeah, that's just assault with these officers. So there's no transfer orders needed
Got it.
for us.
Okay, Brock, you ready?
Yes, Your Honor. Good morning. How are you?
Good morning.
Prisoner Ms. Jasmine Robertson is in the arraignment setting.
Fun for you.
21, Robertson, come on up.
Yes, sir, no, sir.
Good morning, Ms. Robertson. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On July 7th, 2024, at 3:30 a.m., officers were dispatched to a traffic hazard call. Upon arrival, we spoke with a witness who said that he saw the defendant in the front driver's seat of the car. He was traveling northbound on West Loop North Feeders, and her vehicle was parked in the middle of a moving lane of traffic. He got out of his car to check on the driver, and she was in the driver's seat, engine running. The front passenger side of the defendant's vehicle was inoperable, and officers observed an odor of alcohol on the breath and the defendant to have poor balance. Officers observed dash cam footage from the witness, which showed the defendant's vehicle and the defendant exiting the vehicle. The defendant's demeanor was angry and she had bloodshot eyes. Officers spoke with the defendant, who said that she was traveling home from a restaurant. Standard field sobriety test was conducted, 6 of 6 on the HGN, 6 of 8 on the walk and turn, and 4 of 4 on the one-leg stand. The IC was read, breath was declined, and blood was drawn pursuant to a warrant.
Was there an accident? I don't,
Stopped in a moving lane.
just stopped in a moving lane of traffic. Was she, but was she was asleep or awake?
It's not clear.
Yeah, it's the way they wrote that report was like being in a drive-through.
Same questions I had. And when officer arrived, she was not inside the vehicle, Your Honor. They're basing the will witness on this witness that called and asked for the officer to be dispatched.
With footage.
If you find something differently, you can always reapproach on PC.
I will, Your Honor.
Happy to do it.
You know, I would be happy to also, Your Honor.
So, Ms. Robertson, I'm going to find probable cause to go forward with your case now. Do you have a Texas driver license?
Yes, sir.
Do you have valid liability insurance in your name?
Yes, sir. It's in my mom's name, my insurance.
If not in your mom's name, you have to be named on the policy.
Yes, sir.
If you are not named on the policy where your name actually is listed and which car you're protected with, you're not allowed to drive, man.
Yes, sir.
Until I know that, I'm gonna bar you from driving. If you can show me today that you're listed as on the policy, then I'll allow you to drive. So it's very easy. All you have to do is go to literal an app or the
Yes, sir.
website and find out. So I am ordering you not to consume alcohol or illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any kind of dope, I will revoke your bond, put you in jail. You will not get any more PR bonds.
And Your Honor, if I may, she lives in Dallas. She was just down here working for the weekend. Is it possible we can just do tests only when she
So-
appears for court
No, not for now.
rather than random?
What we'll do is you will be called for random testing. You must go to a Quest diagnostic, get the test done there, get it to Brock, and he will get it to us. If you just blow us off, I will issue a warrant for your arrest. But going to a Quest, so I'm making it to where you don't have to come back to Houston to test. I will waive your appearance, so you don't have to waste your time coming to court, but you have to stay in touch with Brock.
Yes, sir.
And when you do get called for a test, go to a Quest diagnostic, test there, get the result to them, and then that'll satisfy us here. Any questions? Okay. For now, I'm gonna have you sign an affidavit that you're not to drive. After that, we'll get you to Victoria sign a reset. After that, you'll get a trace of your bond condition. After that, you're free to go. If you show me that she's got insurance, then I'll rip up the affidavit.
I have it to you, if not today, by Monday at the latest.
Okay.
Thank you, Your Honor. Have a great day. Might be excused.
But wait, she needs to come up here to swear to this real quick.
Judge, the next Spanish arraignment, page 19, Perez. Come on up.
Where did you get this back from me? Okay,
Page 19, Perez.
got it.
Yes, sir.
Stephen. Ronaldo Perez,
Yes.
what have you done now?
¿Qué he hecho ahora?
You've picked up another case. You were on bond for theft. You've now picked up a Class A driving with a false ID or a false license. You're facing up to a year in jail and or a $4,000 fine. And this is your second fraudulent identity case. So we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. You have the right to have an attorney present during questions and interviews. If you cannot afford a lawyer will be appointed to represent you, sir.
On July 5th, 2024, officers conducted surveillance on the defendant who had a felony warrant for fraud use of identifying information. Officers contacted him to inform him that another officer would meet with him regarding an unrelated incident. Plainclothes officers observed the defendant waiting in the parking lot. Uniformed officers met him and asked him for his identifying information, and he presented a Dominican passport with his name, date of birth, and photo. Officers detained him and searched him, and an inventory search turned up a wallet, keys, 2 phones, and a Texas driver's license with the name Aurelio Valdez, date of birth 7/20/1993, and a credit card that did not belong to him. The credit card had a common name and the bank was closed down. The driver's license had no watermarks, blurred font / photo, and no holographic images, no mini photo, no ghost image of the Lone Star state symbol, and the defendant had his own photo on the card. Defendant said that he uses the ID for work.
Mr. Perez, I'm going to find that there's probable cause to go forward with your case. And now I'm going to revoke your bond on your first case, and you will be staying with us. Goes with you. Did they give him a PR bond on this case? You know?
Yes, Judge.
Yeah. Ixnay on the PR bond A.
Judge, also Marcos is on his first case.
Yeah, I'm gonna reach out to Marcos now.
You ready for the next Spanish one?
Yeah, please.
Page 21, Rivera, come on up.
Also Spanish?
Yes. Rivera.
Rivera?
On the old theft, 5,003, and then on the new one, you can leave it at the 5,000, but no PR bond. You're gonna have to pay a surety, you know. Hey Vic, well, who?
Page 21, Rivera.
Are you Mr. Rivera Araujo?
Yes, sir.
Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On July 6, 2024, at 10:30 p.m., officers were investigating a parking lot takeover in a strip mall parking lot. Officers observed 200 vehicles inside the parking lot,
200?
200, participating in the parking lot takeover. Officers observed a white Ford Mustang perform 2 to 3 donuts inside the parking lot and burn out within 5 feet of a large crowd. Officers conducted a traffic stop and identified the defendant by his Texas driver's license. The defendant stated he performed the actions because he was at the car meet, and he also had a front passenger.
Okay. Mr. Rivera, I'm going to find that there's probable cause to go forward with your case. Tell me, are you a United States citizen?
I'm a resident. I have the green card.
You have a Texas driver license?
Yes, sir.
Do you have liability insurance in your name?
Yes, sir.
Okay, I'm now ordering you as a condition of your bond not to participate in any more street takeovers, donuts, reckless driving, burnouts, racing, whatever it may be. If I find that you participate in this kind of action again, I will revoke your bond, put you in jail, and take your driving privileges away from you permanently. Do you understand?
Yes, sir.
No more. Can you file those conditions, please? Okay. We are going to reset your case to give you time to hire a lawyer, Mr. Rivera. I will do everything in my power to protect every single person of Harris County, Mr. Rivera. If that means putting you in jail because you continue to do foolish things on the road, so be it. I have no problem setting your bond extremely high. Do you understand, sir? I'm going to have you go to Victoria, sign a reset. After that, you will take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free on your way.
Page 31, Velasco Morales.
Every day in the USA, people find themselves in court.
Daniel Henman,
Dakota Henman?
Dakota, excuse me, Dakota.
Yes,
All
sir.
right. This is State of Kansas versus Dakota Ray Henman. It's case number 2025 CR 210. Jared Regier appearing for the state, Mr. Henman from the jail Zoom location. Mr. Henman, do you have a copy of your charging document before you?
Yes, sir. Yes, sir.
Count 1, alleges theft, a level 9 non-person felony. Count 2, expired tag or registration, an unclassified non-person misdemeanor. Count 3, no proof of insurance, a class B non-person misdemeanor. A felony is involved. You will not be asked to plead at this time. Rather, a preliminary hearing scheduling will be made before your assigned judge, which is the Honorable Jan Satterfield.
What would you say count 3 was? I only got 1 and 2. Sorry.
It's on a separate page.
I can get them to you. Okay.
Count 3 is no proof of insurance.
Okay. I got a question. As far as this like theft on this car, we got video of dude like literally signing a bill of sale. I mean, everything was done right there at his house 3 weeks ago, and I just got pulled over in the car last Monday, and they
We're not going to get into the facts of
Okay.
supporting guilt or innocence at this time. I just have the charge before me. I'm just trying to inform you what those charges are.
Yes, sir.
Can you afford to hire your own lawyer to represent you on this?
Not right now, no.
Yeah, I'm going to enter a plea, not a plea at this time. I'm going to go ahead and make a preliminary hearing scheduling before Judge Satterfield, which will be July the 14th, 2025, 2:30 p.m. You must fully and personally appear and participate in Judge Satterfield's docket at that time, July 14th, 2:30 p.m. I'm going to require you to appear at the Butler County Judicial Center in El Dorado, Kansas for that appearance if you make bond, Mr. Henman.
Okay. What is my bond?
Well, we're going to talk about that here in a little bit.
Okay.
Regarding an attorney, Mr. Henman, what's your
What?
financial situation currently?
I am employed. I don't know. I don't got that much like saved up to put it down deposit. I mean, depending on what his retaining fee is, I may be able to get an attorney. I haven't even.
It's going to be pretty high.
I mean, the charges changed. I thought there was different charges than this. This is the first time I've seen these charges. Everybody keeps telling me there's something else. So
Okay. I'm going to go ahead and find him partially indigent and we'll appoint a lawyer to represent him. James Watts will be appointed. Recommendation regarding bond here, Mr. Regier.
Your Honor, the state's understanding is this is a case where pursuant to page 2 of the affidavit, the vehicle is alleged to have been stolen from a location in Sedgwick County. This is defendant who the state understands would be considered a B on the grid under Kansas law. The state's understanding is this is a defendant with few, if any, ties to Butler County, so the state does consider this defendant a flight risk, as well as the defendant's prior failure to appear at least 4 times. State further understands this is a defendant with a history of traffic and property-related convictions and adjudications, including at least 1 conviction for aggravated robbery and 1 adjudication for felony burglary. For those reasons, the state is recommending all center conditions, no contact with any co-defendants, as well as bond in the amount of $7,500 cash or surety.
Do we have co-defendants on this docket, Mr. Regier?
I believe so, Your Honor.
One's my wife.
Mr. Regier, I need him to answer. I'm sorry.
I believe so, Your Honor.
Okay, and who would that be?
Your Honor, the information appears to refer to multiple individuals, last names Vo, Thomas, and Rakes.
Rakes is my wife. I don't know.
All right. Okay. Court will set bond in this case at $7,500 cash or professional surety required. There are a number of concerns which caused the court to enter a bond that high, including criminal history of this defendant, a record of failure to appear. Among them, the court does set bond at $7,500 cash or professional surety with a no contact restriction, with supercar guys, the alleged victim in this case, or their property, or any of the co-defendants in this case. You wanted to be heard on that, Mr. Henman?
Yeah, I just my wife is Rakes, Tori. So I just
Why does she not have the same name as you then?
it's in your guys' well, not in your court, but it's in the courts right now. We just did it 2-3 weeks ago. The marriage license and all that shit. Like we've been together since high school. I don't got no reason to lie to you, sir. I just didn't know how that would work. Like, cause she's gonna bond out. I'm sure she's gonna try and bond me out. But he said I can't have no contact with her. I live with her. Like, we live at her parents.
Do you have children together?
No, sir.
The court's currently going to follow the state's recommendation regarding no contact with any of the co-defendants at this time. You can ask your assigned judge, Judge Satterfield, for relief on that at some point in the future. I think it's better that you not have any contact with Tory Rake, Sierra Thomas, or Fung Van Vo, who the state identified as co-defendants in your case. And that will be a condition of your bond, Mr. Henman.
Okay.
All right, so we've got our court date set. Judge Satterfield, July 14 at 2:30. Defendant to appear at the Judicial Center, $7,500 bond with no contact restrictions. And James Watts appointed as counsel. Anything else we need to cover here, Mr. Regier?
Not to my knowledge, Judge.
Very well. Then the Henman matter will be in recess.
Okay, so
You Fung Tanvo.
yes, Your Honor.
It's the state of Kansas versus Fung Tanvo. It's case number 2025 CR 211. Defendant appears from the Butler County Jail's Zoom location. Jared Regier appears for the state. Do you have a copy of your charging document before you? Let me inform you of your charges. Count 1 is possession of methamphetamine with the intent to distribute, a level 2 drug felony. Count 2, possession of methamphetamine, a level 5 drug felony. Count 3, possession of paraphernalia for use, class B misdemeanor. Felonies are involved. You will not be asked to plead at this time. Rather, you will be set for appearance before this court on June 2nd at 2:30 p.m. If you make the bond that we're going to talk about here in a minute, you need to appear at the Butler County Judicial Center in El Dorado for your next court appearance. And that would be June 2nd at 2:30. Can you afford to hire a lawyer?
No, Your Honor.
Take you at your word here. This is a very serious case. Court will appoint Chris Pate to represent you. Recommendation regarding a bond here, Mr. Regier.
Your Honor, as to reiterate what the court has already referred to, the state does consider this a very serious case. Besides no contact with any alleged co-defendants and no contact with drugs or alcohol, the state is recommending a high bond in the amount of at least $10,000 cash or surety. I believe the court has already addressed the level of the charges, especially with regard to count 1. Additionally, the state does consider this defendant a flight risk. The state understands this is a defendant with at least 9 prior failures to appear, most recently in September of 2023. Additionally, the defendant has a somewhat interesting criminal history. The court will pardon the conjecture, at least 1 prior conviction for misdemeanor possession of controlled substances, misdemeanor interference with law enforcement, felony attempted trafficking of contraband into a correctional facility, 3 property-related felonies, and at least 10 related traffic convictions.
Very well. Court will set bond in this case at $10,000 cash or professional surety required. As a condition of that bond, the defendant must appear on time for all scheduled court dates and have no contact with Dakota Henman, Tory Rakes, or Sierra Thomas. So you're obviously not to ingest any alcohol or illegal drugs as a condition of your bond. Mr. Vo.
Yes, I understand, Your Honor.
All right, so we've established bond in the amount of $10,000. Chris Pate has been appointed. Next court date in this court, June 2nd, 2:30 p.m. Anything else we need to address here, Mr. Regier?
No, Your Honor.
Then this matter is currently in recess. We'll move on to other matters. And I think that concludes. I'll address that next. It's the state of Kansas versus Ethan Robert Buxton, case number 2024 CR 443. If Ethan Buxton can come on fully at this time. All right, you can now see him, Mr. Buxton. Darren Patterson appears as defense counsel, Mr. Buxton on his own Zoom, and Jared is here on behalf of the state. You might go ahead and just mute yourself for a moment there, Mr. Buxton.
You said mute myself?
Mute yourself. I see a bond in the file that was established by second chance bail bonds in the amount of $2,000. Has secured the defendant's appearance here today. I'll maintain him under it pending further proceedings in his case as may be necessary. Moving on then to the charges that have been filed in this case. Count 1 alleges criminal damage to property, a Class B misdemeanor. Count 2, possession of marijuana, a Class B misdemeanor. Count 3, possession of paraphernalia for use, a Class B misdemeanor. What plea is being entered today, Mr. Patterson?
Your Honor, at this time, we'd enter a plea of not guilty. Would ask the court to accept the bond in the case, would ask the court to set it for a misdemeanor control docket at the court's convenience. Thank you.
Okay. Court has approved the bond in this case. Again, $2,000 second chance bail bonds. I will require the defendant as a condition of that bond to appear for all scheduled court dates when this case is pending. It will be set before Judge Webster on July the 21st. This is a retained case, Mr. Patterson?
Yes, Your Honor.
What time are you proposing that this matter be set?
On July 21st at 9 a.m., Your Honor.
Very well. The court will set the appearance for Mr. Buxton at 9 o'clock a.m. on July 21st, 2025 before Judge Phyllis Webster. Mr. Patterson's already formally entered his appearance in writing and orally here today. So the court need not address court-appointed counsel. Court's approved bond, set a court date, and we have counsel secured. Anything else we need to address from the state's perspective? Mr. Regier.
Yes, Your Honor. It would appear that at the first appearance here in this case back in September of 2024, this court specifically entered a number of special conditions prior to the failure to appear insofar as setting bond was concerned. If the court is continuing all of those, to say there's nothing further.
Right. Are you familiar with these, Mr. Patterson?
Judge, I am not.
The original bond in this case, which he apparently defaulted on at one point, was no drugs or alcohol or special conditions, may not return to the residence of Janice Steckdale. Mr. Buxton, if you'd unmute yourself for a minute.
All right.
Any problem with either one of those?
I mean, Janice Stockdale's my grandma. I don't know if.
Well, I may suppose there was a good reason for this.
Yeah.
Is there? Apparently it was a criminal damage to property allegation of something that belonged to Ms. Stockdale.
That is the state's understanding of the case, Your Honor.
Does the state still wish to maintain that restriction?
The state does so wish, Your Honor.
Patterson, do you want to be heard on that?
Judge, I hate to request this, but to be heard, I would need to have a breakout room with Mr. Buxton.
Well, counsel, without input directly from the alleged victim in this case, the court's not likely to relax the restriction.
Yes, Your Honor.
I understand the position you're in, but I'm going to go ahead and endorse those restrictions on this bond. No contact with Janice Stockdale. No alcohol or drugs. You can apply for relief on the bond by a request to Judge Webster at any time. All right. Mr. Patterson, anything further at this time?
Nothing further, Judge.
Mr. Regier?
Not from the state, Your Honor.
I will excuse Mr. Patterson and his client, Mr. Buxton, from the meeting at this time.
Thank you, Judge.
Thank you.
Every day in the USA, people find themselves in court.
Morning, Mr. Lohr.
Good morning, Anna. For the record, Soto Lohr with the city.
All right, Mr. Parent, go ahead and call your first case.
First, we have Ronald Sofur for review.
Good morning, Mr. Sofur.
Good morning.
This matter comes on today for active probation review under cause number 3A07156110. Ms. Parent, there was a report completed by Ms. Sprague. Did you go over the allegations contained in that report with your client?
Yes, Your Honor, I did.
All right. Just to make the record, it is that he failed to report to probation, failed to comply with alcohol drug evaluation and treatment, and has also committed new criminal law violations. What is your client's position on those three allegations?
He does admit to failing to report to probation with the explanation that he lives in the Everett area and it's very difficult to come down to Bothell to meet with probation. He denies not doing the SUD evaluation and treatment. He tells me that he completed inpatient treatment in Chehalis at ABHS back around April 18, and that he's been in outpatient treatment at Evergreen Recovery in Everett since graduating inpatient. He tells me that he believes that he signed an ROI for the Bothell court, but it sounds like perhaps Bothell's not receiving information from the treatment agency. And he denies at this time the pending law violations.
Mr. Lohr?
Your Honor, I don't doubt he did treatment, but we just don't have any proof of it. It's been almost a year. Well, 11 months. He was required to do the SUD evaluation, but he hasn't produced that to our court.
So I will let everyone know that I'm completely unimpressed with the failure to report to probation since it's a phone call, not having to appear in person. So the fact that he lives in Everett has absolutely no impact on his appearing for his probation. I'm very clear about that in every time that I speak with individuals, and I don't know what the limitation was in being able to communicate. As far as having done treatment, I have absolutely no proof. I have nothing indicating that there has been anything done. I'm not even contacting probation to let them know you're in treatment. So how would I know that you are in compliance?
I told them to let you guys know.
So Mr. Sofur, you're saying you told the treatment providers to let
Yeah,
you know?
I told them and ABHS and Chehalis to let the Bothell courts know that I was there. I let them know that I signed the RI. I don't know why it didn't get, I don't know. I have no control over that. But I was at ABHS in Chehalis recently, like I just completed.
So you completed in April?
Yes,
What day?
18th.
So I had a hearing scheduled for April 22nd here. I guess as you didn't get notice of it if you got done on the 18th.
No, I didn't.
Mr. Parent, what's your recommendation?
Your Honor, in light of what my client is saying about him doing treatment, we would ask the court to revoke 3 days with credit for 3 days served and refer back to active probation and have him meet with probation immediately upon his release.
Can I say something too? Like, before I wasn't doing what I was supposed to, I know that, but like I just started getting my life together. Like I'm in a clean and sober living house. I'm, rebuilding a relationship with my family. Like, I'm just asking for one last chance. Like I'm actually just completed treatment. Like I promise I won't let you guys down anymore. Like before, I know I wasn't doing what I was supposed to. I'd get out and I'd go use again, not go to treatment, all that stuff. But I mean, I don't know how else to say it, but I'm just asking for this one last chance. I promise I won't let you guys down again.
So how did you end up in ABHS?
I had a DOC violation. I went to Monroe to do the IMU in Monroe, and they sent me to Chehalis, the ABHS in Chehalis.
Because I have to say the fact that 3 days ago you got picked up on new charges at Everett Municipal Court for having controlled substances and a soda order violation makes me very hesitant.
I understand that, but I don't know what else to say. Like, I'm at a clean and sober house, but I don't know if you guys know the name Robert Smiley, but he's the one that runs the house. He's helped me out a lot, and like he'll provide me with transportation. He's helped me get everything settled, and I'm just trying to actually start my life and start, being a normal person. And I just feel like this would set me back a lot if I have to, I'll lose my housing. And I don't know. I just feel like if I have to do a lot of time in jail, I'm gonna have to start all over again when I get out.
Aren't the new charges going to cost you your housing?
Well, I mean, those are still pending charges.
I see that Everett Municipal Court set bail,
Yeah.
but only at $100. So you're sentenced in June of 24. You had a hearing in January of 25. You're supposed to meet with probation. You didn't do so. Oh, you did make it to that. I'm sorry. You did make it to your. Oh, wait a minute. Nope, you didn't make it to probation then. Didn't contact them. Got a new charge in Everett Municipal Court. Got a new charge in Edmonds Municipal Court. Evidently got the DOC violation, although that's not available to me.
Yeah. That was all before I did my inpatient. I'm off of DOC now. I did the inpatient, like, I know in the past, my past record doesn't look good, but I'm just asking for one chance, like, as a normal person now. Like, I'm not, dope sick. I'm not doing fentanyl anymore. Like, just as a normal person, like, give me a chance to show you guys that I could do it. Before I was addicted to drugs. I was doing a bunch of fentanyl and meth all the time. And I wasn't worried about stuff like that. I'll admit that I wasn't right, but.
So what is the drug that you were alleged to have had on you for the Everett Municipal?
Your Honor, I would ask my client not to answer that.
I'm not asking what he had on him. I'm asking what he was alleged to have had on him.
A controlled substance.
Okay.
What it says on the record.
All right. As I will say, that new charge, everything else sounds wonderful, but that new charge makes it all kind of sound hollow.
Yeah, but
Mr. Lore, what's the city's recommendation?
Yeah, and I'm also looking at the same criminal history for Mr. Sofur, and the city's inclined to just recommend 45 days jail at this time. Maybe stay that for 2 weeks for Mr. Sofur to provide the treatment verification from Chehalis. If that doesn't happen, then there'll be a commitment date at that time.
Mr. Parent?
Sorry, I just want to make sure I understood. To impose 45 and stay it?
For 2 weeks.
For 2 weeks, okay. Mr. Sofur, do you think that you can get the treatment information to the court within 2 weeks?
Yes.
Okay. Your Honor, that does sound like a reasonable alternative to my original recommendation.
All right, so what I'm going to do then, because just providing us with proof isn't going to be sufficient to address the situation. I'm going to set it for a review hearing on the 20th at 2:30 in the afternoon in person at the Bothell Municipal Court. So on May 20th, you're going to come to the court because you will have provided that information, and then we'll determine what's going to happen with regard to your sentence. All right?
Okay.
And just to make sure that we're all on the same page, Mr. Sofur, I'm going to add 60 days to the sentence if you fail to appear. All right? So it'll become a 105-day sentence.
I understand.
So if you are for some reason in custody or unable to attend, you're going to be on the phone to Mr. Parent right away, understanding that if it's not something that can be verified, you're looking at a lot of time, right?
Okay.
So at this point, I've set that to May 20th at 2:30 in person at the Bothell Municipal Court. I have found a willful violation and imposed 45 days with credit for 3 days served. And in the form itself, it indicates that you will be released today. And you'll appear on the 20th. If you don't appear on the 20th, then I'm not giving you a date to report to jail. Well, I guess I could do that. What does the city believe? Do you want me to give him a report date if he doesn't appear?
Yes, please. Yes.
All right, so we'll say May 21st. All right, so if you don't show up on the 20th, you will be required to appear at the Snohomish County Jail no later than May 21st at 4 p.m. Okay?
Okay.
So that's the order of the court. That'll conclude this matter, Mr. Sofur. You can stand up and let them know that you're done.
Thank you.
Last, we have one Perea for arraignment.
Good morning, Mr. Perea.
Morning.
You are here for arraignment. Could you please state your full legal name?
Juan Diego Pareja.
And this is under cause number 5A0378054. Mr. Parent.
Your Honor, Mr. Perea and I had a chance to speak earlier today. He understands the nature of the charges against him as well as the maximum penalties. We waive formal reading of the complaint and enter a plea of not guilty. We also reviewed the advice of rights form. He permitted me to sign on his behalf. He had no questions and understood them all.
All right, so Mr. Perea, I just need to confirm with you that you did understand the rights that you went over with Mr. Parent on that form.
Yes, that's correct.
All right, I did review your request for court-appointed counsel. I do find you qualify at no expense. Mr. Parent has indicated pleas of not guilty on your behalf, which will enter at this time. Court did review the police reports, did make findings of probable cause. What is the city's request with regard to release and conditions?
Yeah, the city is requesting bail amount of $10,000 at this time for this and $10,000 for the review case. The defendant, frankly, Your Honor, this was almost an attempted murder. He tried to stab the victim, Marco Antonio Lopez Sanchez, with a knife, and he would have done so, they believe, if he wasn't stopped by his family members. So the city is concerned for the public and for the victim in this case. In addition, Your Honor, the city is requesting a no contact order, a non-DV no contact order, protecting Mr. Lopez Sanchez.
All right, Mr. Parent.
And Your Honor, we have no objection to standard conditions. He does want the court to know that he's a lifelong Washington resident. He does have family here. I see only one other conviction on his criminal history. He would ask the court to impose no more than $5,000 cash or bond if the court believes that bail is appropriate. He's not a flight risk and will come to all of his court hearings. He also executed a declaration of non-surrender. At this time, he doesn't have any dangerous weapons, firearms, or concealed weapons permit.
All right. And I was just looking at some of the information available to the court. I am concerned with a number of different things, not the least of which being the number of protective orders sought with regard to your client, with regard to family members and or members of the community. I do see past allegations of violence, which did not result in conviction. I will acknowledge that, but I do also have some concern when I look at that in conjunction with the alleged facts in this case. I do see that there is a concern for the safety of the community. So I am going to grant the city's request, and I will set bail in the amount of $10,000 on the arraignment matter, which will be should you post bail, Mr. Perea, I am going to indicate the following conditions. Need to notify the court in person or in writing of any change of address, have no new criminal law violations for which there's probable cause, make an appointment with your attorney, make it to that appointment because they can't help you if you're not talking to them. Make it to your court dates, which I'm going to give you in just a moment. Only use your true legal name and date of birth if contacted by law enforcement. You may not own, possess, or have under your control any firearms. You may not possess or have under your control any dangerous weapons. You must immediately surrender any firearms or dangerous weapons to the Bothell Police Department and any concealed pistol license. I am going to issue a non-domestic violence, no contact order protecting, I'm sorry, protecting Marco Antonio Lopez Sanchez. We'll go over what that means in greater detail in just a moment. I'm going to set these matters for pretrial on I can set them to the morning of May 20th or actually I'm going to go to May 22nd, I think. At 9:30, trial will be tentatively scheduled in the June trial term. Your next court date will be May 22nd. That will be at 9:30 in the morning by Zoom. So if you do post bail, you still need to appear on May 22nd at 9:30. With regard to the no contact order. No contact order is my order. It is not Mr. Lopez Sanchez's order, which means he has absolutely no ability to give you permission to violate my order. The only person who can do that is me or someone sitting here in my place. No contact means exactly what it says. No contact, not in person, not by Snapchat, Instagram, Facebook, or any other form of social media. You cannot ask someone else to contact on your behalf. You may not cause, attempt, or threaten to cause bodily injury to assault, sexually assault, harass, stalk, or keep under surveillance the protected party. You may not knowingly enter, remain, or come within 1,000 feet of the protected person's residence, school, workplace. If you find yourself in the same location as the protected party, you have the responsibility to immediately leave the location. Failure to do so would constitute a violation of the order. Because I have issued this order, you may not own, possess, or have under your control any firearm under state law, firearm, or ammunition under federal law. You may not access, have in your custody, control, obtain, purchase, receive, attempt to purchase or receive, or possess a firearm, other dangerous weapon, or concealed pistol license. You must immediately surrender all firearms, other dangerous weapons within your possession or control, and any concealed pistol license you may have. And a separate order with regard to that, and we'll go over that as well. This order will remain in effect for the pendency of this case up to a period of 2 years. All right. You need to understand that possession of a firearm or dangerous weapon may be in violation of this order, would result in a new criminal charge being filed against you. All right. So today is May 9th. I am signing this at 10:29 a.m. Now, there is also the order to surrender. I understand you've indicated a declaration of non-surrender, but we're going to talk about the order of surrender first and then talk about that. All right. Is the city requesting a review hearing be set in this matter?
Yes, but yes, Your Honor.
All right. And that would be for Monday at 9:30?
Yes, please.
All right. So Monday at 9:30, we will have a hearing if needed with regard to compliance with the didn't it? Okay. It's not allowing me to set it to Monday at 9:30.
Yeah, that's assuming that he bails out over the weekend.
Right. Madam Clerk, it is telling me that mapping is not available for that date. I don't know. You can let me save and maybe you can do it. I will go ahead and go over this. So Monday at 9:30, the city is going to do a records check to see if there are any firearms associated with you, and then if there are, that we would have a hearing to determine whether or not there needs to be additional action taken. But you must surrender any firearms that you have in your possession or under your control to the Bothell Police Department. Oh, no, never mind. Sorry. So at this point, I'm going to indicate you must appear at the hearing. If that changes before Monday, we will let you know. All right.
Yes, Your Honor.
I will notify you that you, I want to notify you this voluntary surrendering weapons may not be used against a restrained person in a criminal prosecution under chapter 7.105, 9.41, or 9A.56310 RCW, or in any criminal prosecution pursuant to which this order of surrender and prohibiting weapons was issued, except a prosecution for perjury, giving false statement, or otherwise failing to comply with the order. Okay?
Yes, Your Honor.
All right. So with that, I have signed that order, and I guess I should actually give the warning too. If you fail to comply with this order, you may be found in contempt of court or be charged with a misdemeanor and punished accordingly. You may also be charged with a crime up to and including a felony if you are found to own, possess, or control a firearm or other dangerous weapon, or if you are found. Okay, that just ends there, so that's not a sentence. You have the right to remain silent and not make statements that may incriminate you. Anything you say can be used against you in a court of law. You have the right to consult with a lawyer before responding to this order. So, and then, but again, that goes then to but surrendering the weapons is not something that could be used against you. So, all right. I've signed that order. Now we're going to talk about the declaration of non-surrender, which I do see that you signed. And did you have a chance to go over that with Mr. Parent before giving him permission to put the electronic X on the signature line for you?
Yes, Your Honor.
All right. So I believe that concludes everything that we need to go over on this case. I may see you on Monday, but most likely not. So if not, I will see you on Thursday, the 22nd. All right. I believe that concludes this matter. You can go ahead and stand up, Mr. Perea, and let them know you're done. And that will conclude the 9:30 calendar.
Every day in the USA, people find themselves in court.
Court is calling 2024 CR 2071 and 2024 CR 007676 State versus Hank Maldonado. Can I have parties announced?
Andrew Harrison, State.
David McLean for the defense.
And are you Mr. Maldonado?
Yes, yes, Judge.
In each of these cause number, you entered a plea of no contest. According to your plea bargain agreement and each cause number, punishment is to be assessed at a cap of 12 months in the state jail facility. The state is opposed to your application. The cases will run concurrently. The state is taking in consideration 2024 CR 1039. Have both parties had a chance to review the PSI report, state?
Yes.
Defense?
Yes, Your Honor.
Any objections to the PSI report, state? Defense?
No, Your Honor.
All right, state you're opposed. Why?
Reading the PSI, it seems that Mr. Maldonado is still in denial about certain things. The first is his history of drug use and whether that constitutes a problem. While I am not qualified to say whether someone is addicted to substances or not, it does seem to me that 3 arrests over a period of 10 years for illicit substances, 1 case leading to a person being sentenced to confinement, seems to be serious negative outcomes that the persistent engagement in those behaviors would seem to indicate an addiction. Mr. Maldonado does not seem to have a good track record of appearing when he is required to do so. His previous controlled substance case, he was ultimately revoked and sentenced to 2 years for the resisting and evading cases for which he is still pending. He failed to appear on December 1st of 2023. So going back to 2011 or going back to 2023, Mr. Maldonado seems to have an unfortunate tendency to not take his commitments to the court seriously. And based off of that history, it doesn't seem like he's going to be any more committed to meeting these requirements today.
All right, defense?
Your Honor, on behalf of my client, I reviewed the PSI and the TAP. The TAP evaluation seems to indicate that he does not have any kind of serious drug or alcohol problems. They were recommending basically urinalysis, not even an outpatient program. I think he's addressed those issues. In all candor to the court, we had a PSI set for Mr. Maldonado and he did not appear and he did take off for quite some time. I've talked to Mr. Maldonado about it and he is basically just terrified of going to prison. That's really what it boiled down to. And with kind of this opposed type of offer, he was very nervous about coming in. And some people have a fight or flight, and he took off. And I tried, Your Honor, to get him back in, and it was just something that he was just too afraid to face. And that's just being honest with you. I think he could be successful on probation. I do. He's got a business. He works with his wife. I think it's something that he could be productive. He hasn't gotten in trouble while he's been out, which is not an excuse, but it is at least something where he's not just going out and reoffending again. We would ask the court to at least consider the application for deferred and place him on probation.
All right, Mr. Maldonado, you were scheduled to appear for court. You did not appear. That's a sign that you won't be a good candidate for probation. I'm looking at your criminal history and you have a burglary of a vehicle from 2011. You were sentenced to 80 days in jail. Then you had a possession of marijuana, which I understand people see that differently now. That was dismissed because you were convicted of something else, which tells the court that it was taken in consideration. Then in 2011, you had a possession penalty group 3, 28 to 200 grams. You were placed on deferred adjudication for 4 years out of the 186th District Court. Probation was revoked and you were sentenced. They amended it and just sentenced you to 2 years in the prison. And then in 2023, you had another case, book dismissed. And then you had these 2 cases that you were set to appear before the court and you failed to appear. How old are you?
33.
So you're 33. You're not a teenager. So why you would steal someone else's vehicle or use it without permission is beyond the court's understanding at a person your age. In each cause number, the court is going to find you guilty, sentence you to 12 months in the state jail facility. The cause numbers were run concurrently, taking consideration 2024 CR 1039.
I apologize for interrupting. Is
Yes.
there already a dismissal form on file for that cause?
I'll have to have the clerks look and see.
What was the case number again, Judge? I'm sorry.
It's 2024 CR 1039. In each cause number, there's to be restitution and no contact with Richard Anthony Johnston and also Felix Francisco Cintero Rivas. And I recommend the therapeutic community. He says he doesn't have a drug or alcohol problem, but there has to be something wrong with you, or either you're just someone who likes to steal and take what doesn't belong to you. Did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal in each of these cause numbers?
Yes, I did, Judge.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, I did.
All right, and it probably would have been in your best interest. Well, not probably. I know it would have been in your best interest to have appeared on your sentencing date. Who knows what would have happened if you would have. All right, good luck to you.
Thank you, Judge.
You're welcome.
Thank
And your other client,
Good luck. Conferring with Ashley on that.
Yes, sir. Yes, Your Honor, we are conferring, there is a new offense that has occurred. I am trying to reach out to the complainant on that offense. Just waiting for a call back. We can have just a little bit.
okay, sure. All right. Yes.
Justice.
Thank you. And I'm just going to put a couple of things in the Odyssey, then I'll give you these files.
Judge, may I have your excuse?
Yes.
Thank
You're welcome.
It's interesting how people mess their situation up right before sentencing.
Oh, yeah. It's just like, all you have to do is show up. I would always tell my clients, and I know he does too, hey, you know, we have a shot. But we're not going to have a shot maybe if you don't show up.
I think it was with you, Judge. I had a guy. He was looking good for deferred, even though he got drunk and shot up a bar. It was a closed bar, whatever.
Mhm.
But the day before, I think it was you, asked him, what's the last time you had something to drink? Because and he's like, yes. And he had all kinds of sympathetic stuff. Like
Yeah.
I actually thought he was going to get deferred, but I mean, obviously that was the wrong answer. That was,
Yeah.
you can't be, after all that, you're drinking while you're on probation or while you're on bond. It's
Yeah.
right before the court. It was,
You would think
It
you'd
was
be
just-
like, I'm not going to drink or do anything. I'm going to get my life together because I want to present the best me for the court, you know?
well, I told him, I said, well, you just drank yourself into prison. I said, I think that had you not had that drink, you might well have gotten
Yeah.
deferred. I said, it was because he had a very sympathetic story other than that, but obviously he didn't learn anything because he was still drinking. I had another guy went out, the night before his PSI, he ended up starting to have a couple drinks in Houston. Then it turned into some blow. Then it turned into a chase with the police.
offense.
Mhm.
And I think it's going to impact how Ms. Jones wants to proceed
Mhm.
with the recommendation to the court, which we know is not binding on the judge.
Yeah.
But we'd at least like to have some sort of recommendation where maybe we can have both cases taken care of.
All right. I'll have you all come back on the 22nd.
22nd.
Mhm.
That's perfect, Judge.
All right. See you all back on May 22nd.
Thank you, Your Honor.
You're welcome.
Thank you. Yeah.
Take that square microphone and put it on your shirt. Can you raise your right hand? Do you solemnly swear from testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. Make sure you keep your voice up so that the members of the jury can hear.
Yes, Your
Defense-
Honor.
Thank you. Defense, you may proceed.
Can you state your name for the record?
Mariano Rendon Jr.
And are you a resident here in San Antonio, Bear County, Texas?
Yes, sir. Bear County, Shabana.
Where were you born?
Midland, Texas.
And where did you grow up there in Midland?
Yes,
And where did you go to high school?
Midland High, in Midland, Texas.
After high school, what did you do next after you got out of high school?
I had a brief started with college, and then from there I just took off to the Army. I left the Army.
Okay. Where were you stationed in the military?
In Fort Benning, Georgia, with Fort Stewart Detachment and Fort Hood.
Okay. And while you were in the service, did you have an accident doing like rappelling?
Yes, I did.
Okay. And can you describe how you were injured?
My rope broke. I was 16 feet in the air, and I fell like a banana head first, injuring I had traumatic brain injury. L3, 4, and 5 are bulging, and my left leg is numb, my upper leg.
Okay. And do you get disability pay from the U.S. Army?
Yes, sir.
Now, when did your wife purchase Joe's Volcano or El Volcan?
About 8+ years ago.
And at that time, was it already operating as a club at the time that you guys had taken it over?
It was operating, but it was transitioning. We made the transition from what it was before to a different genre of music.
What was it before?
It was hip hop and that category.
Okay. And what kind of music did they play there at El Volcan?
Regional Mexican cumbias.
Okay. And part of the things that you do is like, you guys sometimes have live musical acts that play there?
Yes, we either have promoters or we did our own live acts.
Okay.
With Tejano music and regional music as well.
And do they also have like recorded music that plays some nights?
Yes, on Saturdays, that's always a DJ recorded music.
Okay. And what you're there all the time, kind of when they're during operation, is that fair to say?
Friday we check in, and Saturday I was there. During the week, the staff, my wife, my kids, they run it.
Okay. But you try to help out on the weekends when the club is kind of the most busy time?
Yes, I'm basically the host.
Okay. And what do you do as the host? What is your job there?
For me, it's eyes on deck. Just walking the perimeter of the dance floor, walking the club, just walking with or without a security guard or without, just reading the people, reading the body language, reading the hats. We don't allow hats to go backwards because that's starting fighting or something. So we read the crowd, or if there was new people or guests. I knew 90% of our customers one-on-one. I mean, just overall, I wanted to be the point to call in the radio and hurry, there's a problem, it's over here.
And then you would also spend a lot of time like greeting people that you knew that were there, like your past guests and people like that.
Yes, for the most part, every Saturday was the same crowd for the most part.
Okay. And you had seen Tina Jimenez and Pablo Rodriguez there quite often?
Tina started about 5.5 years ago. I think she had her husband passed away or something, and then she started going there. Pablo and his friends had been going there since we bought it. They had their own section where they put all their beer buckets and drinks. And the two stools where Tina and Pablo would sit, or Tina and other ladies would sit in that area.
And you had spoken to them at various times in the past, is that correct?
Pretty much every Saturday.
Okay. So whenever you see them, you greet them and things like that?
Yes.
And like, we see what's been marked as states to the degree and enters into evidence. And this is a photo of you and him, kind of just, you and Pablo just kind of posing and be in a friendly manner?
That's the norm. That's if you were to say that, show that picture to anybody, it's the norm. I'm one-on-one with everybody. I want to know everybody.
Okay. And that's part of, that's part of your, getting to know your customers and treating them right?
Yes, sir.
Okay. And is it important for you that El Volcan is a safe place for people to go?
I want our business to be the safest place where I could take my wife.
Right.
And if I could take my wife to our place, then I would feel safe for anybody else to take their family members to our place.
And one of the problems sometimes, like if you have a club that becomes unsafe, then it's kind of like a magnet for the bad people and like a anti-magnet for the good people, and that hurts your business. Is that correct?
Yes, that's correct.
Okay. Specifically, going back to August the night of August 19th and then the early morning hours of August 20th, were you there present in the club that day?
Yes.
And at some point, did you have like an encounter with Pablo Rodriguez before all this stuff happened, maybe around midnight?
Yes. I know my customers. I know their demeanor. I know one-on-one. This particular night, I didn't know it was his birthday. I didn't know anything other than I was wearing a baseball cap, and I literally didn't wear it the rest of the night because I had an issue with it. As I'm walking around on the interior of the dance floor, there's a railing all around the dance floor, and I walked inside and I'm greeting everybody. I'm looking at everybody. I'm making eye contact with everybody. As I'm passing them, I said hi to Tina as usual. Nothing out of the norm, because all of their party, they work from Casillas Muffler Shop, and they're always there, and they all knew me one-on-one. As I'm passing Tina, the gentleman that I forgot his name.
Pablo.
Pablo, I'm sorry, I went blank. Pablo, he grabbed my hat and shook me, went like that, like that, like that, like 3 times. He just jolted my head, and I stopped him, and I said, "You need to stop. We're not gonna do this tonight. We're not gonna do this." And then Tina got on his case. I said, "Tina, I don't know what's going on, but tell him not to do that, or I'll kick him out." And then that's when she said, "Oh, yeah, we're partying at this place. We're having drinks. He's just a little accelerated."
Objection, Your Honor, hearsay.
Yeah.
Sustained.
Just don't talk about what other people said, okay? Because there's some rules about the court, which means that we can't talk about what anybody said unless the judge says we can.
Yes,
So whenever I'm asking you questions, I'm just asking you questions about your observations of their demeanor or like their actions, like physical actions.
Yes,
Okay?
I'm sorry.
Okay. Now, when he grabbed your hat, did you feel like that was kind of out of character for him?
Yes, sir.
And did it surprise you that he did that?
Yes.
And did you begin to think that he might be intoxicated when that happened?
I think he was just feeling very, very good. I mean, because we're at a club, I think pretty much everybody's trying to get intoxicated or gonna get intoxicated. So he was feeling good.
Okay. But maybe a joke that you felt kind of crossed the line a little bit?
Yes.
Okay. Between that and 2 o'clock, did you have any other interactions with Tina or Pablo that is memorable in any way?
No, just the normal. If you're, let's say, like they were always there at one part of the club by the dance floor, I think I would say 8 to 10 times I'll circle the club all night long, keeping an eye on everybody. I'll circle them about that many times.
And then, but there was nothing that stood out like as odd other than that incident with the hat.
No.
Prior to this. Okay, so let's talk about 2 o'clock in the morning. So what is the significance of 2 o'clock in the morning in the business, in the bar business?
Well, in my timing is 1:45.
Okay, what is significant about 1:45?
1:45, everybody that has beer buckets, we take the buckets out away from them because the beers are in ice. So our philosophy is take them out of the ice, put them on the tables, they'll drink up because they don't want them to get hot. So it gives them a time span, hurry up, we got 15 minutes. And then I think we pick up the beer buckets, I believe it's 1:55. That's the time that all beer buckets should be picked up by then. Then at 1:45 and every 5 to 10 minute increments, they're saying last call, last call. Now, where it gets confusing is that last call is the bar is closing. However, we have late night hours through TABC and they can still drink till 2:15. We don't ever tell our customers that because then it'll be 2:15 plus. So they think they're getting away with 2 or 3 minutes, whatever, but we start picking up the empties or hot beers and throwing everything away at 1:58, 2 o'clock.
And when we talk about TABC, we're talking about the Texas Bureau of Alcohol and, is that correct?
Texas Alcoholic Beverage Commission.
Texas Alcoholic Beverage Commission. And so they have these strict rules, and if bars are in violation, they sometimes have people that go into the bars to check on their compliance. Is that correct?
Correct.
And sometimes they may come like and inspect your bar, or they may have somebody that's there either trying to buy alcohol underage, or they may have somebody trying to check to see if you're complying with your stop drinking times.
Yes, sir. Plenty of times.
And so that's something that's of concern to you, is that you have your drinking, that you stop selling at 2, correct?
Correct.
And then you have to have everybody stop drinking by 2:15.
Correct.
But at what time do you start picking up the actual bottles of beer?
As what my pattern is, when it's closer to that time, when it's 2 o'clock, I start going like this around the whole dance floor. I'll go another 5, 6 times around the dance floor, and I'm aiming at my watch and telling them to drink up. With that, I'm either I have a porter with me or I'm by myself on the dance floor because everybody else, it's a big club, and I'm throwing away the empty bottles or the bottles that are halfway, and telling with what I'm doing, I'm letting our customers know that it's time. Start drinking up. And on the third time, because I'll tell them the first time, hey, it's time. Then I'll go around the second time, the same person, and it's time, hurry up, I'll be right back. And the third time, they've already been told 3 times, that's when they know to give them up. And it's customary. That's what we do. And we pick up everything and we sweep. We basically sweep like clockwise, and we take everything off where everything's empty.
And at that time, all the porters and the security officers come to the floor to help collect all the alcohol. Is that correct?
Yes, that's correct.
And what does a porter do at your establishment?
Porter's always picking up trash, broken bottles, empty bottles, any debris that needs to go into the trash can.
Okay. And then the security officers, what are their roles?
Their roles is to oversee the entire clientele inside, the parking lot outside, to continue to overwatch the bars, to continue to overwatch me, and to be on alert if something comes in.
And on a night like this, like how many security officers would be inside the club?
We always do more. We're required for the size of our club to have 3 security. That's the requirement by TABC. I think, and it might be 3 or 4, but it's like if you have 200, you're supposed to have 1 security guard, something, there's a matrix. However, I always try to get 8 to 13. I always want to have an abundance of security so they can cover the outside, they can cover each other, they can cover the inside, and then we can also patrol the parking lot.
And in a normal night, how many people might be outside versus inside?
Security?
Yeah.
2. 2 is a protocol, 2 guns outside at all times.
Okay. And then there may be some other guys going out to deal with incidents or something like that.
To deal or talk with customers, to go to the parking lot. The parking lot's around the corner of the building. So somebody will take off out there to scan the area, make sure there's no burglaries. And the rest of the guys are by the restrooms. We have them posted by the restrooms and strategically.
How big was El Volcan?
10,000 square feet.
10,000 square feet, so that's very large. And it's all on one level?
Yes, sir.
And then, how many people can fit, what's the amount of people that can fit in that establishment?
I don't know if it was 860, from the upper 800 to lower 900. I don't know, I can't remember the exact number.
And that's a lot of people, right?
Yes.
Like on a Saturday night like this, about how many people would be in El Volcan at a time?
We're known for the safest club, so I mean, we'd get to the point where it wouldn't be how many we can put in, is how many people are going out. That's how many people we let in. If 6 people left, 6 people would go in once we hit our capacity.
And then, on this particular night, how did you get kind of alerted that there was a problem?
Me and the door guy, also my staff, like Chris and the door guy, they'll at some point during the night, they'll be from outside, they'll go inside and assist us. So me and I believe his name was William, we were walking the dance floor. We had already made our rounds. We were on our 3rd round coming around. We were probably 40, 50 feet away from where Tina and Pablo were sitting. In their area where they normally sit. At that point right there, I see something, I see a commotion, I see a brawl.
And do you have a walkie-talkie that you carry?
Yes, I do.
Okay, but you didn't hear any radio call about it, is that correct?
No, I don't have a speaker. I'm the one that just calls it in.
Okay.
I don't monitor the chatter. If I see a problem, if I see somebody, putting their baseball cap backwards, putting their shoulders up, some demeanor, I'll call security in, go to this area, go to bar 3, go to bar 1, just monitor.
And so when you heard the commotion, what did you do?
I saw the commotion, and it's dark. It's a club, it's dark, and there's a lot of lights, but I saw like just a ball, and then people were getting away. So I knew there was something. So me and the gentleman with me, the door guy, we ran up there. And as I'm running up there, I see it's just there on top, and it's just a mountain. To me, it was a mountain of people, and they were attacking somebody. That's all I saw.
And did you know, I mean, because it is crowded, because it's dark, there's lights, there's this pile of people. Do you know who's in that pile?
No, sir, I did not have a clue of who was where, when, nothing.
Okay. And so describe that. So when you start to have, what do you do when you see that?
As I'm running to a situation like that, I am immediately assessing. I'm looking out for security guards. I'm probably yelling on the radio. There's so many things simultaneously that are going on. And as we're approaching, my staff is ordered, their protocol is to make a wall around the problem, to stand. They're not allowed to get involved. Just stand, watch while the security gets there and they take over. But at least nobody else gets hurt. They're just there to instruct it. So as me and the gentleman were running, I see them just wailing on somebody. I did not know who it was. There was 3 to 4 guys and a girl. They were on top, just wailing at somebody.
When you say wailing, you mean they were throwing punches?
Oh yeah, it was bad.
Okay. And so when you get up there, what do you do?
Well, at that point, there's only 2 things I could do. I don't see security yet because it's happening so fast. I'm yelling it in. And I just went and I mowed them over. I pushed everybody off. With the momentum of me running, I just put my hands on the whole crowd and rolled them over. And I remember getting up, and the first person I got is this girl. I grabbed her. She was hitting somebody down there. I grabbed her up, pushed her off. I got the guy here, pushed him off, and then we're peeling off the other guys. When they saw who it was that went there, they immediately dispersed. That's when I believe security got there, and they were handling.
Okay. And at some point, when you first got up, when did you realize it was Anthony that was on the ground?
After we peeled them off, after I picked up the girl and moved that guy and pushed them. off the mound, so to speak. Then I noticed there was a security belt, security uniform, and a weapon.
And did that scare you, the fact that there was a weapon in this pile of people?
That's my biggest fear. That's my biggest fear. I will not panic. I will go, just alarms are buzzing. That's my biggest fear.
Because if someone gets the gun, they could hurt you, your staff, or your patrons, right?
Yes.
At that point, did you know that Pablo was in that pile of people?
No.
So after that happens, at some point, you kind of get everybody off. Is that fair to say?
Yes.
And we saw the video. We see the video that somebody took with their camera, right? That was passed to, I think, Esperanza. And that video, that clearly does not show the entirety of this encounter. Is that fair to say?
It's very fair to say.
Okay. And does it look to you like it's been edited in some way?
Definitely.
And why do you say that?
Because it doesn't show me running up, doing what I did and peeled the people off. It didn't show me literally grabbed her from behind, picking her up and putting her over here, getting the other guy, which I guess that was her boyfriend because they stayed together, putting him over there and then dispersing the rest of the people off.
Okay. So what we're really just seeing is the very end of the encounter. Is that safe to say?
Going to the ending, yes, sir.
And then we also saw, to some extent, the video that you had, your surveillance video, I guess, from the club.
Yes. Now that will show you, however, it's very hazy, but I could walk through to there I am, and you could see exactly what I did.
Okay. And but it is super hazy, right?
Yes, we
That's
have
one of the
smoke
problems.
machines. Yes, sir.
Yeah. And then one of the other problems, you have all these flashing strobe lights and things like that.
Yes, sir.
Does that sometimes obscure the camera?
Yes, sir.
And make it difficult to see?
Yes, sir.
And then you don't have, it's kind of dark in the club, is that right?
Yes, sir.
And that's because that's like the mood kind of lighting that people like.
Yes, sir.
When they're dancing and stuff like that.
Yes, sir.
And then as we go through this, so once you've got them initially off, let's start with the overall. So, yeah, the surveillance. We do that on this. Yeah, just stop. Okay, kind of describe yeah, it's probably easier for you to look at that bigger one. And then just if you need to move your microphone or if you need to say something, just turn around.
Yeah.
Okay, tell us what we're seeing here.
If you could play it a little bit, just a little bit, so I could just get a grasp of where I'm looking at. Because it'll turn colors with the lights. Yeah, we're looking at the dance floor.
Okay, where we have like a fan over there that's in the way.
Yeah, the fan's right here.
Tell me when you see something that's significant. It's very hard to see, is that correct?
Yes, sir. Okay, if you could back it up right there. Now I know where I'm at. I think I'm in the white shirt.
I'm kind of playing it frame by frame. Can you see where you're at there?
Yes, sir.
Where are you? Can you stand up and point to where you're at?
I believe this is me right here.
Okay. And is the fight already started at this time or not yet?
I think, yes, I think it has.
Do you want me to back it up a
Yes,
little
sir.
bit? Just kind of frame by framing through this. And you just tell me when when you see yourself. Is the music quite loud in there?
Yes, sir.
And in fact, throughout the entire encounter, we see some people on the other side of the dance floor, and they don't seem to be aware of what's going on at all. Is that correct? We see them actually dancing. What about strobe light?
If I'm not mistaken, this camera was probably at 40 feet away.
Okay. You see where you're there at all, or not yet?
Not yet.
Is there something? Well, let me just see what that person. You see that area next to the man in the couch or in the what looks like it could be a baseball hat?
Yes, sir.
Is that the struggle that's going on? It's just very difficult to see. Is that, can you see anything now?
I don't think it's happening yet. Okay, there, that's when I rolled right there, I pushed everybody. It's hard to see it when it's still.
Okay, I'll just play it and you tell me.
I pushed everybody, then I'm feeling them away right there.
So you're that right there when we see you, is that you bending over to pick somebody up?
No, that was one of their people, I'm right there, there I am, right there.
We see somebody kind of stumble away.
Yes, sir.
And who was that? Do you
That
know?
was one of the guys in their party.
We see people struggling there.
That's where, yes, I'm in contact with a couple. They kept coming at me, or coming at the situation.
Okay. Is there anything else you think we need to see from there?
If we just play it full off, and from the beginning, that way I can.
I'm just gonna play it at full speed and you tell me what you see.
Okay. And from this side, it's very hard to see. Right there. There. I came in from that end this way, and I pushed everybody. And the struggle is going on and on and on. See, there goes one guy got pushed, the other guy's on the bottom with the security guard. And that's where I pushed them, because it's still going on. I've already made it one-on-one with the security guard, but these people kept coming. So at least we got a perimeter waiting for the security guards.
Okay. So after you started peeling people off, some of the guys stayed on the fight and some people but Pablo and Anthony are continuing to struggle there on the ground, correct?
Yes, sir.
But after you start peeling people off, and were other staff members like Calvin and Chris also trying to help keep people away?
My staff is the ones that are not certified as security guards or anybody else. They're not allowed to touch, grab, push or anything. They're allowed to make a wall. Now, sometimes they have to grab somebody or something, but our protocol is if staff is there first, you create a wall. You're telling us, here we are, instead of, we don't know where you're at, they're over there. So now we see our staff, half circle, or two guys, they're waving us in, like an airplane, they're just waving us in. And then that's when we all get there, everybody gets there, whoever comes first, either I or security guards, just whoever could come assess and do something in the situation.
Okay. Now, during this period of time, the female is continuing to come and approach you multiple times. Is that true?
Yes, that's correct.
When you first, let's talk about the people. You said there was, how many males were on top of Anthony when you first arrived?
I believe it was 3 plus his nephew and the girl. And I remember the girl because it's rare to see a girl fighting with guys, and she was hands-on.
Okay. And so at some point you saw her hands-on, and then at some point, Carlos, her boyfriend, is trying to like pull her away, and she keeps coming back to the fight, correct?
Yes, sir.
At some point, did she make contact with you physically?
Yes, one of the times that I pushed her back, another fear is I have somebody I'm dealing with here, and this takes priority because he's a licensed armed security guard. So my priority is here, and then I have somebody just continuously on my back. One of the later times that I pushed them back is she made contact with me and scratched my neck part.
May I approach the
Yes.
issue with remark states number 9 and 10? Do you recognize these photos?
Yes, sir.
And what are those photos of?
Of my back.
Of your back, and is this photo 10 is your back and photo 9 is your neck?
Yes.
And when were these photographs taken?
That night when we got home.
Okay. And your wife took these photographs?
Yes, because she saw him. She goes, "Hon, you're scratched up." I said, "Well, I know she made contact with me, but I didn't think it was bad."
And there's a period of time where you're like we see on the other video that's been admitted into evidence, we see you talking to the police officer and your shirt's all kind of undone and like that. Is that because you were showing the officer the injury?
I don't remember.
But if that, you remember why your shirt was all undone when you were talking to the police?
Well, because they were yanking it from behind.
Okay. And these photos 9 and 10, they accurately represent how your neck looked when you got back to your house?
Yes, sir.
I'll tender to the state and move to admit states. Our defendants 9 and 10.
No objection. All right, defense exhibits 9 and 10 is admitted without objection. Yes.
Well, let's talk about the injury we see in number 9. Do you believe that was caused by the female?
Yes.
And the photo we see the scratch on your back, number 10, do you believe that was caused by the female?
Yes.
Not the stream video, the other one, the cell phone. Okay, now, when we start this video, is it apparent to you that this video is only capturing the end part of the altercation?
Yes.
And
yes.
what tells you that?
Because if you see my video, even though it's hazy, you could position those two when I'm standing up and when I'm pushing them, if you were to position those two and back up and forward, there's plenty of video that's missing.
Okay. So here we see, who's that laying on the ground?
Now I know that was Pablo.
Okay. But at the time, did you know that was Pablo?
No, sir.
And the person on top of him is who?
Anthony.
Okay. Now, at this point, when the video starts, the other people that were fighting in that area, they have now stopped or at least moved off of where Anthony is. Is that correct?
That's correct.
And so now, who is this person in the white shirt looking down?
I don't know.
Okay.
I know that next to him, the other security guard has another guy on the floor.
And as we see this video, does it appear that Pablo is continuing to struggle with the officer?
Yes.
Okay. And like right here, he's trying to move his hips in to change direction?
Correct. I mean, he's trying to turn himself around.
Do we see you in this photograph?
Me right there looking down.
Okay.
And I'm watching that as I'm watching him twist and turn and trying to turn around.
What are you doing right here as we see you moving forward?
I'm dealing with that couple, that girl and that guy, and waiting for security. Like I said, it's milliseconds that all this is going on. Right there, I looked down and his hands were more closer to his weapon.
Okay, and now is where we see you actually do like a knee drop on him. Is that correct?
I put one knee on his stomach.
Okay. And why did you do that?
Because his hands were touching the holster.
Okay. And were you concerned at that time for Anthony's safety and your safety?
I was concerned for everybody's safety. I did not want to have a massacre in my club.
Okay. And then as you're dealing with this, we see you starting to get up. Do we see the female coming back towards you?
Yes.
Okay. And then you get up here and push them. Is that correct?
Correct.
And we see you push him again. We see an object at the bottom of the frame. You know what that is?
That appears to be Anthony's hat or somebody's black hat.
Okay. We see her step towards it, and then we see her, I think, pushed again, and then she falls in the area of the hat. Is that correct?
Yes, sir.
Or here, you're doing this with your hand. What are you doing when you're doing this?
When a situation goes on, I yell. And as you can hear me there, I am yelling because I need everybody to understand to get back. I don't care who you are, you have no business.
So here we see some items here on the area on the floor. We see the hat. Do we know what those other items are?
On the very bottom, if you can see that little white rectangular thing, it's about a rectangular right here. This right there.
Mm-hmm.
My wife prints out And labels every radio. That's the radio because that's the label that she prints out like 15, 10. They are all marked and GPS.
Now, in this picture, we can't see the people. Is the struggle continuing during this period of time? Kind of blocked by these other people?
I think the security guards they should be, they'll be coming up from that end.
And then this is the time when you push the girl and the guy, I guess the third time, is that correct?
Yes, because if you can see the distance, they're closer than the previous times. They're real close to what's going on. Where the hat was at, that was far away.
Okay. And she falls in about the direction of where the hat and the radio is?
Yes, sir.
And do we see him reach down to pick something up at this time?
Yes, sir.
And do we know what he picked up?
No, the radio and the hat are no longer there.
When you look back there, we don't see the hat any longer.
No, sir, no hat, no radio. Everything was missing now.
Now, afterwards, Anthony had, afterwards, there was, an effort. Part of your thing is if you have an incident where staff people get hurt, you guys want to document that, is that fair to say?
Yes, sir.
Okay. And, so there were some photos taken of Anthony. Had you seen these photos before? You can take a look at them. What's been marked as defense exhibit 7. Let me go through these real quick. Defense exhibit 7, 5. Let me put them in order first. So we have defense exhibit 4, 5, 6, 7, 8, and states exhibit 33 and 24. Okay. Were these photos that were taken to document any injuries that he might have the night of the event?
If there's any incidents, they're always to take photos at the end of the night as well as write a statement.
And did they do that in this occasion? Did they all write statements and and have photographs taken?
I'm not sure.
Okay.
I'm,
But you've seen these with Anthony, correct?
probably back then.
Yeah.
Yes, sir.
And when you saw Anthony after the event, what did you notice about Anthony?
That night,
Yes.
the morning, he was just, he was showing signs of being in a struggle, you know, after a fight, you're limping, you're red, his face was red and had marks on his face.
Did you notice anything abnormal about his uniform?
Well, that, some of his gear was stripped off.
And was there, at some point, were you informed that the radio was missing?
Yes, immediately after the radio was, known, when we did an inventory of what was missing, we realized that the radio was part of it and we started GPSing it.
What about the baton? Was the baton missing as well?
Yes, the baton,
Did you ever locate the baton?
we didn't locate the baton, no, sir.
Okay. And the radio, so you talk about it, the radio's equipped with a GPS device and you started to GPS that?
Yes, sir. Immediately, it's like pinging the phone. You're trying to ping it to find out where it's at. And they do that through the computer. So they were pinging it and we could see it. It was on I-10 and 1604 at a tire shop, a mechanic shop, in the wee hours of the night, you know, after 3 o'clock in the morning. And then from there, it went to Nixon, Texas.
And that's significant to you, the fact that it went to a tire shop, because you're aware that Mr. Rodriguez was a mechanic, you knew that at the time?
Yes, they fixed the tires of my trailers and my trucks, and they also replaced one of my motors in one of the trucks.
And then after you tracked it to Nixon, at some point, did you describe this to Detective Grossi?
Yes, I told them that there's reports, that we filed reports over there in Nixon, and that we pinged it over there.
And did you ever go out to Nixon to see where it was, or did you ever?
Yes, I know we went there once. It's been a while. I believe we went out there twice, but I know for a fact that we went out there once because it was pinging by a church and an apartment complex, not apartments. They're like 2 duplexes together, like a row, four apartments together.
And you know if the Nixon police ever went out, or the police department handling that area ever went out to try to locate the device?
Yes, one police officer met us out there and we're showing them where it was pinging. And so we were looking around the church building and I didn't want to get close to the apartments. So that was gonna be up to him on what he did.
Okay. But as far as you know, they never did locate the radio after that?
No, sir.
And it no longer functioned after that?
It functioned maybe a week or two, another Saturday, either the next Saturday or one of the Saturdays following. And the reason we know that is because when you click our radios, it tells you who's calling. Like if I have number 16 and I click number 16, all of the radios will say 16 is calling. So that way we identify which guard is calling it in. So we're already on alert to, hey, it's so-and-so's radio, he's clicking it, go check on him. And the number came up with a missing radio, and they were just yelling and screaming and talking while we were conducting business, and it was during business hours.
Okay. John, I'm gonna show definitive definitive 1, 2, and 3. I've already tended these to the state. We're gonna ask that they be admitted. I believe there's no objection.
Any objection?
No objection.
Right, defense exhibits 1, 2, and 3 are admitted without objection.
And is there a camera at the entrance exit door?
Yes.
And are these stills that we took from that entrance exit door camera?
Yes, sir.
And who is in these photographs? Who's the person in the brown shirt?
That's Pablo.
Okay. And is he being escorted by a security guard as he leaves the building?
By Anthony.
Yeah, and Anthony actually is hands-on with him as they leave the building.
He's got his shoulder on him just in case if he wants to turn around, or it's protocol. We put our hands on their shoulders.
Publish the jury. Um. Before this incident happened with Pablo, I mean, when you found out that it was how did you find out it was Pablo that was the person that was on the ground?
I don't remember.
When, did you find out that night or another night?
Yes, that night, because his wife was in the front, but during their whole interaction, I did not know it was him.
And, there were some people that you knew were involved in the fight, but did you know the names, addresses, and phone numbers of these other people that were involved?
No, sir.
Okay. When you did the knee drop on Pablo, was it your intention to cause him, was it your intention to be cruel to him or mean to him in any way?
No, sir.
Okay, what was your intention in doing that?
To stop him from grabbing the weapon.
And did you believe at that time that you were defending yourself and defending Anthony?
Yes, sir, because Anthony, it was, he could not handle him, and something else had to be done before that. Again, milliseconds, he could have grabbed, and it would have been bad.
And now, when you did the knee drop, was it your intention to cause injury to any person when you did that? I mean, was it your intention to cause serious bodily injury to the person that was laying there?
No, sir.
What was your intent? What was your hope was going to happen after that?
I was hoping he's just stop. I was hoping he would just free up and give up.
Okay. And if the female and her boyfriend had actually stayed away, what would you have done if they would have stayed away and not come back to continue to get involved?
I'm just gonna object to speculation now.
Sustain.
Well, let me ask you this. If they had stayed away, that would give you a better opportunity to handle the situation.
If they would have stayed away while we're calling in security, the next thing to do, while there's already somebody hands on the person, the other person immediately grabs the legs and folds them back and neutralizes his movement.
Okay. And so because these other people were getting involved in the fight, did that make it more of a difficult situation for you to contain?
Correct.
Now there were some phone calls between you and Tina afterwards. Can you describe how did that come about?
Tina went to the front and she talked to first she went to my daughter at the front desk, and then she went outside to talk to my son. When she was at the front desk, she asked for my number, and my daughter told her, or she didn't give her my number, so she gave her number to give it to me.
Okay. But it was Tina that reached out to you and asked you to contact her, correct?
Yes, sir.
And then you had a couple phone conversations with her, is that correct?
That's correct.
And you actually sent Tina, I'm gonna show you what's been admitted in the evidence, is, I think you stated it 14. Did you actually send Tina a copy of the video that was on Facebook?
No, I didn't.
Okay. Read that.
It is on his nephew's Facebook, and it is clear on it.
Okay. But is that a video that you sent her?
I don't know if I don't think I sent her the video. I think I sent her a screenshot.
Oh, a
I
screenshot.
don't remember, because her nephew or the girlfriend, they were just saying a lot of negative stuff about us on Facebook.
So in this text, you're saying, it looks bad over here as well. a security guard was beat up real bad. Let's work together and figure this all out. What was your intention in sending that text?
Just to help each other out. We're friends. I didn't want it to go further.
And you said you are my family and I value you very much.
Yes, sir.
And in this question, we hear what colors were his pants? I'm trying to identify. At some point, are you trying to identify the other people that were involved in the fight?
I was trying to identify everybody
And why were you trying to do that?
because I wanted to know who those other guys were that were fighting so we could ban them.
And during the fight, the porter named Calvin, was he injured as part of the fight?
Yes, he ended up going to the hospital with a dislocated shoulder, is what I was told.
And then he missed work the next weekend because of his injuries from the fight?
Yes, sir.
At some point, was she trying to did you feel like she was trying to get money out of you?
Yes, the conversation from us trying to help her started going toward, well, Pablo needs to get compensated. So then it was no longer help. It was like, okay, now it's more, she's talking more of a settlement instead of helping each other out.
What do you mean by helping each other out?
Well, I mean, I was just trying to do the friendly thing and work together. Let's figure this out because it happened and let's just work on it. Let's work it out.
I'll pass this.
All right, ladies and gentlemen, do you all need a short break? All right, so what I'm going to do is I'm going to give you all a 15-minute break. Is that enough time for everyone? All right, please remember my previous instructions and I will have you all back here at 3:45. Everyone, please rise for the jurors.
in video probably just had one. We had the hardwired video, the one you would buy like at Sam's or Costco. And
Those are nice. Sure. All right, court is gonna call 2024 CR 2338B State versus Mariano Rendon. Can I have parties announce?
Megan Gower and Jason Garahan for the state.
Dave Bloomquist for the defense.
And are you Mr. Rendon?
yes, Your Honor.
All right, are both parties ready to proceed?
Yes, Your Honor.
All right, let's bring the jurors in. Okay, sure. Yes. All right, the parties on Rebecca Davis. Court is calling 2025 CR 003154 State versus Rebecca Davis. Could I have parties announced for the record?
Thank you for the defendant.
And are you Rebecca? Just have you seen discovery?
Yes,
Did you review it with your client?
we've gone over it. Yes.
Court will find that the state is in compliance with discovery. Ms. Davis, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do.
State, are you proceeding on the indictment as presented? Ms. Davis, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with driving while intoxicated third or more? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine.
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, she has. She has assisted me.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, I do.
Ms. Davis, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 8 years in the prison. There's a $2,000 fine. State recommends community supervision. They're taking in consideration 2024 PF 28045. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No such motions.
All right, off the record, probation, this is cause number 2025 CR 003154, and it's an application for probation. All right, we're back on the record. Outside the agreement, the state is asking that your punishment be assessed at 8 years in the prison. That your length of probation. See, I'm trying to make sure everybody's awake. It's shocking everybody's system.
Yeah.
What they're asking for is that your length of probation be 8 years, that there be a TAP evaluation, 200 hours of community service restitution, 2-year license suspension, and they're asking that there be 10 days in the Bexar County Jail as a condition of your probation. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
And state, with regards to the 10 days in the Bexar County Jail, would you object to her serving that on GPS?
No objection.
Right. Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
State offers exhibit 1 and attachment.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We'd like to proceed, Your Honor.
All right, anything you wish to say on behalf of your client?
Yes, yes, Your Honor. Since the date of offense, she has been in a rehab facility. It's now 90 days. And she may be better to explain this facility to you.
All right, what facility are you in?
SOBA, SOBA,
And where is it located?
here in San Antonio. Northeast side, I believe.
All right, I'm gonna have to look that up.
Yeah,
I did
it's
not know about it.
amazing.
So could you tell the judge about
Yes,
some,
I would love to.
everything that they offer and that it's a lockdown facility?
Yeah, okay, so it's typically a 60-day program, and the first 30 days is residential, and you are not allowed to leave. You get 4-hour visits on both Saturday and Sunday. We are in class from 9 a.m. until 4 p.m. They take us to Gold's Gym at 4 p.m. if you would like to go Monday
Well, I
through
need to
Friday.
join that just
I
to
know,
get in.
just to get the gym membership. They introduce yoga classes. We have yoga twice per week. We have CBT training, which is cognitive behavioral therapy. I have my own individual therapist and my own individual caseworker. Most of the staff are recovering either alcoholics or drug addicts, so they understand. We have an AA meeting every night from 7 to 8, Monday through Sunday. Yes, we are actually breathalyzed twice per day, once in the morning and once in the evening. And then we are UA'd Monday, Wednesday, Friday, and that's actually sent off to the laboratory as well. And that's typical for your whole stay. Like that's never going to change. After 30 days, you enter a PHP, which is partial hospitalization. I believe they shave off 2 classes, so you have a little bit more free time.
Oh, you know what? Now that you mentioned the hospitalization part of this, I do know about this program because somebody brought someone who actually is over the program to come talk to me about it, but continue.
Okay.
Because I think people should know about this.
Yeah, you enter PHP and like I said, partial hospitalization. They shave off 2 classes, but that's just to have more time to get with your sponsor and go through the steps, that kind of thing. It's very step-based, the whole program. During PHP, you get 2 4-hour passes, one on Saturday and one on Sunday, so you can leave the premises, but they UA you upon re-entry to the facility. And then after the 60 days, you can choose to go into the next 30 days, which is IOP. It's less classes. We only have to attend AA 5 nights per week, but that's when you get a job. The facility actually helps you get to and from work for the whole first month, whether it be Uber or someone taking you. I'm gluten intolerant and they buy me special food. It's a fantastic facility. So I've learned so much and just in the short period of time that I've been there.
So how much longer time do you have with inpatient?
So I'm gonna be totally transparent. I had entered the facility on February 10th and was released on March 13th.
Mhm.
It took about 2 weeks, but I relapsed. I was not doing what I was supposed to be doing, which was attend to AA, talk to my sponsor. I was self-isolating again. And so it took 2 weeks, but the thoughts control the behavior, which control the actions, and or feelings then control the actions. So I did relapse. I then scared the crap out of me because I don't want to be an alcoholic. Well, I'm going to be an alcoholic, but I don't want to. I want to live a nice life.
Mhm.
And because I used to have everything and I lost it all. I'm at rock bottom. And so I re-entered the program voluntarily last Monday. It'll be 2 weeks. So I have another 6 weeks before I enter the IOP, which is when I go get a job and everything like that. I plan on staying in sober living afterwards. So that's going to be another controlled environment with UAs and breathalyzing. And I can do that at SOBA. So they actually have, I think it's like 25 acres or something like that. Yeah, it's amazing. It sprawls out. There's a men's house, a women's house, a nursing
I
station.
have to come and get a tour.
Yeah.
I've had the people at the facility come and talk to me because it really clicked with me when you mentioned the hospitalization part.
Yes, ma'am.
Because the person talked to me and they told me that with alcohol and really with any other drug, of course, you got to detox and all of that.
Yes, ma'am.
And then you got to get your mind straight.
Mhm.
But then the hospitalization part is a part of that. So there won't
Yes,
be any
I totally forgot
backslides.
that. Yeah, it's actually considered a dual facility for both rehabilitation from substances and a mental facility.
Mhm.
So I am medicated. I have bipolar 2, ADHD, OCD, those kind of things, PTSD, and from childhood trauma. And yes, I'm on a bipolar med. If you can't sleep, they help you with, and non-narcotic, of course, sleep, like melatonin. It's just a fabulous facility. Like all the staff is super caring, the nursing staff. We've got a doctor on call at all times, Dr. Healy, he's a psychiatrist.
Yes,
Uh-huh.
that's who talked to me.
Yeah, Dr. Healy. Yeah, he's awesome. He's awesome. He really listens and doesn't just push pills. Like I can't stand that. Like I don't want to be over medicated. I don't want to be a zombie. I just need the help. So
Okay, awesome.
Let me just ask a question. So you're locked down for how many more days?
for another 6 weeks, I cannot leave. Well, I can leave the facility, like I said, for the 4-hour passes, after 30 days on Saturday and Sunday. But I would not be adverse to just foregoing those passes, just to stay in the lockdown, aspect of it. But like I said, after the 60 days, that's when you can actually leave and go get a job. And yeah.
All right, so you're going to have to sign a release for probation. Probation, with regards to this facility where she is, you all can do the UA testing or you can accept their UA testing, however, that's appropriate under your program. So, all right, thank you. So as previously stated, the court is going to find you guilty. The court will sentence you to 8 years in prison, suspended and probated for 6 years. There's to be regular reporting by Zoom or in person. You to continue with treatment at SOBA, SOBA?
Yes, ma'am.
All right. There is to be a 2-year license suspension. All right, with regards to the GPS, if she were on full lock time at that facility and they were not allowing her to leave, I wouldn't even do GPS because she would be there.
And
So-
that was where I was trying to go to because we had talked about that and if the court instructs her that she's still within that lockdown for 2 more weeks, and then she would be where she got some freedom, but the court could order that she could not leave the facility for those 4 hours.
Those other 30 days.
All right, so
It's up to y'all.
then,
I mean, I
well,
don't.
here's the thing, GPS is expensive.
Yes.
Yes, ma'am. And I
Yeah.
am indigent.
Yeah.
Like I said, I've lost everything.
All right, State, do you have any objection to the court ordering that since she's at SOBA, that for the 10 days, she is to be on their lockdown and not leave campus?
As long as there's verification that she does remain on campus for the entire 10 days, they know the state is not in.
All right. So in lieu of the 10 days in the Bear County Jail, I'm going to order that you're to remain at SOBA on their lockdown
Yes, ma'am.
and not leave the campus.
Yes, ma'am.
And she was brought here by the facility.
Yes, they
Oh,
take you
yeah.
to appointments.
where are they?
They're not in court.
Okay.
Yeah, I just call them and they
Yeah.
come pick me
Okay.
up. Yes, ma'am. Like I said, it's a fantastic facility. I just can't get over the level of care and understanding, just because, like I said, most of the staff, even my therapist has a master's degree in social work and he is a recovering alcoholic. So he does this amazing therapy called EBDT.
Mhm.
It's fairly new. It's about 3 years old and it's like hypnosis based.
Mhm.
And you target like a traumatic memory and he walks you through and it's got this wand. It's really weird, but it is like magic. So yeah, it's great therapy.
Okay. All right. And then there will be, and as I previously stated, in lieu of the 10 days in the Bear County Jail, there's to be complete lockdown at the SOBA facility for 10 days. A DWI education course, VIP Live, DWI intervention. And if they have those programs at that facility, then those will count towards that. But you will need to give a release to probation so that they can make sure that those programs are equivalent to the programs that I'm requesting.
Yes, ma'am.
All right, there's 200 hours of community service restitution. Do you have any children?
I do. They don't live with me. My 14-year-old lives in Kyle with his father, and then my 23-year-old is on his own. He's very successful.
All right. I'm going to order parenting classes. Once she completes that, the community service hours will be deemed satisfied. Do you have any vehicles?
No, ma'am. Well, I have a vehicle right now, and that's something that I would like to discuss as well. It's about to go back to the bank. Like I said, I'm indigent. I have no way to pay for it. Plus, I haven't been driving it. It's been sitting in my boyfriend's driveway, but with the breathalyzer on it. Like I said, it's going to have to either get sold back to CarMax if they accept it or go back to the bank. And I was hoping to get a release of breathalyzer off the vehicle because I cannot, excuse me, cannot sell it or turn it back to the bank with the Smart Start device on it. I would not be adverse to getting an in-home device. That's, I know that's typical.
All right, so what I'll do is, it's going to be ignition interlock for half the term, or you can provide an affidavit of non-driving, and the court will order a portable alcohol monitoring device.
And will that allow me to, because I believe Smart Start needs proof of a judge release?
They're going to give everything to you.
Okay, yes, ma'am. Thank you.
There'll be field visits one time per month for 6 months. Proof of employment within 45 days of release from SOBA. There's to be no employment as a home healthcare provider or with minors. And I'm going to order 120 sober meetings in 120 days. I know you're already doing that there, and you'll need to make sure that they receive that.
Yes, ma'am.
Taking consideration 2024 PF 28045. Probation, is there anything else?
No, Judge, I think that'll be it.
Is there anything else you need from the court in order to be successful?
No, ma'am. You've been extremely helpful. Thank you.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question about that, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. I'm glad that you are taking this seriously, because alcohol and driving just does not mix. You could easily kill someone. You understand?
Yes, ma'am. And I thank God every day that I did not harm someone else and I didn't kill myself. So just because my boys would be devastated and my family in general. So.
Well, here's the thing. In this court, your attorney will tell you communication is key to successfully complete probation in here. If there's an issue, let your probation officer know. If you feel they're not addressing it, you can always come back to court, okay?
Yes, ma'am.
All right, good luck to you.
Thank you.
Just remain in court probation. We'll go over conditions.
Yes, ma'am. Thank you.
You're welcome. And State, if I could have that dismissal. I gave her the appointment for Charles. All right, awesome. And let me see the file on Hernandez and on Javier Herrera, please. Oh, go ahead. Okay, so you all need to explain this to the court.
Yes, ma'am. We've spoken with the complainant. This is the outcome that she wants. And that she feels controlling over the
And how is the complainant?
20, well, I'm sorry, she's born in, she's 26 now, Your Honor.
All right, and so the complainant is now 26 years old and this is what she's requesting?
Yes, Your Honor.
Okay. Court is calling 2021 CR 2011 State versus Javier Herrera. Can I have parties announced for the record? State?
Ashley Jones for the state.
Lindsay Shaw, I'm sorry, Lindsay Shaw for Mr. Herrera.
And are you Mr. Herrera? Did you review this document entitled deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am, I did.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are not, Your Honor. We are proceeding only on count 2, which is indecency of telephone.
Did you review the court admonishments with your attorney? Did you understand it? Did you cite it in all the appropriate places?
Yes, Your Honor, I did.
Did you understand the state is proceeding on count 2, indecency with a child by contact? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you're giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Herrera, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, there's a $1,500 fine. There's to be no contact with the complainant, and Chapter 62 registration in the state is recommending deferred adjudication. Did you understand that to be the plea?
Yes, Your Honor. I did.
Defense is at the plea.
Yes, ma'am.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, ma'am.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 5 years, 200 hours community service restitution, and you're to be supervised by the sex offender unit. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Did you count 2? How do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State offer states Exhibit 1 in all attachments.
No objection.
All right, did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. All right, so why am I following this agreement? Or I should say, why should I follow this agreement?
Your Honor, we have discussed this agreement at length with the complainant, including just proceeding to trial and having a jury decide whether the defendant is guilty or not guilty. She understands everything that comes along with the trial and everything that would come along with this plea agreement. She has chosen, or at least let the state know that she would, her preference would be to go forward with the plea.
All right, and now the former child is now an adult?
She is, Your Honor, and I did misspeak earlier. I aged her by a year. She's only 25, but she does not have any contact with the defendant. My understanding was that the defendant was married to the complainant's mother, had gotten divorced, and has been divorced from their mother for quite some time now.
All right, do you have any other children?
Yes, Your Honor, I do.
And what are their ages?
10 and 5, Your Honor.
All right, I'm not going to allow you to have contact with minors. I'm not going to allow you to reside in any household with minors. You can't be trusted around children.
Yes, Your Honor.
So I'm going to give you a choice. Here are your choices. The state is asking that your community supervision be for 5 years. That's a recommendation for them. I'm going to make it 10.
Yes.
Or either if you all would want to negotiate a prison term, you can. Otherwise, it's going to be 10 years deferred adjudication.
Yes, Your Honor.
So do you want 10 years deferred adjudication?
Yes, Your Honor.
All right, there's a $1,500 fine. 10 years deferred adjudication. There's to be no contact with minors. No contact with the complainant. Chapter 62 registration. Regular reporting, and that's going to be in person. Regular random UAs. Proof of employment within 35 days of release. There's to be no employment as a home healthcare provider or with minors. There's to be no residing in a household with minors. He's to be supervised by the sex offender unit. They're asking for community service hours. There's no community service hours I can give you legally because there's no place that will accept community service from you. There's going to be 180 days in the Bexar County Jail as a condition of probation. Probation, is there anything else? And we can do a TAP evaluation while in custody.
No other things, Judge.
All right, there'll be a TAP evaluation in custody. Follow recommendations. Is there anything else you need from the court in order to be successful?
Oh, yeah.
Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. So what I can tell you is the complainant saved you from going to prison. Because in this specific case, if the complainant still would have been a child, I would not have followed this agreement. But because she's an adult, I realized that maybe her mother or somebody is not pulling strings. You understand?
Yes, Your Honor.
All right, is there anything else?
Yes, Your Honor, we do have victim impact statements. We are having a little bit of trouble getting the link to the complainant. I would just ask maybe for about 5 minutes so that.
All right, then what we can do is if she is she able by phone?
Yes, Your Honor.
All right, so then what we can do is if he'll go into the box and then you all can play the phone for him where she does her victim impact.
One thing we missed was the field visits.
All right, thank you. Field visits 1 time per month until further notice.
Judge, if I may, my client, when he was arrested, he's been living in Cheyenne, Wyoming for the last 6 years. We would ask once he's released from custody if we could have this transferred to Cheyenne, Wyoming.
Do we know what county that is?
I can look it up really quick, Judge.
All right, and I'll look it up as well. And there's to be a transfer to Cheyenne, Wyoming. You're not transferred unless they accept you. Do you understand?
Yes, Your Honor. got arrested when I was on my way to work, and I left my belongings over there to my employer, so I have no ID, no social security.
It's Laramie County.
Okay, thank you, Judge.
All right, thank you. All right, thank you.
Thank you, Judge.
And then Lindsay on Abel Hernandez.
Those are mine, sure.
All right, court is gonna call 2024 CR 2338B State versus Mariano Rendon. Can I have parties announce?
Megan Gower and Jason Garahan for the state.
Larry Bloomquist for the defense.
And are you Mr. Rendon?
Yes, Your Honor.
All right, are both parties ready to proceed?
Yes, Your Honor.
All right, let's bring the jurors in.
Okay, just move this.
Okay, sure.
Maybe make sure.
Yes.
Hernandez, stand, please. That was fun.
All right, if you'll restate your name for the record, please.
Tina Linda Jimenez.
All right, still under oath. Defense, you may proceed.
Thank you. Tina, I just had a couple quick questions for you. My first question is, were you there when Pablo exited the building?
As far as I can remember, yes.
Okay. And I think you testified that you guys just walked out and that nobody escorted you out. Is that correct?
Right, nobody was, that I can remember, nobody was holding Pablo. I know nobody was holding me.
Okay. And if there was somebody holding Pablo, was that possible that that did happen?
Could be.
Okay. And Pablo was wearing a brown shirt that evening, is that correct?
I don't recall.
Well, we saw him in the video yesterday and he was wearing a brown shirt. Is that accurate?
I would say yes.
May I approach? Oh,
Yes.
Let me show you which have at this time just been marked for identification purposes. Defense exhibit 1, 2, and 3. They've not yet been admitted to evidence. But can you just look at those, and are those photographs of do you recognize the person in this photograph?
Yes, Pablo.
That's Pablo.
Yes,
And we see Pablo being in both state defense 1, 2, and 3.
yes.
Does that refresh your recollection
Okay.
about whether he walked out by himself or whether he was escorted out by security?
Okay, that refreshes my mind now.
Okay. And so the answer is yes, he was escorted out by security.
If it's on there, yes.
And then there was some conversations that we had about drinking. And I think you had said that he had had about 5 drinks in total, correct?
Exactly.
And the way that you were kind of portraying it was that Pablo was not intoxicated. Is that what you were trying to convey to the jury?
That is correct.
Okay. There was a conversation that you had with Mariano Rendon. Is that correct?
Correct.
And part of that conversation was you were seeking compensation for Pablo's injuries.
I don't recall that.
Okay. Did you ask that basically telling him things like, well, you need to make this right, things like that?
Of course, because Paulo got hurt very bad.
During that conversation, isn't it true that you made, I'm going to read you a couple statements and just let me know if you made it,
Okay.
okay, or not. He had a little more to drink. It was his birthday. Did
I
you
don't
make that
recall
statement?
I don't recall.
Okay. Is it possible that you made that statement?
I don't recall.
Okay. Pablo was a little more drunk than normal because we had went to have dinner with all of our family and we had margaritas. Do you remember making that statement?
No, I don't recall.
Okay. But it's possible you made that statement?
I don't recall.
Okay. I can say Pablo had more to drink than normal.
I don't recall.
He drank and drank it for his birthday. Do you remember making that statement?
No,
You're saying you did not make that statement.
I don't recall making that statement.
Okay.
He drank and drank, no.
He had been drinking more than he was supposed to. My apologies. Did you make that
I don't
statement?
recall.
Okay. Judge, may
Yes.
I have some moments with her outside the presence of the jury?
Could I have parties approach?
Yes. How are the headphones connected? How do I connect them?
Deputy Laura, do you have the headphones for him? Over here.
Oh, okay.
And if there should be an outlet in your computer, I think. Yes, they're wrapped tightly.
Good arm workout.
Oh, he's not plugging into his computer. Hopefully it's the right side.
Tina, I'm gonna play you 2 audio clips.
Okay.
And I'm gonna ask you afterwards whether that refreshes your recollection, if you did make those statements, and you'll either admit or deny making those statements, okay?
Okay.
If you need to hear it more than once, I'm okay with that. Just let me know, okay?
Okay.
You hear it okay?
Don't hear anything.
You don't hear anything?
Mm-mm.
Just let me know if you hear it now.
Loud.
You need more volume or less, let me know.
And it, that's fine.
You need to hear it
Okay.
again?
No.
I'll play the second clip.
Okay, no.
Okay. He takes the headphones off. Was that able to refresh your record?
Yes, yes.
Okay. And okay. Did that refresh your recollection?
Yes.
Okay. So in fact, you did make the statement, he had a little more to drink. It was his birthday, correct?
Yes, but not to the point to be intoxicated.
And then you did say, Pablo was a little more drunk than normal because we had went to our dinner with our family and we had margaritas, correct?
Which was 1 each.
But you did say he was a little bit more drunk than normal,
A
correct?
little bit.
I can say Pablo had more to drink than normal. You said made that statement as well, correct?
Correct.
And then you said he drank and drank for his birthday, correct?
I said that, the normal 5.
He drank more than he was supposed to. My apologies. Did you make that statement?
Yes, I did.
Okay. So you recall, this just kind of refresh your recollection and you do admit to making all of these statements.
I do.
I'll pass the witness, Your Honor.
All right, State.
Yes. Do you remember during this 40-minute conversation that was recorded by the defendant, that was a phone call that you had with the defendant the next day?
That is correct, but I didn't know I was being recorded.
Okay. But to be fair, it was your voice on there and it was the defendant's voice.
That is correct.
And you recall the defendant saying, look, I know Pablo wasn't plastered drunk or anything.
Right,
And.
correct,
And you did say Pablo had a little bit more to drink than normal.
correct.
And normal, he drinks how many?
3 to 4.
Okay, so and this night he had at least five, well, we're saying around 5 or so.
5, yes,
Okay.
plus that one margarita we had.
All right. And, you know, during this long conversation, and I know you probably don't remember it all, because have you ever heard that 40-minute phone conversation, the recording?
No, sir.
So you're just going off your memory right now?
Yes,
And the
yes.
small portions that defense played for you?
Exactly,
Okay, so he did only played snippets of that whole conversation,
exactly, he did.
but it was a 40-minute conversation.
Yes, it was.
And y'all spoke about many things about that night.
Yes, sir, we sure did.
Spoke about the security guards taking your husband to the ground
Yes,
and also beating on your husband,
yes,
and that your husband was pretty beat up.
absolutely, yes.
And this is before the surgery, though. This is the next day.
The next day, yes,
So he didn't have his surgery until several days later.
exactly, yes, sir.
So you were unaware that Pablo had a ruptured intestines.
That's correct.
So, oh, well, let me ask you this. Were you aware that this man from that video had kneed your husband so violently in that video?
No.
So when you're speaking to him on this recorded conversation that he recorded without your knowledge, he didn't tell you at any time during this conversation that he used both his knees and jumped into your husband's stomach, did he?
No, he didn't.
You thought this was a friend trying to help you.
That's correct.
And then on top of that, in this conversation, he tells you Pablo will be charged with a felony.
That is correct.
Several times he tells you Pablo will be charged, you can be charged, the nephew can be charged, and also the nephew's girlfriend, did he not?
Yes, sir, he did.
And then on top of that, he says, but look, you remember him saying this? He says, we want to de-escalate this. Let's not press charges.
Yes, he sure did. Plenty of times.
And so during this long conversation of him saying this, did he also say, I have every right, legal right to do whatever means it takes to dis-escalate the situation?
That is correct.
And then he also say, I do whatever it takes.
Yes, he did.
Do whatever means to get people out.
Yes, that's correct.
Pass the witness.
I have no further questions for this witness.
All right, is this witness excused or subject for recall?
She can be excused, Your Honor.
All right, the rule has been invoked, so you are not allowed to discuss your testimony with anyone except for attorneys for the state or the defense. Do you understand? All right, you may step down. Don't forget to leave your microphone.
Thank you.
Your Honor, at this time, we'll call Jacqueline Reyes. I'll grab her.
If you could raise your hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Make sure you keep your voice up so that the members of the jury can hear. If you could state your name for the record.
Jacqueline Reyes.
All right, you may proceed.
Judge, remember you approach briefly?
Yes. Right, defense, you may proceed.
Can you state your name for the record?
Jacqueline Reyes?
And Jacqueline, had you been employed as a bartender at El Volcan?
Yes,
And how long did you work at El Volcan?
about 8 years.
Okay. And do you have any family relationship to Mariano Rendon?
Yes,
And how are you related to him?
he's my father-in-law.
Okay. And describe your general duties as a bartender there at El Volcan.
Not over serving, making sure people are only getting the amount of liquor they're supposed to or beer, and then cutting them off as soon as you see that they're too intoxicated.
Okay. And then just generally making drinks and serving them. Do you serve at the bar or do you serve outside the bar, just at the bar?
Just at the bar.
Okay. And then did you know Tina Jimenez and Pablo Rodriguez? Did you know them?
Yeah, they would come in every weekend.
Okay. So they were regulars, would you say?
Yes, I would serve them every weekend.
And do you know if they sat in a particular area of the bar when they would come in?
Yes,
And where was that at?
closer to my bar by the kitchen.
Okay. And so were you the bartender that they would always go to purchase their drinks from?
Yes,
Okay, because you're right there as close to where they always sit in the same area, correct?
yes.
So, I mean, over to the last, and how long have they been coming there?
I remember them probably about 6 years back.
6 years back?
I would be there every weekend.
So you would see them every week for about 6 years?
Yes.
Plus or minus 1 or 2 weeks, right?
Yes.
During that period of time, what would they generally order when they would come into the bar?
They would order a couple beers, Modelos, and then they would switch off between Modelo and Bucana and Red Bull.
What is Bucana and Red Bull?
It's a whiskey.
Okay, Bucana's a whiskey.
Yes.
And then they would they sometimes buy the beer by the bucket?
They would get them in pairs.
In pairs, okay. And were there times when, had you ever had to cut Pablo off from drinking because he was overserved?
Objection. I'm gonna object to the form of the question and relevance as to previous.
The relevance was the state made an effort to show that they had drank very little on that occasion. And the fact that he was had been
All right,
seen.
that objection will be sustained.
Did you see, were there times when you would see Pablo Rodriguez where you felt that he was intoxicated?
Yes, there was a couple of times where he would be really, really sweaty, more than
Object
usual.
To the question, if I object.
Could everyone please approach? All right, so just so you know, when any attorney makes an objection, just stop speaking, because that means they want me to make a ruling on something. Nope, just 1 second.
So on the night, did you see Pablo Rodriguez and Tina Jimenez the night that this big fight occurred?
Yes,
And was that the last time that you saw them at the bar?
yes.
Okay. And can you describe what you noticed about Pablo Rodriguez's demeanor that night?
He was a little more intoxicated than usual. He was really sweaty. His eyes were red, and he was a little humbly. So I cut him off.
Okay. And then, and about how long, from the time that you cut him off to the time that the fight occurred, about how long had that been?
Maybe 30 minutes.
Okay. But as a bartender, one of the problems is that if I go and buy let's say I come up to you and I buy 4 drinks, right? You can't control who might else hand somebody a beer or a drink, correct?
No,
Once I leave the bar, it's like you can't control who I'm giving those to.
correct.
And there are times when you may cut off a patron, but another patron may give them alcohol that you're unaware of. Is that fair to say?
Yes.
Okay. I'll pass the witness.
All right, state.
Ms. Reyes, so you stated that the defendant is your father-in-law, is that correct?
Yes.
And about how long have you known him?
15 years.
Okay, and so I'm assuming you're married to his son, is that correct?
Yes.
Do you have children with his son?
2.
Okay. And so you've known him for 15 years, and you said you've been married or together with the son for how many years?
15.
Okay, and then you worked at Volcan for 8 years, is that correct?
Yes.
Okay, and the whole time that you've been employed at Volcan, were you a bartender?
No, I started off working the door
Okay.
and then I switched over to bartending.
And then you stated, well, I guess Volcan is closed currently, correct?
Yes.
Okay, and about how long ago did it close?
About 30 days, a little
Like
over.
a month ago,
Yeah.
maybe? And that was the location that's located at Ingram Road, is that correct?
Yes.
Okay, and it's a little up the street from Ingram Park Mall, correct?
Yes.
And that's located here in Bear County?
Yes.
Okay, and isn't it true that the defendant is opening a new Volcan at Randy's Ballroom on Bandera Road?
Yes.
Okay, and that's set to open this weekend, correct?
Correct.
Okay, and so in your duties as a bartender, well, I guess if we describe the atmosphere at Volcan, I mean, it's a place that people go to drink alcohol, correct, and dance, right? Is that right?
Yes.
Okay, and so that's kind of the experience that you all seek to provide, right? A good time where people can drink alcohol and dance to cumbias and norteño music.
Yeah,
is that
safe
correct?
environment for them to have fun.
Okay, and just so the jury's aware, that cumbias and norteños is just a type of Spanish music, is that correct?
Yes.
Okay, and that was predominantly what you all would play there at Volcan, correct?
Correct.
Okay, and so you stated that on the night of the incident, well, I guess you stated that you were familiar with Pablo and Tina, is that correct?
Yes.
Okay, and they were regulars of yours, correct?
Yes.
And you stated on the night of that you observed Pablo with red eyes, is that correct?
Yes.
Would it surprise you to know that a police officer that interacted with him a couple of maybe 30 minutes later didn't note those same observations?
Don't see how he didn't see that. His eyes were bright red.
Okay. And you stated that you cut Pablo off on that night, is that correct?
Yes.
Okay. But you were at the bar when the fight happened, correct?
It was right after we closed down the bar.
Okay, so you didn't actually see what happened regarding the fight, is that correct?
No, I saw after the aftermath.
Okay, and I guess I kind of have a question because I'm kind of confused about how you guys, or the protocol about last call. So when we say last call, is that an announcement that's being made for people to go buy their last drink? Or can you explain that to me?
So we announce it on the microphone, that last call, they have 10 minutes to go get a last drink or finish their drink.
Okay,
And then we pull alcohol at 2.
okay. So then, if somebody chooses to go buy their last drink, they're expected to drink that within the last 10 minutes?
No, we give them about 5 minutes to finish.
Okay, I'm a little confused. So you announce last call, correct? And that gives the patrons a choice to either buy their last beer or finish the drink that they currently have, is that correct?
Yes.
Okay, so if a patron was there and at last call, they decide, hey, I'm gonna go get my last beer, then how fast are they expected to drink that beer?
They need to have it done by at least 2:01. So we start telling them they need to finish it
they need to go in the trash.
Okay, and so about how many minutes is that they're expected to drink their last drink if they were to buy it at the last call?
For 10 minutes.
In 10 minutes?
Mhm.
Okay. That's pretty dangerous situation if you have somebody that's chugging a drink in 10 minutes. correct?
Objection relevance.
All right, that'll be sustained.
We pass the witness, Your Honor.
You said that you saw the aftermath of the fight. Did you see people that worked at the bar that were injured?
Yes.
And who did you see that was injured?
Calvin and Anthony.
And I just want to talk about your observations. What did you observe about Anthony?
Anthony was all red. All his equipment was taken off, and he looked like he got scratched up a little bit. He was red.
What did you notice about Calvin?
Calvin was holding his shoulder. They threw him on the floor, and he said that it was hurting really bad.
I'll pass witness.
All right, any further questions?
Just briefly, Your Honor. Does Volcan have cameras inside?
Yes.
Okay. And in your experience in working there, are the cameras usually in good working order?
Not all the time.
Okay. And so since you work there, can you tell me where the cameras are located?
I don't know where all of them are located. I just know where a few are.
Okay, go ahead and tell me where the few that you remember are located.
The entrance and the front door.
Okay.
By one of the bars and outside.
Okay. Have you reviewed any footage in preparation for your testimony?
No.
So if there's a camera by the bar, would that have captured you cutting Pablo off?
No,
And why is that?
because I'm in the back bar.
Okay, so you're saying there's no camera by where you're at?
No.
Okay. Would it surprise you to know that the defendant, when asked to provide video footage for this case, stated that the internet had been down on the night of the offense?
Can you ask that again?
I'm gonna object. This is misleading. I mean, I think they've already been testimony that Mr. Rendon provided video to the state, and the state has actually already admitted that into evidence. So I think that question is trying to mislead the jury.
All right, that'll be overruled. You can ask the question.
Were you aware that when the defendant was initially asked to provide video footage of what happened in Volcan that night, he stated that he wouldn't be able to do that because the internet was down on that night?
Yes.
It would surprise you?
No, it usually goes down. We have a lot of internet issues.
Okay. Now, there has been some footage entered, and would it surprise you that other people that were in the bar were walking out and were stumbly and had red eyes and had the same descriptors that you described earlier?
No.
No, so usually people that go there, they drink to a level of where they're swaying and.
No, we cut them off before then.
Okay, so if there's people that are on the surveillance video stumbling out and have red eyes and stuff, that's a surprise to you?
Yes.
Okay, so you're saying about how many people did you cut off the night of the offense?
Just Pablo and one other person.
Okay, and on any other nights, how many people would you typically cut off?
A lot of people usually handle their liquor, so I don't have to cut them off very often.
Okay. Do you know what the legal definition of intoxication is?
Yeah, objection relevance.
That'll be overruled. You can answer either yes or no.
Yes.
What is it?
They're tumbling, they're slurring their words, they have red eyes, they're just, sometimes they get angry, sometimes they don't.
Okay, and is that, I guess, what you found in your training and experience?
Yes.
Okay. Will you pass the witness, Your Honor?
I have nothing further for this witness.
All right, is this witness excused or subject to recall?
Excused from the defense.
Excuse.
All right, the rule that's been invoked, you're not allowed to discuss your testimony with anyone except for attorneys for the state of defense. If you remove your microphone. All right. All right.
All right, this time the defense called Chris Villanueva. Let him stand.
If you'll have a seat here, please, sir. All right, and there's a tiny microphone that's up there, it's square. If you put that on your shirt somewhere. Yes. All right, can you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you keep your voice up so that members of the jury can hear. If you'll state your name for the record, please.
Chris Villanueva.
All right, you may proceed.
Thank you. Chris, I want to, first of all, let me ask you this. Did you work last night?
Yes, sir.
What's your shift that you worked last night?
Third shift. I work overnights.
Okay, and what time does third shift start?
I started at 11 p.m. I got off at 6 o'clock this morning.
Okay. And so this would be a time that you would normally be sleeping. Is that accurate?
Yes.
And where do you work at, Chris?
Retired right now at IFCO.
And what do you do for them?
I do labor work, load. It's a warehouse. I do loading, unloading.
Okay, and how long have you been there?
Like a few weeks, month.
Okay.
Maybe.
And did you used to work at El Volcan?
Yes, sir.
And how long did you work there?
Since 2021.
Okay. And how many shifts would you do there per week on an average?
Well, it changed from time to time.
Okay.
Like, there was a time when I was full-time worker, and then there was a time when I was just worked the weekend. That was it.
Okay. And what about in August of 2023? What were your general working hours during that time?
Definitely worked the weekend. I for sure always caught every weekend. Every Saturday was the main day. That there was a lot of people and there we had to go.
Okay.
All the employees had to be there.
And what was your general duties there when you were working there in August of 2023?
I was a parking attendant, and after I closed down parking, I would go inside and I would do portering.
Okay. And what does a porter do?
I pick up empty bottles and throw them away, or once it's past time for there to be no more alcohol, we'll go and tell people it's time to throw their alcohol away, and
Okay.
and
So there's like several porters doing that at a last call. So there's you and other porters that are actually going out to collect the alcohol.
If we have some hired at the time, yes, or security will go around also to help us.
And I want to turn your attention back to the night was August 19th and into the early mornings of August 20th, but we're really talking about the early hours of August 20th. So like around 2 o'clock in the morning at last call. On that day, what were you doing in the bar? You'd already finished your parking, correct? And you had gone in to begin doing the porter work. And tell me about last call on that day when the fight broke out.
I was going around and with the security officer, with Anthony, and we were throwing away empty bottles and telling people that it was time to throw their alcohol drinks away, and people would have to throw it away.
Okay. And at some point, did you become aware of a disturbance that occurred?
Yes, Anthony told a security guard. He told one guy that it was past time for his drink and he had to throw it away, and then he refused, and he jerked back away, and Anthony tried to reach for it, and then they began to argue over the drink, and then they began tussling over it.
Was Anthony called over there, or was he there when they first to get the drink from the gentleman?
No, we were walking together
Okay.
to go around, throw away drinks. So he was already there. He was just another person that were telling that it was past time to, and they needed to throw their drinks away.
And at some point, did they get in kind of a tug of war over the drink?
Yes, and then it led to the dance floor, like deeper into the dance floor, and then the guy's friends went and they all jumped on Anthony.
Okay. And to be fair, you didn't know who this person was. You didn't know his name or who this person was that was not giving up their beer. Is that fair to say?
No,
And
I don't know him.
if his name is Pablo Rodriguez, if he testified that he had one extra drink and threw it away, is that accurate?
No, he didn't throw it away because he was fighting with Anthony, the security guard, over the drink.
Okay. And at some point when he started to struggle with Anthony over the drink, what happened after that? I mean, what did that man do after that?
They started struggling over the drink and they led deeper into the dance floor. And then they went around some people. And so I couldn't really see right away. But then the guy's friends went to go help. But once I did get around the people, because there's usually a lot of people in there, so it's hard to get around or see very well. But once I got around the people and I saw them, I saw all I could see was Anthony's legs sticking out, and he had 3 guys on top of him.
Okay. So Anthony was on the ground and there were 3 men on top of him. Is that correct?
Yes, sir.
And at that time, do you know if Anthony had a gun on him?
Yeah, he carries a gun. He's a security guard that carries a gun.
And did you feel it was a dangerous situation for Anthony, who's armed, to be on the ground with 3 men on top of him?
Objection, speculation, Your Honor.
Sustained.
Well, I mean, he can talk if that was one of his concerns. Was it one of your concerns?
Objection, speculation, Your Honor.
No, it's his personal feelings.
The objection will be overruled.
Did you have concern about that?
About him being on the ground.
With the gun? Yeah.
With the gun. Just him being on the ground with 3 guys on top of him, I had a lot of concern for him, just his safety and everything, yeah.
And these 3 guys, what were they doing to Anthony?
I couldn't really see what they were doing to him because they were on top of him. All I could see was his legs sticking out. So
okay,
I went over there to try to help him.
And what did you do to try to help him?
I was trying to get that guy's friends back, and I was trying to keep them back, and I was trying to let Anthony, the security guard, and that one guy have their one-on-one rather than him having all these people jump on him.
Okay.
So I was trying to keep that guy's friends all back from.
Were you able to do that?
I was trying, and me and my coworker, we were both trying to keep them back, but they kept pushing through us and going around us and jumping on Anthony once again and all teaming up on him. And this went on for a while.
It went on for quite a while.
Yeah.
And then there was a female involved as well. Can you tell me what she was doing?
She wasn't jumping on Anthony at that time, at least that I saw, but she was she was trying to push us because we're trying to keep the other guys back. So she was pushing us and yelling, and she was yelling at us and stuff.
And she laid hands on you?
Yeah, she pushed me a few times. Okay. Because I was trying to keep the other guys back away. But I didn't touch her at all. I just let her push me. I was mainly focused on the men, but I mean, I am a small guy. I'm only 130 pounds, so I can, people can push me around.
And who was your coworker that was trying to help keep these people off of Anthony?
My coworker was Calvin. He was also another porter, and we were both trying to keep the guy's friend back.
At some time, did you see that Calvin had gotten knocked down?
I didn't see him get knocked down, but he was trying to help. But at one time, eventually he did get hurt, and he couldn't help anymore.
Okay, and then just kind of on a scale, okay? So when we're talking about this fight that's going on, Okay. 10 is full WWE melee where, it's just carnage. Everybody's fighting like crazy. It's life or death struggle. And 1 is just a little touch. Where are we at in this spectrum in the intensity of this fight that was going on?
It was like a wrestling match, they were going at it. They were wrestling back and forth. They were on the ground, back up to their feet, back on the ground. They were all jumping on Anthony, the security guard again. And then, we were trying to help him and he'll get back to his feet. And then they were all jumping on him again.
And would you consider this an intense fight that was going on?
I mean, they were all teaming up on him, so I thought it was definitely wasn't fair. So that's why I was trying to keep the guy's friends back and let him just have his one-on-one with the main guy.
And were you concerned for Anthony's safety?
Yes, especially when he had, the times when we couldn't help him because they were overpowering us and they were all just on top of him or just like, dragging him around or whatever, slamming him and stuff.
Were you concerned for your safety?
Well, kind of. I thought maybe they would start trying to hit me or something. I was concerned for my safety, but they were mostly focused on Anthony. It seemed like for some reason they were just kept trying to go after him.
And at some point, JR comes over to help. Is that correct?
Yes.
And tell me, what does JR do that you saw?
Later on in the fight, my coworker, Calvin was hurt. I was tired, and once again, Anthony was on the floor, and he had all 3 of the guys on top of him, and I was looking around for help because none of the other security guards had came yet, and then that's when JR and another security guard showed up, and they got the guy, and they picked him up, and the guy's friends, when they showed up, the guy's friends backed off, and they got the main guy, and they picked him up, and the security guard walked him out.
Okay. And so, did you believe that JR's purpose was trying to stop this fight from occurring?
Check speculation,
Sustained.
Yes, definitely.
Excuse me.
That's fine.
I sustained the objection. You're not allowed to answer.
Yeah, if there's ever an objection, if one of us says objection, just wait, and then she'll make a ruling, and then if we're allowed to ask a question, we'll just ask it again. Okay. And after the fight, did you see that Anthony was injured at all?
Yes, he was pretty injured and exhausted, and he had been back and forth, hitting the floor, and he said one of the guys had a.
Don't tell me what someone else said, okay? We can't talk about what other people say. That's what we call hearsay. So you don't need to say that.
Well, he had his hat and his baton and his radio missing, so we were trying to help him find this stuff afterwards.
Were you able to find any of his stuff?
No, didn't find none of his stuff.
And did you see who ripped his radio off?
I saw him at one point during the whole wrestling match having a tug of war over his radio with the main guy that he first asked to throw the drink away.
And what about Calvin? Did you see that Calvin was injured after the fight?
Yes, he was.
Can you describe what injuries Calvin had?
I'm not too sure exactly.
Okay.
I just know that he said he was hurt.
Okay. And it was clear to you that from observing him that he was in pain?
Yeah, I think his back or his shoulder or something like that.
I'll pass the witness.
Great state.
Thank you, Your Honor. And I'm sorry, I didn't catch your full name. Was it Christopher Villanueva?
Christopher Villanueva.
Okay. And what's your date of birth, sir?
It's May 25, 87.
And I'm sorry, can you just move that microphone a little bit closer, if you don't mind? I'm sort of hard to hear, so if you don't mind, if you just gonna, this one right here. Yeah, so you can move it closer to you if you like. That way I can hear. Now you stated, I think earlier that you worked at Joe's Volcano for a number of years, is that correct?
Since 2021.
2021? And so you know Moreno Rendon,
Yes, sir.
JR. You just have to answer out loud, sir, sorry.
Oh, yes, sir. Sorry.
And I mean, you worked for him that whole time, is that right?
Yes, sir. For him and Esmeralda and the family.
His wife, right?
Yes.
Okay. And they're the ones that run Joe's Volcano. Since then, it's closed down about a month ago, we heard, is that right?
Yes, I was working there up until March, the end of March, I believe. Yeah.
And we heard also with testimony that it's gonna reopen at Randy's Ballroom, right?
Possibly. I don't know all the facts of everything.
sorry?
But I don't know like all the facts on that and everything, but I'm hoping so. You know.
You're hoping so?
Hopefully. I don't know.
I mean, because you would probably go work there again.
Possibly.
And so let's talk about this night. I mean, Mr. Lucas was asking you some questions about, like, say, injuries. And in the description you gave of this fight of up and down, and then you spoke about three guys on top of Anthony. And how were they on top of it? Like, they were all like packed on top of each other? Like, or some on his head, some on his feet? How were they on top of him?
Yeah, like on the side, the head, you know, the shoulder, like all I could see is legs. And the first time that they were all on top of him, but it happened, you know, several times, you know, as it went on. You know.
And so, I mean, this was, as you said, and tell me if I'm wrong, this was an intense fight.
Well, it was a wrestling match, I would say mostly.
Wrestling mostly? So
There
there was no punching.
I didn't see punching, but
So this whole time you're there, and you're there from the beginning of this fight to the end of the fight, you saw no punching.
well, there was times when they were all on top of him. I couldn't see what they were doing to him, you know. And there was times that they were all on top of him, and I couldn't see what they were doing to him. So I was really worried about his safety and what they were doing to him. And I heard that he got punched, you know.
You heard that?
Well, that's what he said, but
Who said that?
Anthony said that they
Anthony
punched
said that.
him.
I mean, you spoke to Anthony after this fight, right?
Yes.
You
well,
spoke to Anthony recently, haven't you?
No, not well. Right after the fight happened, I was helping him look for his stuff.
So you talked to him right after, then you never talked to him again?
Well, yeah, he worked there still for a while, and I talked to him a little bit, you know.
Okay.
But you know, right after the everything happened, I was helping him look for his stuff, and he was exhausted, he was tired, he was hurt, and you know, from hitting the floor so many times and people pushing him and pulling him and getting on top of him and, you know, grabbing him, all this stuff. And he had said that, you know, he got punched in the face and also, so.
So wait, you just said he got punched in the face?
That's what Anthony said.
Okay, but again, you didn't see any punching the whole time?
I didn't see it.
Okay, you just heard that from somebody else?
It was more like from what I saw, it looked more like a big wrestling match. You know?
So just a wrestling match you saw. Now, and you testified that you're fearful of his safety, is that right?
Yeah, well, yes, when you have three guys on top of you and he was laid flat on the floor and all I could see his legs, so, you know, I was worried about what they were doing to him, what was happening.
try to help out, but you said you're a small guy, you're about my size, not that big, right?
I'm not very big. I'm 130 pounds.
Yeah. Probably a little heavier, but the fact is that you stood by and watched the whole thing happen, though, right?
I was trying to keep the guys' friends away, but they kept powering through, you know, and I tried, you know, but they kept, you know, powering through and getting around me and continue to jump on Anthony, the security guard.
All these guys are just beating on and jumping on and wrestling and tugging and pushing Anthony the whole time. We got that. That's what your testimony would be, right? Is that correct?
Say it again.
All these guys, three, was there more than three? Was there five? How many?
What I remember is 3 guys and 1 girl. That's from what I remember, but
Okay, so
I
three
mean,
guys and one girl.
there was a lot of people around, you know.
So there's a lot of people around.
Well, there's
Can we-
it's a
can we
club, there's a
approach
lot of
briefly?
people in the club, you know.
Yes.
I guess let me just I want to clarify this. So you're saying 3 guys and a girl were involved in this, and that's it.
From what I remember.
What you remember. And look, all I want is what you remember, okay?
Yes,
Not what
sir.
somebody else told you, but what you remember. Because, I mean, to be fair, you spoke with Anthony Cochran, which is the security guard, after this happened, right?
A little bit.
Okay, and then you also spoke with Mariano Rondon, the defendant in this case, about this after it happened, right?
Well, I kept working there, but we didn't speak too much about it. Like, you know, I would only see him at work, you know, and then we were always real busy at work.
Okay, so I guess my question is, you never spoke to JR about this incident at all?
Little bit, but not like a lot, not really. I didn't even know that there was still like this was still an issue. I mean, it happened so long ago, you know.
Okay,
I don't.
all right. So through all this incident that happens, is what we call, let's just call it a fight. You state that you were standing there, at least trying to help, or at least watching everything that happened.
I was trying to keep the guys' friends back.
But off of Anthony, right?
Yes.
So you, during this whole fight, you were focused on Anthony. Is that correct?
I was trying to keep that guy's friends back.
And I understand that, sir. I'm not trying to put words in your mouth.
That's what me and my coworker were doing, just trying to keep the guys' friends back as much as we could. But, you know, there was times we were able to a little bit, but there was times they got through us, you know, and it wasn't until, you know, later on that JR and another security guard came to help. And you know, I felt very relieved because I was very worried about, you know, Anthony and what was going to happen to him, or, you know.
Okay. Okay. And you say this went on for a while. Is that correct?
Yes, sir.
How long? Like 5 minutes?
I don't know. I don't know how long. It just went on for a while, you know.
So you don't know a time limit?
I'm not sure.
I'm sorry, you just have to answer out loud for the court reporter, okay?
I don't know exact time limit, sir. I just know it went on for a good while to where I was tired, you know, and trying to hold people back and, you know.
And so, again, my question simply is, during this whole time that this fight is happening, you're focused on Anthony because you were worried about his safety.
I was worried about Anthony's safety.
So that's a yes?
I was worried about Anthony's safety, but also worried about, I guess, everybody else's safety. if they got a hold of his gun or something, because he did have a gun on him. You know, and he was a security guard and he was only by himself, you know. And I was wondering where all the rest of the security guards were, you know, and why he was by himself having, you know, all these guys, you know, team up on him.
Okay, so when you saw JR arrive, that's your boss, right?
It's my boss, yes, sir.
Is that correct?
Yes, sir.
And when he arrives, he starts pushing people around, is that right?
No, he just went, him and the security guard went and they got the guy and they picked him up, but the guy's friends backed off once they came. So they just got that one guy and picked him up, and then the security guard walked him out.
So again, you're watching JR there, and they get all the friends back, the other security guards there, Anthony's there. Is this when Anthony is on top of that guy?
Anthony was on the floor and he had 3 guys on top of him when JR showed up with the other security guard.
Okay, let's talk about right after that.
Me and my coworker were standing there looking around for help. My coworker's hurt, you know, I was tired, you know, we were looking around for help, and you know, Anthony's on the floor. He's got 3 guys on top of him. That's when JR and another security guard show up.
Okay, and I'm not gonna interrupt you anymore. But what I'm gonna ask you is, if you just answer my question, okay? My question is, after the 3 guys that you say were on top of Anthony were removed, they were taken off, right? And pushed to the side, is that right?
No, well, when JR and security guard came, they got the guy, the main guy, and the guy's friends backed off. When they saw JR and security guard show up, the guy's friends, they backed up.
Backed away. Where was that guy?
The guys, at least. The girl, she wanted to argue and yell at everybody and stuff. And then the guys, they came back too, I believe, and started arguing too and stuff. So they backed up for a second, but then they came back to argue and this and that, you know.
Again, when the people were backed off, where was Anthony?
Well, he had 3 guys on top of him, and JR showed up, got the one guy to pick him up, and then that's when the guy's friends started to back off, and then Anthony was getting back to his feet.
Okay, so when JR shows up, people back off. They pick up the guy right away and escort him out.
He showed up, JR showed up with another security guard, and they picked the guy up, and the security guard walked him out.
And you stood there the whole time and watched all that.
Yes.
So when was it that you saw this man over here use both knees and jump into the man on the ground's stomach? When did you see that?
I didn't see
I
that.
didn't see that, but you were there the whole time.
I was there, but I mean, can only, you know, see so much. I don't know.
Okay, I'm
I
gonna show you
didn't,
what's
I didn't,
I'm
I
gonna show you
didn't.
what's Mark State Exhibit number 2. And that's what can you look into the big screen up there? It might be easier for you to see. I know that one has a glare down there. This is already in evidence. I'm gonna go ahead and play it for you, okay? Okay, where are you at?
I don't know. I can't even barely see what's going on in there.
I'm sorry, you gotta speak up and.
I don't know. I can't barely see what's going on in there.
Okay, Your Honor, we may have to, I'm gonna play it again for him since. We're gonna play it one more time for you, sir. Go ahead and take a look at it. Who's on the ground?
It's probably Anthony and the guy.
Where are the other people?
Well, where's the rest of the video?
Well, I'll play the rest of the
Like,
video, but I'm
no,
just asking
well,
you.
all the video, everything that happened before that.
This is the only video we have. Is there other videos?
Well, why wouldn't y'all show the whole video of when they were all jumping on him before?
Have you seen that video?
Well, obviously they're not showing it.
No, I'm asking you. Have you seen that video?
It would be before this.
I'm asking you. Have you seen a video of everybody
I
jumping on
haven't
him?
seen any videos.
Sorry?
I haven't seen any videos.
You haven't seen
This is
any
my
videos?
first time watching this.
Okay. Where are you at? Where are you standing at when this is going on?
I'm not sure, sir. I can't really see everybody that's there, but I'm sure I'm around there, standing around
Okay.
somewhere.
We'll go ahead and play the rest of it for you, okay? Who's that to the right?
Okay,
I'm sorry?
that's probably me, but you can't really tell.
It's probably you.
Can't really see who it is or anybody is really.
But that's what you were wearing that night, is that right?
Possibly.
Possibly. What's in Mark State Exhibit number 21? Who's that?
Your Honor, can I just move so I can see what
Sure.
they're showing?
Who's this record?
It looks like me. But if I didn't see everything that happened, like I didn't see what you're trying to tell me that I saw. I mean, if I didn't see it, I didn't see it, I'm telling you what I saw and what I didn't see.
But that's you standing in the video in State Exhibit number 2, isn't that correct?
Probably. You can't tell, you can't see who that is in the video.
And you stated after this, oh, Judge, we're gonna ask that enter State Exhibit number 21, Senator Defense.
No objection.
All right, State's Exhibit number 21 is admitted without objection.
Hey, I just publish it, I'll hand it to you.
Well, can I see what you're showing?
Yes. State Exhibit number 21, yes, sir.
Just in the entrance door or the exit door?
That's correct. In fact, this is the entrance of,
Standing. That's the entrance, the exit, they're right next to each other.
right, of Joe's Volcano that night.
Okay.
You have your arm outreached. Why do you have your arm outreached? Do you know?
Huh? I'm probably opening the door for somebody. I don't know.
What if I asked you, well, let me ask you this. Did you hand anything back to Anthony Cochran?
And anything to him?
You didn't hand his badge back to him?
Not that I remember.
Now, did you talk to Anthony like you stated previously?
Not previously. I mean, not recently.
Not recently, but that night, you said that he was really just worn out or something after this fight. Is that right?
He was worn out.
Yes.
He was tired. He was hurt.
And you stated that you try to help him find stuff. Is that right? Like his radio, because you said that his radio was being tugged on. And the tug of war was over his radio also. Do you remember that?
I said that at one point I seen him having a tug of war over his radio with
Right.
the guy, with the main guy. And after the end of everything, not only me but everybody, the coworkers, we were all trying to help Anthony find his stuff.
Okay.
He was missing a baton, he was missing his radio, and he was missing his hat, his own personal like a cowboy hat. I guess it was expensive, I'm not sure, but he seemed pretty upset about it.
So do you remember finding something of his or giving it back to him? Because earlier you said you didn't find anything.
I don't remember. Where's Anthony? Is that
I'm just asking you, is that you?
Again, I moved it. See the exhibit?
Yes, you can move around.
well, why don't you show everybody what you're showing me?
I'm asking you, is that you?
Well, I
Yes or
think
no?
you should show everybody what you're showing me.
Just asking, is this you?
It's just a person standing there at the exit door with their hand out holding something. But whether I was given that, I don't know who was given that.
If you can just answer my question, is that you?
Well, I think you should show it to everybody.
Again, I'll try to ask one more time. Is this you?
Well, show everybody what you want me to tell.
Judge Kim.
Yes, excuse me, sir. Questions are being asked. You need to answer the question. Do you understand?
I understand.
Do you understand the last question?
I understand it's
All right, ask your question again and you will answer the question. Do you understand?
just this
On
person
this- on-
standing there holding something
Is
at the
that
exit door.
you?
It looks like me.
That's good enough. Here, I'm gonna play this video for you.
Okay,
Pause this video
but does that mean that, what does that mean? That I don't know what time that was. I mean, when I was giving that to him.
All right,
don't
ladies and gentlemen, I'm gonna have you step outside just for a few minutes and I'll just have you in the hallway. Please remember my previous instructions.
Hang on a second.
All right, everyone, please be seated. All right, I'm going to explain something to you and I want you to internalize what I'm saying and listen to what I'm saying. Do you understand?
Okay.
You need to say yes or no. Do you understand?
You want me to listen to you?
Yes.
Yes.
All right. So this is the way the legal process works. Sometimes maybe people don't understand the legal process because maybe this is your first time being a witness. I don't know. But this is what's going to end up happening. The defense will ask you questions. You will answer his questions. That's Mr. Bloomquist. The state is currently asking you questions. That's Mr. Garehand. You're going to listen to the question and you're going to answer the question that's asked of you. Do you understand? There is not to be any of this, well, why don't you show the jury? Well, why don't you do that? Because that question has not been asked of you. Do you understand? So you're going to answer the questions that are asked of you. Do you understand?
Okay.
All right, let's bring the jurors back in. All right, so we're going to take 5 minutes, everyone.
Thanks, Judge.
You're welcome. All right, everyone, please be seated. State, you may proceed.
Thank you, Jay.
Yeah, that's fine.
I'm gonna show you a small portion of this. And I'll again ask you, one, is this you?
Okay, it looks like he's handing Anthony a badge, but I don't know what day this is. I don't know what time this is. I mean, you're showing me a video. I mean, I was there like almost 4 years, and this could be any time.
Okay.
I don't know where you're getting this video.
You're
I don't
saying
know.
that you don't know if this is the night that this incident happened. Is that what you're saying?
This is an entrance, this is the video of the entrance door,
Okay. But
of the
your-
exit
Your
entrance.
testimony is you don't know if this is the
I
night.
don't
that it
know,
happened.
I don't know what this video, this is the same video, I don't know. From the same day or the same night, I don't know. But what does it matter if I'm handing him a badge? I mean, what is that
Excuse me,
supposed
sir.
to?
Yeah, just responding, please.
I guess
Are to listen to the questions that are being asked of you and answer those questions. Do you understand? You may proceed.
the reason I'm asking you that question is that you stated in early testimony that Anthony Cochran had lost several items and none of these items were returned to him and you couldn't find any of those items. That's why I'm asking you that question, sir.
I
But
said,
in this video, you are handing him a badge to Anthony Cochran on the doorstep of the exit of Joe's Volcano. Is that accurate?
I said he lost a hat, baton, and a radio that we were looking for. A badge, I don't remember a badge, but it's possible. I mean, it could have been his badge too. I don't know. I mean, it wasn't a main thing that I remember looking for, The main thing I remember looking for was his hat, his baton, and his radio.
Now let's, in reference to state exhibit number 2, the video that we have watched and the jury, it's in evidence. That is you standing there watching everything unfold. Is that correct?
I don't know. Can't see who that is in that video.
Who else would that be?
I don't know. There's a lot of people in that club.
We're gonna play state exhibit number 2. Is that, sir?
I don't know.
You don't know what that is?
No, sir.
It looks like a hat, doesn't it?
Possibly. Could be anybody's hat. A lot of people wear hats in there.
So was it a hat or not a hat?
Possibly. I don't know. I can't tell what it is.
And what's next to the hat? It looks like a radio to me. What does it look like to
Again,
you?
objection, objection, he's calls for speculation. He's testified he doesn't know.
All right, with regards to that objection, it will be overruled.
Does that look like a radio to you or not?
I don't know.
Person's still on the ground, is that right?
I don't know. I can't see.
Can't see it. I mean, but you said that when JR got there, Everybody moved back. They picked up the guy and took him straight outside. Is that right?
Say it again.
You're saying that when JL got there with the other security guards, everybody got moved back. Anthony and the other security guards picked the guy up and they walked him outside. That's what your testimony was. Is that
I
correct?
said when JR got there with another security guard, that Anthony was on the floor, had 3 guys on top of him. This is not a video of when JR first got there. This is already a little bit after. That's what I'm saying. Where's the rest of the video? And where's all the video that's of when they were all jumping on Anthony? And you know, they edited the video. They're only showing you the end part.
So when JR got there, you're there, right?
When JR got there with the security guard, Anthony was on the floor with 3 guys on top of him. That I remember
Okay,
that correctly.
so you're there when JR arrives. You stay at this incident, this fight. You're watching it the whole time. Correct?
I'm an objection asked and answered.
Overruled.
You can answer the question, sir.
I was there with Anthony when it started, and I was there to the end, but I mean I didn't see everything. I mean there's a lot of people. I mean, and plus I was trying to keep the guy's friends back from jumping on Anthony, so I mean I didn't want to turn my back to them. So there's a lot of things I saw, a lot of things I missed. I can't see everything.
I agree with that, and I understand that, and I'm not trying to make you see everything. I'm just trying to find out for this jury what you actually saw.
I'm telling you what I
Because
saw.
you testified earlier that somebody told you there was a punch, but you didn't see any punches. And then also, you're talking about people jumping on people, but in this video, you only see one person jump on anybody. You saw JR jump with both knees into the victim's stomach. Did you see that on that video?
I'm telling you, this is not the rest of the video. There's a lot of video that's before this that you're not showing.
Thank you for that. However, I'm asking you a different question. Did you see JR with his knees jump into the victim's stomach? Yes or no, sir?
I didn't
Just a yes or
see
no.
I didn't see nobody knee anybody or anybody hit anybody.
State exhibit number 2. Watch it one more time, sir. Please just watch it and tell me if you see JR with his knees into the victim's
I'm telling
stomach.
you what I saw that night.
I'm asking you
I'm not.
asking you if you see it on the video.
Why do I need to watch a video when I was there
I
that night?
object, Your Honor. Whether what he sees in the video speaks for himself. He's testifying about what he saw that night. What he sees in the video, what anybody sees in the video speaks for itself.
All right, that objection is overruled.
We're gonna play state exhibit number 2 for you one more time, sir. Please pay attention here. Okay. Question is, did you see JR with both his knees go into the stomach of that person laying on the ground? Yes or no, sir?
I'm telling you what I saw that night, and I didn't see nobody knee anybody. And that's what I'm sticking to. So I'm only telling you what I saw that night,
I understand. Thank you.
not what I seen anywhere else. What is this?
I'm asking you to look at it, sir. This is you, correct? This is a judgment on your case where you were convicted. You recall that?
What do I have to do with anything?
I'm just asking you, were you convicted of an aggravated assault with a deadly weapon? That happened in 2010, and you were convicted
2010.
right here, sir. The offense date is May 27th, 2010. And you were convicted on January 30th, 2012? Do you recall that?
Of an assault.
Aggravated assault with a deadly weapon.
I think they dropped the weapon or the ag or something. It was, I don't know.
You see what it says on here, is that correct?
But I do have an assault charge from 2010, but I mean,
And-
so what?
Did you serve time for that, sir?
I served time.
How many years?
I did 4 years and I got out on parole. And I completed my parole and I,
That is correct.
you know, I
You are a convicted felon, is that right?
from a long time ago. It's been what, 15 years? I don't know.
And let me ask you, sir. The radio tug of war that you stated, that didn't really happen, did it?
It's what I saw. I saw Anthony and the guy having a tug of war over his radio at one point.
So your testimony is there's a tug of war over a beer bottle, there's a tug of war over a radio, and that the security guard had a gun on him, but there was no tug of war over the gun, right?
Not that I saw.
Not that you saw. But you didn't see any person's hand on that gun, did you?
I didn't see that, but like I said, he's had 3 guys on top of him at one time. I couldn't see what they were doing to him.
But again, my question
And
is
I
that
didn't see everything. You know, anything could have happened that I missed, you know. I turned my back and a lot of times, you know, there was a lot of people in there.
And you stated that Anthony was, I mean, after this fight, you said, I mean, tell me if I'm wrong, that Anthony, was he hurt?
He seemed hurt.
Where at?
Well, he was tired and, you know, like limping a little bit. And he said he had been hit in the face, punched in the face.
He said that.
That's what he said.
Okay. But you talked to him that night. You saw him after the fight, right?
I saw him after everything,
And he was walking around.
walking around. He was
Walking obviously through the
exhausted, seemed
entrance of-
kind of hurt, but he was like, okay, I guess he was still alive. Everybody else still alive. Thank God.
So everybody's alive, thank God.
I don't know.
You're aware though, in this case, it's aggravated assault causing serious bodily injury of an individual. You're aware of the charges. Do you understand that?
I don't know everything about this case.
So you're not aware that the person that was kneed in the stomach had,
Objection relevance. He's here to testify about what he saw that night.
All right,
His
let me-
knowledge of everything
Let
else.
me
is-
hear the question and then I'll hear
All
your
right.
objection and make a ruling.
that an individual was kneed in the stomach and there was tears in his large intestines.
All right, so just one moment before you answer that.
Again, my objection is his knowledge of the case outside of what he saw that night is irrelevant.
All right, the objection will be sustained.
Did you see the named victim in this case after everything happened?
Can you say it again?
Did you see the person that was on the ground in this video? Did you see him after this fight, this incident?
The one that was fighting with Anthony?
Mm-hmm.
Did I see him after? Not really. I mean, I don't know. I just saw him, you know, get up, get walked out by the security guard, and I never saw him again after that. I don't know.
You never testified earlier that Anthony was ever on top of the person. You never testified to that.
Possibly, I don't know. There was it was a wrestling match that went on for quite a while. Sometimes you know, they were rolling around the floor and you know, I don't know. I mean,
Possibly.
I mean it you know, it's a wrestling match, you know, they're rolling around. I mean, sometimes one person might be on top, sometimes another person might be on top. But the thing is that it was 3 guys on 1 security guard, and you know, and it was really unfair, you know. It was unfair for Anthony.
Who is on top of that guy?
Can't see who that is, but this is at the end of the video. I mean, this is at the end of the incident.
So this is at the end, right? So. it looks-
Probably if JR is there, because
it's
JR
under control at
came
that time,
towards
is
the
that
end.
right?
Not, well, obviously it's still kind of going on a little bit.
Okay,
It's not all the way under control.
there's one guy on top of another guy in this video, is that right?
It's what it looks like.
You're standing there watching it, JR's there, right? Correct?
I'm around there. I don't know if I'm watching that exactly at that moment. I don't know. I could be looking somewhere else. I mean, I can't see everything.
I understand that. So, and then JR, this is when JR then knees the guy in the stomach, correct?
I don't know.
You don't know. You saw the video though, correct?
I'm only telling what I seen that night,
Okay.
and I didn't see anybody knee anybody.
We'll pass the witness, Your Honor.
All right.
And to be fair, this happened in August 20th of 2023. Is it your memory probably back in August of 2023 would have been better than it is today? Is that fair to say?
Yeah, so it was a long time ago.
Okay, may I approach?
Yes.
You did see Anthony that night, correct? Let me show some photos of Anthony. I'm gonna show you defendant's exhibit, what's been marked as defendant's exhibit 4 and 5. Do you recognize the person in the photograph?
That's Anthony.
Okay, and is that how Anthony appeared on the night of August 20th of 2023?
Yes, I remember he had said he got hit in the face. I remember his cheek was red, and I didn't see clearly everything that happened, but
But that appears to be the way that he looked when you saw him on that evening, correct?
yeah,
And that's an
he
accurate
had
representation of him.
he had a mark, and
All right. Your Honor, at this time, I'll tender defendant's exhibit 4 and 5 to the state and move to admit defendant's exhibit 4 and 5.
No objection from the state, Your Honor.
All right, states exhibit, I'm sorry, defense exhibits 4 and 5 are
May I
admitted.
publish to the jury, Your Honor?
Yes.
Now, you didn't see Anthony like remove any of his clothing or see some of the other injuries he may have had. Is that fair to say?
I didn't see him remove any clothing.
Okay. But it's possible he may have had other injuries that are underneath his clothing that you didn't see. Is that fair to say?
Yes, I'm sure possibly, and he would have probably had a few.
And I'll pass the witness at this time.
Hey, let's mark say exhibit number 23. Who's that? That's Anthony, correct?
Looks like Anthony.
Right?
It's half his face,
That looks like his face, right?
half his face,
Half his face. Where are the injuries?
his chest, and he covering his stomach. But that's only his front part. Could be some of his back. I don't know, or his shoulder.
There's another picture of Anthony, state exhibit number 24. Where's the injuries on his arm? You see some
I
injuries?
see little red marks, but I mean, not like a big injury. His elbow is pretty red,
And you
probably
testified,
from hitting the ground a few
Um,
times.
and you testified earlier that he would have several probably injuries underneath his clothing. So is this what you're talking about?
I said possibly. I mean, I don't know. I didn't see him remove his clothing that night.
Judge, we're off to state exhibit number 23 and 24, tender to defense for any objection.
I have no objection to those exhibits.
All right, states exhibit 23 and 24 are admitted without objection.
Published to the jury, Your Honor.
Yes.
You didn't see many injuries in this other videos,
Just marks,
smart, but injuries.
not like big injuries, but marks. But I mean, I'm not a doctor. I don't know. And I didn't check him that night.
Like for internal injuries, you don't know if there's any internal injuries, right?
I don't know how injured he was. I mean, you would have to ask him, or he would have to get checked out.
But he went to work after this. You saw him for months after this. Is that correct? You testified earlier that you did, so.
For I don't know how long, but he did continue work for a while afterwards. But I don't know. I mean, we mainly only worked 1 day a week, so he might have, you know, had the whole week to feel a little better to come back next Saturday. You know, I don't know. I can't remember exactly if he was there the following Saturday or maybe he missed one. I don't remember exactly.
He
But
wasn't in the hospital for 25 days, was he?
not that I know of, sir.
Okay, thank you. Fast witness, John.
May I approach?
Yes.
Any objection?
No. No objections. I'm sorry. I don't know what the exhibits are.
Judge, we're moving to admit defense exhibits 6, 7, and 8.
Any objections?
No objections, Your Honor.
All right, defense exhibits 6, 7, and 8
And who's
are
the person?
admitted without objection.
I'm sorry, Judge.
No problem.
I gotta let you do your business. I'm sorry. States exhibit 6, who's the person in that person? Or defendants exhibit 6, who's the person in that photograph?
Looks like Anthony.
Okay. And do you see a red mark on his chest?
Yes, and his stomach a little bit.
And the same, it's another version of the same photograph in defense exhibit 7. And I'm gonna show you his leg, he's lifted up his pant leg. in
His
December.
knee
His
or
knee.
something.
You see like a large red mark on his knee?
Yeah.
And that's kind of, may I publish to the jury, Your Honor?
Yes.
And that looks like somebody to you that's been in a fight, is that fair to say?
Yes.
Okay. The people that work at at El Volcan, do you guys have kind of like a uniform that you wear, or do you have like some clothing guidelines that you wear?
We have El Volcan shirts. Well, the security has their own uniform, and
Right.
you know, other people have
But
their shirts.
but pretty much everyone that works there, all the porters, they wear black shorts. Is that correct?
Um,
I mean, as
usually
far as
it-
the porters, let me just get to the porters. On the porters, what do they wear?
usually they're dressed in black.
Okay.
But I guess depending on if it's the season or whether they'll be in pants or shorts.
Okay. And usually they wear black pants or black shorts.
Usually.
I'll pass the witness. I have nothing further.
No further questions of this witness, Your Honor, but we would like to possible recall.
All right, the rule has been invoked. What that means is you're not allowed to discuss your testimony with anyone except for attorneys for the state of the defense. Make sure you're available if either party wishes to recall you. If you'll remove your microphone, please. All right, ladies and gentlemen, I'm gonna give you your lunch break now, and I'm gonna have you all back here at
Every day in the USA, people find themselves in court.
Good morning, everyone. This is the time set for the pretrial conference and plea docket. First case on docket today is State of Kansas versus Gene Taryn Ocelot. And Mr. Page, is your client there?
He is not with me. I'm actually at the Butler County Courthouse.
Okay.
I don't see him logged in, but I did send him the link a couple days ago.
Okay, we'll wait just a moment or two, then we'll take case up. Court takes a 5-minute recess for Mr. Pate to try to make contact with his client.
And Judge, just to note, Mr. Ocelot told me a couple weeks ago his phone was disconnected. I've been communicating with him by email, so I did just send him an email asking if he was going to log in or not.
And Mr. Pate?
No response from Mr.
Okay.
Ocelot.
We'll go on the record in regards to Mr. Pate's case. On the Zoom record, case is entitled State of Kansas versus Jane Taryn Ocelot, 23 CR 427. State of Kansas appears by Assistant Butler County Attorney Amber Norris. The defendant, Mr. Ocelot, does not appear. He does appear by court-appointed counsel Chris Pate. This matter does regularly come back before the court this date for pretrial conference plea docket. And announcements to the court, Mr. Pate.
Your Honor, I do also have a motion that I'd like to discuss, but as to Mr. Ocelot's non-appearance, he informed me about a week and a half ago his phone had been disconnected and said he could communicate by email. I'd had numerous ongoing email conversations with Mr. Ocelot in the last week and a half. He'd been very responsive. I sent him the Zoom link for this hearing, or the Zoom code and passcode. along with the proper time. I would note he is not logged in. I don't have any explanation for his non-appearance. So that's all I know at this point. As I said, I do have a motion I'd like to bring up after the court addresses the non-appearance.
Thank you, Mr. Pate. Court does order bond forfeiture bench warrant. Recommendation as far as bond, Ms. Norris.
Your Honor, I would ask the court to, I think kind of standard is to double the previously posted. And it looks like he's out on a $10,000 surety bond.
That's what it appears to the court. So the court does order $20,000 cash or surety bond. $20,000 cash or surety bond.
And for the record, Your Honor, would you note the defense is requesting a continuance of the pretrial and for the bond to not be forfeited?
Court does note the same. Court overrules the motion for continuance and for the bond to not be forfeited. Any other matters to come before the court?
Your Honor, I do have two motions on file. The motion for the subpoena can just be deferred because Mr. Ocelot is not here. I also filed a motion to withdraw. Obviously, the ethical rules prohibit me from getting into all the details of that. I would just say communication between Mr. Ocelot and I has devolved to the point where I don't think I can effectively represent him. It's not that we had not been communicating. There's been plenty of communication in the last couple of weeks. I don't think as to where the attorney-client relationship is presently that I can continue to effectively represent him. Would note, as the court is well aware, this is not something I request very often. I can think of maybe 3 cases in the last 10 years where I've asked to withdraw. I like to try and work through these things, but I don't think I can do it here. Given the fact the court issued a warrant and there's not going to be a trial next week, I don't think it would otherwise really delay the matter if the court was to allow me to withdraw and appoint substitute counsel.
Thank you, Mr. Pate and Ms. Norris.
State takes no position, Your Honor. I don't have any independent knowledge regarding the motion to withdraw.
In regards to Mr. Ocelot, it appears that Judge Satterfield recused herself from this case. It appears that Mr. Watts previously represented, Mr. Watts previously represented Mr. Ocelot, and subsequently Mr. Pate as replacement counsel for Mr. Watts. Is that all correct?
I believe so, Your Honor.
Yes, Your Honor. Judge Satterfield, I'm not sure that she actually agreed to recuse or if Judge Ricky did it, but it was at Mr. Ocelot's request because she had previously presided over a case, I think, or been the prosecutor on a case of Mr. Ocelot's years ago. And I believe Mr. Watts ended up having to conflict out. I'm not sure exactly the reason. It may have been something similar to what Mr. Pate is having to do today. And it looks like Jim is nodding his head. So I think they must have had some sort of a breakdown in communication or something like that. And so that's how Mr. Pate was then appointed. And that would have been back in around late October, early November of 24.
Thank you, Ms. Norris. It appears that Mr. Ocelot has a history of counsel being replaced periodically. The court, Mr. Pate, at this point in time, I'm not going to order your withdrawal on the case. I'm going to keep you on the case at this point, and we'll go from that point at this time. Anything further?
No, Your Honor.
So, Your Honor, are you denying the motion or are you just reserving judgment?
Reserving judgment. Well, let me go back just a moment, just to try to move forward with the case. Court will grant the motion of Mr. Pate to withdraw as counsel. I think at this point in time, the court will appoint Nika Cummings. Nika Cummings is appointed to represent Mr. Ocelot going forward. And once again, court does order bond forfeiture bench warrant, notes that the defendant has failed to appear. New bond is set at 20,000 cash or surety, with Nika Cummings appointed to represent Mr. Ocelot. There being anything further, Mr. Pate?
No, Your Honor, but thank you for letting me go first.
And Ms. Norris?
Nothing from the state, Your Honor. Thank you.
There being nothing further, court is in recess. Everyone have a good day.
You too.
And Mr. Dunn, your next case?
Judge, I hate to interrupt. It came to my attention.
Oh, Mr. Pate, excuse me.
I needed to put something back on the record on behalf of Mr. Ocelot. We were on a break in that termination hearing I'm in. It came to my attention that apparently I made a typo in one of the emails I sent to Mr. Ocelot and accidentally emailed him 10 a.m. So I needed to make the court aware of that.
Okay. So is Mr. Ocelot, has he appeared?
He's logged in.
Okay.
And
Mr. Ocelot, if you take yourself off of video and audio mute. Mr. Ocelot, if you take yourself off of video and okay, I can see you now, Mr. Ocelot. And Mr. Dunn, I'll be back with you in regards to your final case. I'm going to go ahead and go back to Mr. Ocelot and Mr. Pate. I'll need to pull the file just a moment. And proposed announcement to the court regarding Mr. Ocelot, Mr. Pate.
Your Honor, we appeared at 9 to about 9:15. Mr. Ocelot did not appear. The court granted a motion withdrawing me as counsel and appointing Ms. Cummings. The court also issued a bond forfeiture bench warrant for Mr. Ocelot. I got a message from Ms. Norris probably about 45 minutes ago, stating that Mr. Ocelot had logged in and was saying that I gave him a different time. And then I went back through my sent emails and verified apparently I did make a typo in an email I sent Mr. Ocelot a few days ago. where it said show up at 10 a.m. rather than 9. So I'm basically here to vouch for Mr. Ocelot that it's probably my fault that he showed up late, basically.
All right, thank you, Mr. Pate. The court will go back on the Zoom record. Case is entitled State of Kansas versus Gene Taryn Ocelot. Case number 23 CR 427. State of Kansas appears by Assistant Butler County Attorney Amber Norris. The defendant, Mr. Ocelot, appears at this time in person. Also appearing at this time is former counsel Chris Pate. This matter does regularly come back before the court this date on the pretrial conference plea docket. Before going on the Zoom record, Mr. Pate has advised the court that a typographical error was made in an email sent by Mr. Pate to Mr. Ocelot, advising Mr. Ocelot to appear at 10 a.m. this morning. Therefore, the court does grant the motion of the defendant to reinstate his bond, and that bond would be reinstated at $10,000 cash or surety. That is a reinstated bond at $10,000 cash or surety. The court has previously granted Mr. Pate's motion to withdraw as your counsel, Mr. Ocelot, stating Mr. Pate has a conflict with you in regards to representation. Subsequently, the court has ordered Nika Cummings. Nika Cummings is appointed as subsequent counsel to represent you. And subsequently, the court does schedule this matter back on the court's docket, at the pretrial conference plea docket for June. That is for June.
Your Honor.
Yes.
Are you planning to set this back on a pretrial with subpoenas for a jury trial the following week, or would the court actually set it maybe on a PHC docket so Ms. Cummings could actually meet with defendant, get discovery, and then maybe I don't know what she's going to want to do, but I just want to confirm that I need to redo subpoenas.
All right.
Wherever
For
the court sets
purposes of, excuse me?
Wherever the court sets it, I just want to make sure if we need to redo subpoenas or wait or.
The court does advise counsel that the pretrial conference plea hearing date on June 13, any matters that are set for the following week for a jury trial are subordinated to Greenwood and Elk County jury trials for Division 2. So with that being said, the court finds that the reissuance of subpoenas for trial date the following week, in this case, is not necessary. The court does find that Ms. Cummings will need some time to study Mr. Ocelot's case, review the same, and before proceeding, the court would use that pretrial conference plea docket date for scheduling purposes or for plea purposes. Mr. Ocelot, can you hear me?
Yes, Your Honor.
Did you understand what the court just advised on the record?
Yes, Your Honor.
Your new attorney is Nika Cummings. Nika Cummings is your new attorney. The court did grant Mr. Pate's motion to withdraw. The court's next obligation upon you is to appear by Zoom process on Friday, June 13, 2025 at 9 a.m. June 13, 2025 at 9 a.m. That is for the pretrial conference plea docket, where you will announce the case for trial or whether this case would be disposed of in some other means or manner. I have advised the state to not reissue subpoenas for the following week because the Butler County jury trial with myself is subordinated to Greenwood and Elk County cases. And also there are other Butler County cases that would be prime to your case. And in fairness to your newly appointed counsel, Nika Cummings, the court would wish to confer with her as to how and what date and time she would like to proceed. Do you have any questions about what your next obligation is?
No, Your Honor, I have no questions about my obligation. I just would like to know what firm she's in so I could contact her, make sure she has my current information.
Her firm is Cummings and Cummings, Cummings, located in Wichita, Kansas.
Thank you, Your Honor.
Yes, sir. Anything further to come before the court, Ms. Norris
No, Your Honor, thank you.
and Mr. Pate?
No, Your Honor, thank you.
Mr. Pate, thank you for your service to the court. Please prepare your statement for services rendered, and the court anticipates approving the same.
Thank you, Your Honor.
Court is in recess. Mr. Ocelot, you've met your obligation to the court today. You're free to go. Have a good
Thank
day.
You too, Your Honor.
Ms. Horwath, good morning. I was not, you were not the individual I was expecting.
Well, nice to see you too.
No, it's a pleasant surprise. I was expecting Mr. Reardon or one of the other usual defense counsels. Who is that you have with you at this time?
This is Giovanni Rosales.
Este es el señor Giovanni Rosales.
And Madam Interpreter, I'm going to ask that you begin by identifying yourself for the record.
Soy Mariana Heredia Moncinos, court certified interpreter with an oath on file.
Sir, good morning. You are Giovanni Alexander Rosales.
Señor, buenos días. ¿Es usted Giovanni Alexander Rosales? Hable en voz alta, por favor.
No puedo porque me duelen mis costillas.
¿Cómo?
Me duelen mis costillas fracturadas.
I can't, Your Honor, the interpreter asked Mr. Rosales to speak loud, and he said that he can't because he has broken ribs.
Okay, try again. There's less background noise.
Sir, good morning. You are Giovanni Alexander Rosales.
Voy a empezar de nuevo. ¿Es usted Giovanni Alexander Rosales?
Soy Giovanni.
Yes, I am Giovanni.
And sir, your date of birth is February 4th, 2000.
¿Es su fecha de nacimiento febrero 4 del 2000?
Exacto.
Yes, that's right.
Thank you, sir. Mr. Rosales, you have two cases before the court this morning, both of which are on for pretrial conference. The first case is 428 and the second is 429.
Señor Rosales, usted tiene dos casos que están ahora para audiencia previa. El uno es el 428 y el otro es el 429.
Ms. Horwath, good morning again. How would you like to proceed with Mr. Rosales' pretrial conferences this morning?
Señorita Howard, muchos buenos días. ¿Cómo quisiera proceder en el caso hoy día?
I'm sure hoping that the city feels it's appropriate to dismiss today. If that's not the case, we'll be setting it for trial and asking that Mr. Rosales be released.
Si es que el fiscal ofrece anularle el caso hoy día, sería lo mejor, pero si es que no es el caso así, entonces pongo que se ponga para juicio, para que le den la fecha para un juicio al señor Rosales.
Mr. Vincent.
Previously, the city had extensive contact with the alleged victim.
Anteriormente tuve bastante contacto con la víctima.
However, since this matter has been in warrant status,
Sin embargo, desde que este caso ha estado en estatus de orden, con orden de arresto,
there's been very limited contact.
ha habido un contacto muy limitado.
The city believes it would be prudent to reach out one more time to the victim.
La ciudad piensa que sería prudente al buscarle una vez más a la víctima
Prior to dismissing.
antes de anular el cargo.
And what is the city's position regarding pretrial conditions of release at this time?
Your Honor, the city would defer to the court.
¿Cuáles son las condiciones de libertad que usted daría para esta vez? Y el señor fiscal dijo que eso que la corte puede tomar esa decisión.
Supplement the record, Mr. Rosales provided his phone number to me. He lives locally with his brother. And we do have a plan to get the warrant quashed out of Olympia. He has really limited criminal history.
El señor Giovanni Rosales vive localmente con su hermano y me ha dado su número de teléfono y él tiene la posibilidad de enseguida de cancelar la orden de arresto, arreglar esto que tienen en la corte de Olimpia.
Oh, there it is. Thank you. The court is going to continue to hold Mr. Rosales on bail. The reason being, he has limited criminal history, which the court appreciates. However, it appears that there are 3 criminal cases that are active involving Mr. Rosales.
La corte ha revisado y ve que el señor Rosales no tiene un historial de antecedentes muchos, pero sin embargo al revisar viene que hay 3 casos que tiene que todavía están pendientes, 3 diferentes cargos.
Of concern to the court is the fact that all 3 criminal cases originated at different times in the year 2022.
La preocupación que la corte tiene es que estos casos se generaron por separado, cada uno en diferente fecha en el mismo año del 2022.
And in all 3 cases, Mr. Rosales failed to appear for his first pretrial conference and has been in warrant status for going on 3 years at this point.
Y en los 3 casos, el señor Rosales no se presentó para sus audiencias previas y ha hecho esto que este caso esté bajo orden de arresto ya por 3 años.
There does not appear to be any efforts by Mr. Rosales in the last 2 to 3 years while on warrant status to contact this court or the Olympia Municipal Court to address the outstanding warrants.
Parece que no es de mucho interés para el señor Rosales el hacer una llamada o hablar o buscar ya sea a esta corte ni tampoco a la corte de Olimpia. No ha hecho ningún intento de hablar.
The court will maintain the current bail amount and pretrial conditions of release.
La corte mantiene la cantidad de fianza y las condiciones de libertad.
Court will set this matter as requested by counsel for readiness hearing on May 15th at 1 p.m. in the afternoon.
Entonces posterga este caso para el 15 de mayo a la 1 de la tarde para saber si están preparados para una audiencia de preparación.
Ms. Horwath, it appears that you've added a earlier motion hearing. Is that correct?
Señorita Harlan, parece que usted presentó una petición temprana.
Here, I believe there's a good chance the city will be moving to dismiss that on the next available Pierce County Jail calendar. So I'm seeking him to be brought up on that date.
Yo pienso que todavía hay una posibilidad bastante alta de que el cargo se anule. Así es que yo pido que sea la fecha más cercana, la próxima.
Yeah, that makes perfect sense to me. So, Mr. Vinson, we will need to have an update from the city as to their ability to proceed with the criminal prosecution in this case by next Wednesday.
By next Wednesday?
La corte está de acuerdo con la señora, así es que le pido a la fiscalía que para el próximo miércoles tenga lista la posibilidad de cualquier investigación que han hecho, que tenga listo el plan para el próximo miércoles.
And given that he's in custody and will likely not post bail, we may need to have that readiness date be an in custody date as well.
I'm sorry, Ms. Horwath, could you repeat that?
Sure, I don't expect my client to post bail, and so the readiness date I chose was an out of custody date. If the court wants to switch that to an in custody readiness, or just make it on the same day as the motion, that's fine too.
Debido a que la próxima audiencia, no pienso que el señor Rosales va a poder salir bajo libertad condicional, así que pido que por favor le pongan la audiencia de preparación para lo más pronto posible también, pensando en que no va a poder salir bajo fianza.
We'll leave things as set. We're going to see Mr. Rosales next Wednesday at 10 a.m. If we need to shuffle dates at that time, we will.
Entonces vamos a dejar las fechas como están. Vemos al señor Rosales el próximo miércoles a las 10 de la mañana y ahí veremos qué pasa.
Voy a salir bajo libertad hoy.
Can I be released today with conditions?
The
Just,
condition posting bail, sir.
Mr. Rosales, I am not reducing bail in your case, given how long you've been on warrant status.
Señor Rosales, no estoy reduciendo la cantidad de su fianza debido al tiempo prolongado que ha estado usted bajo orden de arresto.
If you are still in custody, we will see you next Wednesday at 10 a.m.
Si es que todavía está encarcelado, entonces le vemos el próximo miércoles a las 10 de la mañana.
And actually, on that point, if you do bail out, it's your responsibility to be here in court next Wednesday at 10 a.m. here at the Lakewood Municipal Court.
Y en todo caso, si es que usted sale con bajo fianza, es su obligación y su responsabilidad presentarse aquí en la corte de Lakewood a las 10 de la mañana el miércoles. Próximo miércoles.
If you do post bail, the other thing that I want you to do is check in with Ms. Horwath, your attorney, so that she knows that you have been released.
Y si es que usted sale bajo fianza, también le digo que enseguida contacte a su abogada para que ella sepa que ha salido.
Entonces no voy a tener libertad hoy.
So it meaning that I'm not going to be released today.
That's correct, sir, unless you post bail.
Así es, señor, al menos que usted ponga la fianza, pague la fianza.
Yo no tengo quien me la pague. Yo no tengo.
I don't have anybody to pay bail for me.
In that case, I will see you next Wednesday, and you will still be in custody At that time, we will hear from the prosecutor as to whether or not they are able to proceed with your case.
Si es que es así, entonces usted va a quedar encarcelado y le vamos a ver el próximo miércoles a las 10 de la mañana. Y en este caso, el fiscal va a decidir qué es lo que vamos a hacer con el caso.
Madam Interpreter, I believe that's all the cases we have on for interpretation.
Yeah,
Just say, can you click on the join breakout room button?
Abajo de tu pantalla hay una opción para que entres a otro cuarto a hablar con la intérprete, que si puedes entrar ahí.
Ok.
Y si no puedes, llámale al oficial que está atrás de ti.
Ok, sí.
Get the officer.
Oh, disculpe, no tengo el monitor para moverlo. Y el oficial no está.
He's saying that he doesn't have the mouse to move the cursor and the officer isn't there.
Okay, thank you, Sergeant Mullen. Well, it looks like he's now gone into the breakout room, so thank you. Ms. Horwath, who is that that you? Madam Interpreter, good morning. If you could please identify yourself for the record when you're ready.
good morning, Mariana Heredia Monsinos, court certified interpreter with an oath on file.
Thank you very much. Sir, in the Nisqually jail, good morning to you.
Buenos días, señor, el que está en la cárcel de Nisqually.
Yes,
Good morning, Your Honor.
You are Floriberto Jacinto Estabbon.
¿Es usted Floriberto Jacinto Esteban?
yes, sí.
Your date
Yes.
of birth is July 20th, 1996.
¿Es su fecha de nacimiento julio 20 del 96?
Yes, sir.
This matter is before the court for a second pretrial conference in case 25L000632.
Este caso está por una tercera audiencia preliminaria en el caso que termina en 632.
Ms. Arnold, good morning. Are you prepared to proceed with Mr. Jacinto Estabbon's pretrial conference at this time?
Buenos días, señorita Arnold. ¿Está usted lista para proceder con el señor Jacinto Esteban Filiberto?
Yes, Your Honor. So, defense has uploaded a motion to continue.
Sí, dice, hemos pedido hemos hecho una moción de postergar
To give the defendant the opportunity to do a substance use evaluation while in custody.
con la idea de que el señor y con la facilidad de que el señor va a tener una evaluación para abuso de sustancia mientras está en la cárcel.
I've spoken with them today and we're just awaiting approval from a supervisor, but it is stated that it is very likely that this would be able to be conducted sometime next week.
Estamos esperando, pues hablé con el supervisor, estamos esperando la respuesta del supervisor, pero parece que es muy posible que esta evaluación se lleve a cabo la próxima semana, enseguida.
Which is why I set an in-custody date for next Friday.
Y por eso pedí una corte para como si estuviera encarcelado todavía para el próximo viernes.
And I believe that this will help with the other outstanding DUI as well.
Y creo que esto puede ayudar y asistir en los otros casos de manejar tomados también que existen.
Mr. Vincent, does the city have any objection to this request?
No
Señor
objection,
Vincent, ¿tiene alguna objeción a esto? No, su señoría.
Sorry.
One question that I have for the attorneys is what the status of speedy trial expiration is at this time?
Quisiera saber de parte de las dos partes cuál es el proceso del plazo de expeditivo que tiene este caso.
Your Honor, in custody is 6/15/2025.
Por encarcelamiento es el 15/6/15/25
And out of custody is 7/15/2025.
y fuera de, no estuviera en la cárcel es el 7/15 del 25.
I do believe that Mr. Yinto Estabbon has been in custody since the time of his arraignment in this matter.
Yo creo que el señor ha estado encarcelado desde la lectura de cargos en este caso.
Mr. Vinson, any concern regarding speedy trial time at this matter, or is the city comfortable with the expiration date of June 15th, 2025?
Señor Vinson, ¿está usted de acuerdo o tiene alguna preocupación sobre el plazo límite del caso? Y si está usted bien con que sea en junio 15 del 25, la fecha de expiración.
Your Honor, the city is moderately concerned.
La ciudad está moderadamente preocupado.
The city would not object to a release with a alcohol, with a scram unit.
La ciudad estaría dispuesto a dejarle en libertad para que le pongan un aparato biológico en el tobillo, un grillete biológico.
And other conditions as the court may deem appropriate.
Y también otras condiciones que la corte piense son adecuadas.
Ms. Arnold, what is the defense's position?
¿Cuál es la postura de la defensa, señorita Arnold?
Your Honor, it's my understanding that he's being held in Olympia on quite a high bail amount.
Tengo entendido que él está retenido por Olimpia con una fianza bastante alta.
If maybe I could have the chance, I know his attorney out of that court is Mr. Resnick. If I could have the opportunity to speak with him.
Mr. Resnick, are you on the Zoom platform, sir?
I'm sorry, Your Honor, I was on the phone. What, who is this? Oh, I know who this is, actually. I recognize.
You're quite all right.
I actually recognize this defendant.
Correct. And so there is a request from Ms. Arnold to speak with you regarding the status of Mr. Yinto Estabbon's Olympia Municipal Court case.
Okay.
And I believe we just lost the interpreter. So hold on one moment. Oh, there we go. Madam Interpreter, you are muted.
Yes.
Thank you. Can you hear me okay, Madam Interpreter?
Still frozen. I don't know if I can. Can you hear me?
I can hear you.
I cannot hear the court.
Can you hear me now?
I can hear you now. Yes.
Okay. Mr. Yinto Estabbon, we are going to take just a brief break so that I can allow Ms. Arnold to speak with Mr. Rusnick about your cases.
Dice, señor Jacinto Esteban, vamos a tomar un descanso breve para que la abogada pueda hablar con el otro abogado, el señor Wasner.
Okay.
Very well.
So the court will go off the record for just a few minutes so that Ms. Arnold and Mr. Rusnick have an opportunity to confer.
Entonces la corte va a tomar un breve descanso para que los dos abogados puedan conversar.
Okay, está bien, gracias.
Very well, thank you.
Could I please get a breakout room with the interpreter and the squally, please?
Going to invite you to join a breakout room again so that you can speak privately with your attorney.
Your Honor, I apologize for the holdup. We shifted gears and went with something else.
No problem.
I'll go check on them. They might be having a hard time getting back in.
Thank you very much.
Oh, there she is.
And Ms. Arnold, before you entered the breakout room, there was a request, or I shouldn't say a request, but a proposal from the prosecution to releasing Mr. Yinto Estabbon on personal recognizance with a installation of a scram device or an alcohol sensor. What is the defense's response?
Hubo una propuesta de parte de la Fiscalía de dejarle salir en libertad al señor con un grillete biológico en el tobillo. ¿Cuál es la respuesta de la defensa?
Your Honor, instead, defense would like to go with the agreed upon resolution and have the defendant enter into an SOC.
En lugar de esto, su señoría quisiera que el acusado va a aceptar un acuerdo y entrar en un programa de postergación.
Guilty mandatory minimums dismissed. And Your Honor, and Miss Sophia Arnold, I apologize. The city was considering a 12-month SOC, but at the bottom of that chart, it does say a G mandatory minimums, dismiss the deal as third. So I inadvertently, I did not delete out the SOC. So there's both in that grid, both a guilty plea and SOC. I apologize for that.
Me disculpo porque en el documento está escrito las dos cosas, también el acuerdo de postergación y también el acuerdo de una declaración de culpable. Entonces no quité el acuerdo, no eliminé el acuerdo, es que me disculpo.
Ms. Arnold and Mr. Vinson, I'm going to let you both know I am at this point thinking about setting Mr. Yinto Estabbon's matter over to Monday morning.
Quiero que sepan los dos abogados que este rato yo estoy dispuesto a postergar el caso del señor Filiberto para el lunes por la mañana.
Monday afternoon, I apologize, I misspoke.
Lunes por la tarde, perdón.
And let me tell the parties why. It seems like there is conversations that still need to happen off the record between counsel for both parties.
Y déjeme explicar el porqué de esto, es que porque parece que todavía necesitan haber conversaciones entre el abogado y la otra parte.
And at this point, it is 11:45, and this is still the first matter on the court's 11 a.m. Nisqually calendar.
Y en este momento ya son las 11:45 y este es el primer caso que hemos visto del calendario de las 11 de la mañana de Nisqually.
Does either party have any objection to me setting Mr. Yinto Estabbon's matter over to the Nisqually calendar for Monday?
¿Tienen alguna objeción en que yo postergue o posponga o ponga para el próximo lunes para el calendario de la cárcel de Nisqually?
Your Honor, defense would object based on contract law. I mean, an SOC is a contract, and we did have an offer. That offer was accepted. That offer was agreed upon with the defendant in this case. So the defense would have to object.
La defensa objeziona a esta postergación, puesto que ya el acuerdo de postergación es un acuerdo que se llegó y que se presentaron, nos presentaron y nosotros aceptamos ya esto. Así es que yo sí tengo objeción de postergar hasta el lunes.
Mr. Vincent?
I'm happy to show the court the chart that was sent, but it's the city's position that there could not be a meeting of the minds because there are two inherently conflicting statements in the grid.
Dice, este momento su señoría, la fiscalía sostiene que no se podría llegar a un acuerdo ahora, puesto que hay dos cosas conflictivas, dos frases o declaraciones conflictivas en el documento que se necesitan reparar.
At a minimum, it should have been incumbent upon defense counsel to clarify the two inherently conflicting offers.
Y tal vez sería por parte de la abogada de la defensa que tendría que aclarar esas dos situaciones conflictivas en el mismo documento.
The court at this point is at a significant disadvantage.
En este momento la corte está bastante una desproporcionada ventaja.
I have Ms. Arnold on behalf of Mr. Yinto Estabbon indicating that there was an agreed upon resolution and she is requesting specific performance.
Y la señora Arnold está pidiendo que han habido específicas aceptaciones del acuerdo y está pidiendo que se prosiga.
Mr. Vincent is indicating there was no such agreement and that the parties were still in the midst of pretrial negotiations.
El señor Vincent está diciendo que no hubo tal acuerdo entre las partes definitivo y que todavía están hablando sobre esto.
Unfortunately, either way, the court is ill prepared to respond to this disagreement between the parties at this time on this calendar.
Desgraciadamente, en este momento, la Corte no puede resolver este caso conflictivo entre este desacuerdo que hay entre las dos partes hoy, esta mañana, en este calendario de hoy.
I'm going to set Mr. Yinto Estabbon's matter over to Monday at 1 p.m. for the in-custody and esquality calendar so that the parties have an opportunity to confer.
Voy a postergar esto para el lunes a la 1 de la tarde en el calendario de la cárcel de Nisqually para que las dos partes puedan hablar sobre esto.
If either party has a motion for the court, I would ask that it be brought back before the court Monday.
Si es que alguna de las partes tiene alguna petición o alguna para presentar a la corte, pido que lo hagan el lunes por la mañana.
And if there is any briefing that needs to be submitted to the court, I would ask that that be provided to the court as quickly as possible so the court has an opportunity to review it before that hearing.
Si es que también tienen un sumario de lo que pueden, de lo que están pidiendo y de las cuestiones que tengan, que hagan y que aclaren entre ustedes, por favor manden un documento a la corte expresando esto lo más rápido posible.
Ms. Arnold, just so you're aware, I'm amending the order that you prepared a little bit. I'm no longer indicating that this is a motion of defense counsel to continue the pretrial. This is a motion on the court's own motion. I'm leaving the language in there that you included regarding the evaluation.
Estoy poniendo, no estoy cancelando totalmente la propuesta que usted puso, señora abogada. Simplemente estoy diciendo que no es usted la que está pidiendo la postergación, sino es la corte la que está posponiendo para el lunes.
Court is also noting on the order that there are no changes in conditions of release at this time. The parties are obviously free to revisit that on Monday.
También en este momento la Corte no ha decidido ninguna de las condiciones de libertad se mantienen iguales y si se quiere cambiar esto, entonces vamos a hablar sobre esto el lunes.
Court has signed that order. Mr. Yinto Estabbon, we will see you back here on Monday afternoon.
La Corte ha firmado esta orden, señor Jacinto Esteban, entonces le vemos nuevamente en la Corte el lunes a la 1 de la tarde.
That will conclude your hearing. You can go ahead and let the officer know that your hearing is done.
Esto concluye su audiencia. Usted puede dejarle saber al oficial que ya ha terminado.
Muchas gracias.
Thank you very much.
You're welcome, sir.
De nada, señor.
Thank you very much, Madam Interpreter. Hey, Jail, what is your name, please?
Samuel Hicks.
Thank you. Your true name is Samuel David Hicks?
Yes.
Your date of birth is July 26, 1985?
Yes.
Mr. Hicks, you are before the court in case 25L000923 for an arraignment. The city of Lakewood has charged you with 1 count of assault in the 4th degree domestic violence. Ms. Arnold, are you prepared to proceed with the arraignment at this time?
I am, Your Honor. This is Sophia Arnold. Defense will waive a formal reading of the criminal complaint and ask the court to enter a plea of not guilty and stipulate to probable cause for today's purposes only. After screening him, he does not qualify for court-appointed counsel, and I did discuss with him that he will have to hire a private attorney moving forward.
Thank you. Mr. Hicks, based upon the record that Ms. Arnold has made on your behalf this morning, the court is going to waive formal reading of the criminal complaint, find that there is probable cause to support the filing of the charge, and enter a plea of not guilty for you at this time. Court will next hear from Mr. Vinson regarding the prosecution's recommendation on pretrial conditions of release in this case.
Your Honor, the city is not objecting to release on personal recognizance, but the city is requesting a no contact order. The basis for this is that they are roommates, the defendant and the victim, Mr. Hagen Rodriguez. And unfortunately, this was the first day that they moved in together. It appears that there was some contention regarding either girlfriends or other relatives of the two. And we have attempted contact. We've not heard back. Therefore, out of the abundance of caution, we're asking for a no contact order.
Ms. Arnold.
Your Honor, defense has no objections to the standard conditions of release. However, we're going to ask for no hostile contact order. I believe that the two are on good terms, and I don't believe that they would want a no contact order from what I've been told. Also, he does not have an alternative place to stay. He did just move all the way from Queen Anne to take a new job. So we'd ask for no hostile contact. And considering the defendant has no criminal history that indicates that he's violent or anything like that.
Mr. Hicks, the court is going to release you on your personal recognizance. So unless something else is holding you, you should be released later this afternoon. The court is going to impose a number of conditions on you, though, so I want you to listen very carefully to these conditions. First condition the court is going to impose is that you appear in person and on time for all scheduled court hearings. Your next hearing in this case is going to be on Thursday, May 29th, 2025 at 1 p.m. here at the Lakewood Municipal Court. That date and time will appear on the court order that you'll be receiving from officers at the conclusion of your hearing. Court is ordering that you attempt to hire an attorney to represent you in this case and have counsel retained so that they can appear with you at that next hearing on May 29th at 1 p.m. You're to have no criminal law violations. You're to update the court immediately if your mailing address changes. You are not to have any hostile contact with the alleged victim in this case, Josiah Sanel Hagen Rodriguez.
Yes, Your Honor, I understand.
Okay, and the court has signed that order. Mr. Hicks, we'll see you back here on May 29th at 1 p.m., sir.
Yes, sir. Thank you, Your Honor.
Thank you. You can go ahead and let the officer know you're all done.
Well, thank you.
Good morning or good afternoon. Are you Aisha Jadam Anderson?
Yes, sir.
I apologize.
Okay.
Good afternoon. You are before the court for a review hearing. Your attorney, Mr. Rusnick, is also on the Zoom platform with us. This is case 23L000589. This matter, as I mentioned, comes before the court for a review. Ms. Anderson entered a plea of guilty to one count of assault in the fourth degree domestic violence on June 17th, 2024. This matter is before the court for a review following a failure to appear for a review hearing and a bench warrant being issued. The issues that the court see as outstanding are there were community service hours that were ordered, there was anger management that was ordered, and there was attendance at a domestic violence victims impact panel that was ordered. All of those are conditions of suspended sentence. The court's review of the calendar indicates that those conditions, unfortunately, still have not been complied with. But I will give Mr. Rusnick an opportunity to speak to that. Mr. Rusnick?
Looking at her history, including some subsequent violations, including warrant history and outstanding warrants in different jurisdictions, I think Ms. Anderson would welcome a nominal sanction and close these cases. It seems like she's a moving target and maybe homeless for all I know, as far as coming back and complying. I don't think it's necessarily an unwillingness, but an inability, or maybe 90% inability and 10% unwillingness to comply with conditions. But the point being, I think she would like some nominal sanction imposed, and then upon serving the sanction, close out this case and give her some repose.
Mr. Vincent?
Normally, Your Honor, the city would concur with Mr. Rusnick's recommendation. However, the city is concerned that this was an underlying offense, was a domestic violence assault, and the conditions that she was required to perform were to benefit her, but also to benefit the community. Normally, domestic violence charges have a jurisdiction of 5 years. There's still an active no contact order, so the city would not be comfortable imposing and closing this matter without further notice and discussion with the victim in this matter.
Okay. Mr. Rusnick, as a threshold matter, is your client stipulating to the violations, the failure to complete community service, anger management, and the domestic violence victims impact panel?
Yes.
Okay. Or we'll accept that stipulation. We'll find that violation.
I don't know where to go.
So Yeah, I get what both attorneys are saying. Mr. Vincent has a valid point. This matter was only before the court for change of plea less than a year ago, and the court still has over 4 years of jurisdiction that was taken. But Mr. Rusnick is right. It looks like there are a lot of other things going on in other courts that are spreading Ms. Anderson pretty thin. I see that there are warrants outstanding out of Spokane Municipal Court. There is a warrant out of Yelm Municipal Court, and there's a warrant out of Pierce County District Court. So, you know, Ms. Anderson has a lot on her plate at this point, and I guess I'm struggling with what the court is hoping to accomplish by continuing to maintain jurisdiction in this case. I agree with Mr. Vincent. I think the anger management, with the Domestic Violence Victims Impact Panel would absolutely be beneficial for Ms. Anderson, and the community service hours that she agreed to do would be beneficial for the community. What was that?
Oh, I'm sorry, Your Honor. I just said I've been doing community service, but they didn't have any openings at the St. Vincent de Paul, so I just picked garbage up everywhere I go. I'm picking garbage up, and I was hoping maybe I can get signatures from businesses and the people that work there to prove that I've been doing so. As far as getting to Yelm, I couldn't get there. I don't have a car. I didn't have a phone. I just recently obtained the free phone again. So I had to wait 30, 60 days in order to get a phone through that service. Now I have it. I tried calling, was subsequently unable to do so, but getting there was the main problem. I have no problem being in compliance with any factor of what needs to be done to be able to get to these court dates, but I can't go to Spokane if I'm not supposed to leave jurisdiction. I can't, you know what I mean? I didn't even know I had a warrant out for that, for the domestic violence between my son and I haven't spoke with my son at all, which is, I'm sorry, which is killing me in and of itself.
You're okay, Ms. Anderson. You're okay. All right. Here's what the court's going to do. And I don't really like it, but I think I'm persuaded more by the argument and the position of Mr. Rusnick. It's not to say that there isn't value in what is being proposed by Mr. Vincent, but I feel like at this point we continuing to require Ms. Anderson to do those affirmative conditions is just frankly setting her up for failure. The court is not going to close this case. However, what the court is going to do, the court's going to waive the previously imposed conditions of the anger management, the Domestic Violence Victims Impact Panel, as well as the community service hours, the anger management, community service hours, and Domestic Violence Victims Impact Panel. So the court is waiving all of those affirmative conditions at this point in time. The court will maintain jurisdiction at this point for law-abiding behavior, and will also maintain the outstanding no contact order that was issued as a condition of sentence, because Mr. Vincent is right. I'm not going to recall that no contact order unless there's been notice to the victim, and there hasn't been. So the court is going to go ahead and accept the stipulation, find that there is those violations for failure to comply with the terms and conditions of suspended sentence. Court is going to impose a sanction. I do think that's appropriate. Court will impose 20 days in jail and give Ms. Anderson credit for the time that she has already served. It looks like she was booked in on May 8th. So she's entitled to 1 day credit. She'll have 19 days to go. I'll indicate that jail term is to run concurrently with any other commitments.
there any way to do an ankle monitor at New Life instead of being in jail?
Ms. Anderson, unfortunately, no, for the very same reason that I'm waiving those affirmative conditions. I think you've got a lot of stuff going on here, and my concern is that any condition I impose upon you is going to set you up for a potential violation, which is only going to make the hole that you're in deeper. So the court is going to go ahead and impose that 20 days in custody. I'm not going to set any future reviews at this point in time. But that will be the sanction of the court. And you should be released probably in about, I'm guessing, probably about 2 weeks. And then at that point in time, it looks like you've got some outstanding warrants that you're going to have to address in other courts. So I'm going to, for all intents and purposes, get this case out of the way and let you deal with those.
Thank you, sir.
Court has signed that order. That will conclude Ms. Anderson's hearing. Is there anything else from either attorneys that we need to address before court is at recess?
No, Your Honor.
No, Your Honor.
Thank you all very much. Have a nice weekend.
Every day in the USA, people find themselves in court.
Yes, we're gonna put you in there with the mediator.
Thank you.
Reset 7/9, 9 a.m. All right, number 10 is Calvary SPV versus Diane Harris.
Hey, Judge, that's Christopher Tang's logging back into that one shortly.
Okay.
I don't think they knew about that one.
Okay. So P is Mr. Tang. Is Diane Harris here? Diane Harris. Okay, does not look like she is here. I'm going to reset that to the June 18th.
I'm sorry, Judge. I think she is here, but she cannot hear us. I just chatted her. She can come back into the session.
Okay. All right. So I will mark her as here.
And Mr. Tang just logged in for the last one, Judge.
Okay. Thank you. All right, Mr. Tang.
Apologies, Your Honor.
Okay. So this is number 10, Calvary SPV versus Diane Harris. Ms. Harris is having some issues with her audio and or video. And so we're working with her. We'll hopefully get you guys into a breakout room soon. Okay.
Okay, thank you.
All right. Number 11 is Grace Pack versus Jacob Alexander. Something from me? Do you guys need to go into breakout rooms? I know I'm circling back to Miss Barnes. Mr. Tang, did you have an announcement or?
No, Your Honor, as of yet, Ms. Harris and I have not been in a breakout room together, though there's a message in the chat, which I believe is from her, or possibly not, saying that she is still having audio issues.
Okay. She said, okay. Looks like Miss Stevenson is also having some issues. I know I don't see Miss Harris.
It's possible she's either, I don't know if she disconnected or.
Let me look.
She is labeled as Doria Steverson.
That's Miss Harris?
Yes, that is correct.
Okay. Is there another device she can log in on, or can we call her or something to find out?
I just asked her if she can log in with another device, but she said that she's on her phone and nothing.
How'd you like to handle this, Mr. Tang?
Well, obviously it's.
Well, here's someone named Diane Harris in the waiting room. Let me let her in. Let's see.
Okay.
Miss Harris? Can you turn your camera on, ma'am? Unmute. Looks like you're connected to audio because you're. Mr. Gerbig, are you waiting to go into a breakout room?
Actually, the defendant didn't show up and you asked me to wait to schedule.
Okay, sorry about that. 1 second. Well,
Okay.
since I can do default, so it looks like we do defaults on this calendar, so I will circle back to you to do that. Ms. Harris, can you hear us? Ms. Harris? She probably needs to give her Zoom app permission to access her camera and audio.
I would say that's probably the most likely thing, though it's also, I mean, there's a number of possible issues, Your Honor. Theoretically, she could have another app running that's accessing the audio and blocking it. She could also have a physical issue with her audio within the device itself. I don't know,
So
obviously.
we reset it to in person and just, you guys can just.
I don't have an objection to that, Your Honor. Obviously, the defendant has made a good faith effort to appear, and while I would generally prefer remote, if we reset to remote and we have the same issues, then that doesn't really help.
I don't, if this is not, there's no way to guarantee it's gonna, this won't be a problem again. So my thought would be just to, let's see, defendant, audio problems. All right, so I'm gonna reset this to in person just to avoid this happening again. Okay. That date is going to be June 12th at 9 a.m. So that's going to be position number 10. So Ms. Solano, if you don't mind chatting to Ms. Harris or letting her know that we're going to reset this to an in-person hearing so that we don't encounter the audio issues again. Okay.
Will do, Judge.
Thank you so much. All right. Thank you, Mr. Tang. Is that your last case?
I believe so. I know I said that with the last one, but we've been through the calendar now.
Okay,
So.
well, you're welcome to come back if you'd like. Okay.
All right. And obviously feel free to contact us if in the next few minutes somehow the audio starts working.
Okay, will do. Thank you so much.
Thank you.
All right, we got a couple of mediators back. Mediator Smith, did you have an announcement?
Yes, Your Honor, for position.
All right, is there any, so we've still got Ms. Harris here. Ms. Harris, she cannot hear us.
I've been chatting with her, Judge, and she is trying a different device.
Okay. So she's already here on 2 devices.
Yes, she said she will
Hello?
get her tablet.
Oh, Ms. Harris?
Yes, I am filling in for her. She's on the other line. I have a two-way, but I was trying to get it on my laptop. She can hear me, but she can't speak. I don't understand why, but she can't speak into her laptop or her tablet.
Okay. Are you a friend of hers?
I'm actually one of her representatives. I just did a will for her, so she called me to see if I can contact you guys and for her. She emailed me all the. Excuse me.
I'm sorry, I reset her case just because of the issue she's having with her audio. If you could let her know that I reset her case to June 12th at 9 a.m. in person so that you don't have to worry about the.
Yeah, I can hear it now.
And now she's here.
The only issue with in person we have is she has knee surgery and she's 79, so she really can't get around. I can attempt to have somebody from my office take her.
Okay. Well, I've already I can try to get the attorney. I already let the attorney for the plaintiff go.
Okay.
I can call him back and see if he can relog back. Ms. Harris, can you talk? Can you hear me? I think I heard you say something a minute ago. Ms. Harris? Okay, we can hear her now.
Yeah, I can hear it now. Yeah.
I can call Mr. Tang. We can contact Mr. Tang and see if he can come back.
I just can't hear it now.
You can't hear?
This is real low. I can't understand you.
I'll speak for you. She's gonna call the solicitor on the case to see if he'll come back so you can dispose of your case today.
Okay.
Okay, we'll see if this works. Ms. Solomon, can you see if Mr. Tang can come back?
Thank you, Your Honor.
Thank you. Ma'am, if you could turn your camera on for me?
Oh, okay. See that.
Maybe, okay.
Okay, I've turned it on.
There we go. I can see you now. Okay, what is your name?
Okay. Doria Stevenson.
Oh, I see. Okay, so you're Stevenson. And you're assisting Miss Harris?
Miss Harris, correct.
I'll just, I guess for lack of a better, I'll just leave you as a witness. Let's see, witness.
Okay, perfect.
Dory, Dorian?
No, just Dorin.
Okay, Dorin. Stevenson.
Correct.
Okay. Okay, all right, folks, we will wait to see if Mr. Tang can come back.
Okay, perfect.
See what to do there. All right. I'm not going to put Miss Harris back on mute just because she's having so much issues with her device.
Exactly. Right.
We're going to leave it the way it is, okay?
Okay, perfect.
Mr. Ortega, do you need to still be here? I mean, I don't want to keep you if you're not.
Yeah, I assign all of the mediators, so if a mediator comes back and is available for room 10, then I would be appointing them. So I need to be here throughout the calendar.
Okay. All right. Just wanted to check in. All right. Okay, folks, I'm still here. I'm just going to turn my camera off. Hopefully we'll hear from Mr. Tang in just a couple minutes. Okay.
Okay.
Thanks.
Attorney Tang just responded. He should be back within 5 minutes.
Perfect. Thank you. Also, please, I'm going to put everybody. Hello, Mediator Marshall. Do you have an announcement?
Yes, Your Honor. On position 10, the parties have agreed to a consent judgment,
Okay.
and Attorney Tang will be sending the file to, sending the document to Clerk Solano to be filed.
Okay, has it already been signed?
Yep. It's signed by all parties and already sent to the clerk, Your Honor.
Okay, perfect. So I'll just say agree to CJ, order submitted today. Okay, great. All right. Well, unless you guys have any other questions, you guys are free to go. Thank you.
Thank you.
Thank you very much, Jim.
All right. Let's see here.
Every day in the USA, people find themselves in court.
We'll see you back here on July 25th, and good luck.
Thank you so much.
Sure. Okay, so now 9:10. Are we going to set up breakout rooms for both of them?
So I only have one surface available today.
Okay.
I think this case was originally reset. I believe they did attempt mediation. But I only have the one surface today.
Right.
Here, I'm happy to
yes.
I'm happy to have them in one breakout room. That makes it a lot easier for everyone, as long as they're don't have some sort of inability to be in the same room together for some reason.
Well, they're in the same room together now. And so,
and I haven't, I assume Keisha and Denise are around, but I haven't heard a peep. So I'm happy to stay and do that mediation.
okay, give me just a moment here.
That's fine by me, Leslie.
Okay. So you were here once before. You folks were here in March.
Yes.
Okay.
And we spoke with her. I was able to do Zoom then, but we're homeless now and I'm not able to do Zoom. But Leslie is the same mediator that we spoke to last time.
How'd that go?
I was really hoping for a nice mediation.
That's what we all hope for that.
They're not about that. So,
All right. Well, I don't want to make anyone waste their time, anyone's time. And so if you can, Leslie, just a second. Leslie, do you have any recollection of this?
no, but if they're happy with my work, then you should ask Keisha or Denise if they're.
I mean, I know the result would be we just go straight to trial. Excuse you folks. If mediation's not worth it, let me turn with the Lawrences.
Okay.
I mean, is it worth it to, and Mr. Pettit, I'm asking them, okay? They're the parties here, okay? So, you know, mediation, you go into a room and you can see if you can work something out. And that's to the benefit of all parties in terms of, you know, plaintiffs can get out of here with something they can live with, defendants or some measure of satisfaction, defendants can get out of here with something they can live with. Otherwise, you turn the things over to me and then I make all the decisions and you may or may not, both of you might walk out of here mad. I don't know what happens from time to time. You laugh, but that happens more often than you think. And so if it's worth it to go try and meet with the parties, and only named parties are in mediation. So Mr. Pettit, you would stay here. And then you would go mediate between the four of you in a room. Because then if it's worth it to do that, you know, we have time here. There's only one case that's going to go here today. So I got all morning, which is plenty of time. Okay, so you, sir, you're talking to me. No, you can, okay, you can stay from right there. Are you tracking what I'm saying, first of all? And so, can you hear me?
I'm extremely hard of hearing.
Okay, well, so is that, and you're Ms. Lawrence, you're Janice Lawrence? Okay, you've heard me, because I've seen you respond to things I've said. I mean, so I'll ask you, what's your position on, sitting in a room with those two folks with a mediator on a Zoom, on a tablet, for the purpose of talking about this case and working something out? Would that be worth it to do that? Or, I mean, you tried it once before.
I don't have anything to say to them.
Okay. All right. So Leslie, you can go ahead and go, and then Kasia and Denise can too. And then we'll do all the dismissals on the other case later.
Okay.
Mr. and Ms. Lawrence, you can come up there and take a seat there at that table. And then Mr. and Ms. Stevens, you come up and take a seat at that table. Yes, sir.
I do have a hearing device. Mr. Lawrence.
Okay, well, I'll talk about that. Let me call your case up. So, Mr. Lawrence, we have a device, a hearing device, that amplifies sound. You can put that on. Do you wish to have that?
That'll be fine.
Great.
Just say something.
Okay, well, we can put it on. Come on up. Okay, so hang on. Your wire's kind of hooked up behind your ear there.
Okay.
No. Behind, turn this way. Okay, pull that. You have the wire around your ear. There you go. And then loop it. Keep looping. Take the whole thing off. The earphones off. There you go. Unwrap that wire. There you go. Perfect. Now put it back on.
Okay.
All right. Now you can go take a seat. You can adjust the volume on that. And can you hear me now?
Yes, I can.
Okay. So before we start, normally I give this sort of talk prior to trial, but you need to understand a few things before we get going. First of all, what happens in trials, I swear both parties in. I'll swear in the plaintiffs first. Following that, I'll swear in the defendants. And then I'll hear from both sides, and then I may have questions for both sides. If you have any witnesses you wish to call, and I see there may be one potential witness who was referenced in some of the stuff that was filed, you can call that witness. I'll swear that witness in, and then hear from there. I may have questions for each one of you. I may not, and but I want all. Can you hear me? How's that hearing?
I could you could turn it up a little bit, can't you?
Where's the volume pointing?
It's the wheel.
The wheel.
Okay, there you go. Can you hear me now?
It's on 5, is that right?
I honestly, I don't know.
Okay.
Okay. Does it
I
go-
can hear you pretty good.
I know, but it's 5. It's hard. Did you ever see Spinal Tap? Where they painted an 11 on the volume dial. Okay, why don't you bring it up to me? Let's see if we can turn this up. Let me see. Yeah, that's as loud as it goes.
I can hear you now. Thank you.
Perfect. Okay, to recap, again, I swear in both sides. I'll hear from both sides, plaintiffs first and the defendant. I may have some questions for you, and we'll just kind of proceed in that manner. Next, say if you have witnesses to call, I'll swear in the witness and hear from the witness also. I want to remind everybody, I want all comments directed to me. and not to the other party. I don't want you to interrupt the other party. You're going to hear that. I can tell already, this is a highly emotional case. I could tell that from reading the pleadings or what had been submitted. You're going to hear things you don't like. You're going to hear things you disagree with. And then I'll give you a chance to state your disagreement, and then don't interrupt the other side. Don't address the other side. Address all comments to me. The other thing is, you need to be aware of is I'm bound by the law up here. There might be a way that I think that, oh gosh, I can do it this way, or this makes sense to everybody, but I can't do that. And so a lot of times I have the experience where people ask things that the law doesn't entitle me to give. And even though it might not seem right or fair or appropriate, that it's just that's just the way it is. I'm bound by the law and what the facts are presented, and go from there. So with that, Mr. and Ms. Stevens, you're the plaintiffs here. Who wishes to speak first?
Me.
Okay, could you raise your right hand, please? Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
How is it that the Lawrences owe you? You're asking for a judgment amount and the statutory maximum of $10,000. And so I need you to explain to me why they owe that. And then I'm going to need you to itemize. Itemize how you come up with that figure.
Okay. First off, relocation assistance. The home became inhabitable. In all my filings, I have the evidence of that. Notices from the city of Lacey and Thirsty County Housing Authority to also support that evidence. So relocation assistance in the amount of equivalent to the last month's rent that I was paying, $2,350.
How much?
$2,350 is what I was paying when I moved out. 3 times that would be $7,050. I had to buy a heater because we were freezing. That I provided a receipt for that. That's $30.
I mean, where'd you do the heater?
I just bought a space heater for $30 from Walmart
For the place?
for the entire 2,000 square foot home. It wasn't able to keep us all warm. So I put it in the room where the baby is so that the baby would be kept warm through the winter. I provided a receipt for that heater. Replacement of our clothing. There are me, Frank, my 3 boys, and my grandson that lived at this residence, and all of us lost our clothing due to mold. I provided photos of all of our furniture that was covered in mold that we had to take to the dump. I provided photos of all the trips to the dump. I did not ask for reimbursement for my dump fees or for my furniture. I am asking for November, December, January, and February's rent.
Were you
My
there?
portion that I paid, because I'm on housing, be returned to me because I began giving him notices in October for these needed repairs. And the home is inhabitable. We froze all winter. I'm asking for my damage deposit back, which I paid $1,200, but the rental agreement that he provided me when I asked for it says only $1,000. So I would be willing to take the $200 off of that. I have asked Housing Authority for my copy of my rental agreement, which is part of the program that I we take it to them and they keep it in their file, but they have been putting all their, digitizing all their files, and they keep telling me they can't access it. So, which is why I'd be willing to take 200 off of the damage deposit, because all I can go by is the rental agreement that he's provided, which doesn't look anything like the one that I signed. The one I signed had all the damages that were listed, and this that he provided me has had it all removed. The last month's rent of that I prepaid before I moved in is also not even written on this lease that he provided me. And he had me pay first, last, and deposit to move in. But I don't have evidence of that. So I would be willing to not have those, the 200, but the 12, I know I paid that, and I just feel like my family's been really harmed by all this. Our health is.
So talk to me about I mean, you say a few things about rent. You said 2,350 for, I'm not sure where that comes from, for a month, for what month?
That's how much my rent was
Okay,
when I moved out
okay,
of his unit.
okay. So did you pay that without staying there? Or how is it?
I continued to pay him rent even though housing stopped paying him rent.
Okay,
I have the receipts of me paying him
Okay.
rent for those months.
okay, so hang on just a second. So,
Housing.
okay,
told
hang,
me-
hang on just a second, ma'am. So tell me what months you want compensated for rent? And go ahead.
For November, December.
Okay, so hang on just a second. November, so that's November of 24.
Yes.
And then how much was that for the month?
My portion was 332.
Okay. So, and then you were staying there.
Yes.
Okay. And then December,
My portion was 332.
and you were staying there.
Yes.
And did the housing authority pay the rest of it?
Yes.
Okay. And then January of 2025?
My portion was 332. He increased the rent $300.
Okay, so hang on, just one thing at a time, ma'am. And so then, what about February?
In February, the rent went up.
Okay,
My portion went to 825. And he,
okay, so hang on just a second, just a second. And then, what about, and then did the housing authority pay the remainder of that?
yes,
Okay, and then what about March, or when did you move out?
I moved out at the 31st of March.
Okay, so what did you pay for rent in March?
I have the rent check for March.
But we put
Okay, hang on just a second. You haven't been sworn in yet. I'm talking to her, and that's why I'm just gonna do one at a time. And so March, what was the rent situation in March?
So we were supposed to, we came to court, and I was gonna ask the judge then,
No, that was when you were here on March.
yes, and so I was gonna ask the judge that day, do I pay him for March, even though I'm asking for him to pay me back all these rents?
Right.
But we got postponed, so I just
I'm
kept the rent
aware of
check.
that.
So I still have that rent check.
Okay, so you did not pay your share of the rent
For
for
March,
March?
no.
Okay, and then you moved out, I heard someone say, on
Yes.
March 31st?
Yes,
Okay. So you didn't pay anything in March. Did the housing authority pay a share of the rent in March?
I'm not sure what they paid.
Okay, and then you moved out March 30, okay. So the 2350, where does that come from?
That's how much my rent is. That's how much my rent was when I moved out of his rental. That's how much he was charging me.
Okay,
In
but did you
total.
pay that or you want that
No.
back? Okay.
No.
So I guess
that's
if you didn't pay that, why is it that they should give that to you now?
Because I'm forced to have to relocate because of his hazardous home that he did not do any of the repairs to
Okay.
and left me in a hazardous situation.
How long did you live there?
14 years.
All right. Well, how long has this situation been, have they been the owners the whole time?
Yes.
Okay. And so I mean, has it been like this for 14 years?
No, we had a really great relationship. I
Well,
we
what
had-
happened to the place?
So I started giving him notices of needed repairs and he just acted like I never told him. So I started giving him notices in handwriting. And the first time I gave him one, he just crinkled it up and said, I'll get to it. And so then I started taking the notices and taking them down to housing and having them stamped. So I had proof that I was notifying him that these things needed fixed. And at first I thought it was like a memory thing. Maybe he was just forgetting.
Okay. Well, why did you finally move?
Because housing said
pay
if
for it
I
anymore?
continued to stay there, I would lose my housing. And I'm poor. I can't afford
Right.
to live without my housing. So I had to move.
Okay. And then, did you get different housing or what exactly?
No, I'm homeless right now. I'm living in a trailer on my mom's property. I haven't been homeless in a long time. Anyway, I'm living in a trailer on my mom's property. I'm on Social Security. I don't have a lot of money to be able to like just move into a new place.
So again, tell me again, why did they, why would you lose your house? Why did they say you would lose your housing?
Because they will not provide assistance for a home that is inhabitable and the landlord refuses to do repairs.
I see.
They won't pay him for that.
Did they seek reimbursement for rent paid for those months that you were asking for? Or do you know?
I hope so.
No, but you don't know.
I don't know.
All right. And then how did they deem the place was uninhabitable? Did they come out and inspect it or what?
Yes, I provided you with all the inspections, both from the Thurston County Housing Authority and from the city of Lacey, who came out, and they were also mailed these same notifications.
Okay. And then where's that? You submitted a lot.
Yes.
And so, hang on just a second.
And I did provide all of those, I believe. Oh, here's my table of contents.
Well, when did this all start to go bad?
It started going bad, I'd say. I thought things were okay in October. But in November, I gave him the first written notice that I had taken to housing.
Well,
Um,
what,
the catalyst, I had a travel trailer that I was purchasing. And we had asked Richard if we could bring it there. And he said, yeah, that was fine. And we were gonna fix it up for summer camping. And so we brought it there and we started looking at it and decided that, you know, it needed too much work for us. And Richard expressed interest in the trailer. And so I spoke to the person that I was gonna buy it from, and they said, you know, they would sell it to him. The next morning, I came out of my house and Richard had his truck attached to that trailer, not by the tongue, but by the back bumper of the trailer, and was dragging it across the yard. And I have all kinds of photos of him doing that. So I had the person who owns the trailer come and get the trailer before he caused any more damage to the trailer.
I see.
And that was the catalyst that started all of this.
Well, I guess maybe I'll rephrase my question, then I'll hear from you. And then I'm gonna hear from them too. And then if Mr. Stevens wants to speak, I'll hear from him too, but so apparently, and I'll look for it and I'll find it, and I'm sure I've seen it at some point.
And
You know, hang on a second. So I've heard that you said the housing authority said this place was uninhabitable. And so I guess my real question is, was this place been uninhabitable all along? And all of a sudden this trailer incident triggered conflict between the two of you and that brought all this up? Or was this place a nice place that fell into disrepair, or that's?
it was a really nice place.
And so hang on just a second. So you said you had to buy a heater. I mean, did the electricity go out or what exactly?
No, in the photos that I sent to you, the heater quit producing heat. It was just blowing cold air. And now it doesn't blow anything. In the
When
backyard.
did that happen?
So I let him know at the end of summer, beginning of spring, or
End of summer,
end
beginning
of
of spring.
summer.
Those are two different times of the year.
Between spring and summer.
Okay.
It was warm outside.
Right.
So I told him verbally that the heater doesn't seem to be working, but I wasn't really worried about it because it's summer. And so in October, I said, hey, the heater still doesn't work. And I need you to get that fixed before winter comes. And that's when he was just, yeah. I remember you saying something about that. And I'll get on it and have it looked at. And I didn't hear anything. So in November, I provided him a written statement that heater needed fixed. So November, December, January, February, I moved out in March.
Okay.
The heater still doesn't work. In the photos that I provided to you, the outdoor heater contraption has its own ecosystem growing in it because it hasn't been used all winter. The shaft part that blows the air through the vents in the house has it's
Is that and again, because the number of pages aren't on this.
and we did have
So hang on just a second now. So where's the, can you put this in here where I can see that where the pages are? So I'm not sure why that's not showing it. Because I want to find the one with the 80 pages, because I want to find why the housing authority did. Does that make sense? Maybe.
Yeah, it's just not showing you the page.
Yeah, it's not the page, it's page count, right?
Okay.
Okay. So why did the, I mean, again, I'm gonna look, that's what I've been looking for, and I'm gonna try and find it. You said at somewhere in here, there was a evaluation from the housing authority that deemed the place uninhabitable?
Yes, so on my table of contents, I don't know how it comes in your area, but the City of Lacey's inspection report was on page 10 and 11. And the City of Lacey's inspection report, and then the housing authority's
so hang on,
notice of
but
abatement.
just wait a minute, ma'am. All right, I'll look for, it's gonna take me a minute to find that, but I can look at that in a minute. Oh, there we go. Okay, hang on here just a second. Okay. Okay, Mr. Frank Stevens, is there anything you wish to say? She kind of covered a lot of it. If you have anything to add, I don't want you to repeat everything she just told me.
Pretty much covered it.
All right, so who's going to speak for you folks?
Say what?
Who's going to speak for you folks first?
I can speak.
Okay, could you raise your right hand, please? Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
You can put your hand down. And go ahead, I'll hear from you.
Well, I have no way to get a hold of them. I have no address, I can't get a hold of them. I have no way to get a hold of them.
Okay.
They didn't provide me with anything. I can't believe that they were under oath and saying the things that they were saying.
Okay.
But
Well, what's your response here? Okay. What I have in front of me right now, I mean, and again, just a lot of this stuff, I'm not going to be able to compensate for. Here's where I'm coming from, and here's what concerns me about this situation. Okay.
Yes.
So I have in front of me some inspections from the housing authority, one from the city of Lacey, and they came out and, you didn't pass inspection. and for either the city of Lacey or the housing authority. They had some issues with what you're done. The city of Lacey noticed you'd done some electric work that wasn't inspected or permitted. They noticed that the heat facility or the furnace apparently wasn't turned on and wasn't working. They were concerned about whether it was working at all. And then from the housing authority, it indicates that it didn't pass inspection. And as far as I can tell, they were going to stop paying the portion of their portion of the rent, but they were still going to require them to pay for it. And so I guess I would have you answer to that. And also it said, according to the city of Lacey, it's in here that, they told you that that needed to be done by a licensed electrician. You needed to schedule an inspection and you didn't do it. You weren't interested in doing that. So I guess I would have you address that.
I did have it inspected.
Do you have the copy, the inspection?
I do not. The electrician came over there. They denied entry to the house. They would not let them in. And
do you have any sort of documentation from that electrician?
I do not have it with me, but he's a licensed electrician. And like I say, he went over there. They denied him entry, not only once, but 2 times. And
how come you didn't schedule the inspection with the city of Lacey when they asked you to?
I
can read this to you.
I'm not understanding that question.
Sure. I'll read. Okay, so hang on.
Okay.
I notified the property owner that permits were required for any electrical work that was done, and he needed to hire a licensed and bonded contractor to come out and inspect the furnace to find out if it is a working order. The property owner refused to schedule the required inspection.
Well, I had the inspector, I had the electrician come. Like I say, they denied him entry. And I went over there this morning, the heat works. This morning when I went by there, the heat works. And they turned on, Your Honor, they turned on the water, left it running wide open. I got a $2,500 water bill. And they did that on purpose. So I have, right now, the water is,
So hang on just a second.
That bill.
And so then there's a letter to them from the housing authority. It said, the housing authority recently re-inspected your unit, which is theirs, what they are renting from you, and found that the housing quality standard deficiencies have not been cleared. This re-inspection was the final inspection, and as a result, we will need to begin abating the HAP or housing assistant payment, which means they're not going to pay it. And said, you will continue to be responsible for your portion of the rent in the amount of $825, which she mentioned earlier, but you're not responsible for paying the abating housing assistant portion of the rents. Said if the deficiencies are repaired. And so did you do anything to repair those deficiencies?
I repaired.
Okay, so and I'm asking him, not you there, sir.
Pardon me?
You have an advocate behind you who is nodding, and I'm asking you, I need answers from you, not from him.
Okay. The question was,
what did you do to address those deficiencies?
Well, I went over there and I met the man from the housing authority leaving. And I was there to go in with him and go over things, and he just walked off and left me. And
did he give you any notice of anything, of any reason what was wrong?
Like I say, they have taken they're thousands of dollars behind in rent. I mean, the only time they've been current on the rent is the last couple months. When the last I let them buy without paying thousands of dollars worth of rent.
Okay, but you're saying they only played current when you were in November, December, and January?
That's the only thing that they have documents for. They're thousands of dollars behind in their rent.
Well, they don't live there anymore.
No, they don't. But they haven't paid for a long, long time before that.
Why didn't you do anything about that?
I felt sorry for them. How many people they had living there, I have no idea. They had, I don't know, they had probably 5 to 10 people living there all the time.
Again, why didn't you do anything about it?
Well, that's a good question.
Thank you.
Why I didn't. I felt, like I say, I felt sorry for them.
Well,
and I liked them. I always liked them until this thing. And
did you is the premises been re-rented?
No.
Okay. Why not?
Okay, here's a few reasons why it's not rented. The house is dirty.
Right.
All the carpets are ruined, destroyed. Garden window is destroyed. There's broken light fixtures. There's the front door is off of some, I don't even know where it came from. Some metal door he found someplace and put on the front. The sliding doors for the washer and dryer are completely gone. There's $1,500 worth of doors there. The appliances are destroyed. All of Formica is destroyed. There's holes, they've stabs in it. The house smells so bad, and the back door is destroyed. That's a few things that's wrong with the house right now. And like I say, I have that $2,000 some $500 water bill, which they just walked off and left the water running wide open.
And they were your tenants for 14 years?
Yes, they were.
And you never noticed any of this stuff before?
Well, I never went in the house.
So that's a yes, you never noticed that? Do you wish to have?
Well, I noticed the yard was just totally covered with garbage. This trailer that they spoke of, that trailer there, they were renting, they were paid rent to keep that trailer there. And he was running a business out of which is all on in the homeowner, the rental agreement. They're not supposed to run a business out of there. They're not supposed to.
Okay.
Your Honor, the thing is unbelievable.
Yeah, there's a few things that are unbelievable there, Mr. Lawrence. And ma'am, do you wish to have anything to add? Okay. So Ms. Stevens, talk to me about the water bill.
So Richard showed up at my home 2 weeks before we moved out. And I provided you photos of before he dug up the garden and after he dug up the garden. When he was there digging up the garden, he opened up the main water valve and the main water pipe had been leaking, at which time he told me that water bill occurred because of the leak in the main water line from his old water pipe. And I have photos that I provided to the court of that ground being undisturbed before he arrived and dug up after he arrived. And I do have video of him digging it up. So he's trying to say that I left that water running when his main water line burst. That's not my fault.
Mr. Lawrence, you can address that. I mean, she's telling me they didn't leave the water line. They didn't leave the faucet running. The water line burst. And that's what drove the bill up.
She's lying.
And
So hang on just a second. So you saying a faucet was left on or water was just running?
She left the water running wide open.
Where and what sink?
Right in front, where it enters the home.
Oh, you mean she just turned on an outside faucet?
Yeah.
The faucet was spewing water when you showed
Yeah.
up there.
The whole front area was flooded.
Well, that one burst water mains do that. Another question I have for you, ma'am. You know, he's saying that you hadn't been paying rent. You only paid rent the last couple of months you referenced. Was that accurate? Not
That's
accurate?
inaccurate. Had that been the case, I'd lost my housing. So I have paid my share of the rent every month in the whole 14 years that I've lived there, except for in the beginning, I overpaid him and he worked out a deal for me to pay a little more, and I bought a Honda Spree moped from him because he actually owed me back some extra money that I had overpaid him. So no, I've never had this problem ever. My rent's always been paid. And when these issues started is when I start getting money orders because he's always asked for cash. And apparently it's never been registered as a rental, from what the city of Lacey has told me.
All right. Give me a minute. Well, actually, one other question, you know, he referenced a bunch of damages there to the house. He
Well,
talked
I've
about
lived
the
there
door and the
14
window.
years, so the
Right.
carpet is definitely damaged. Not anything beyond normal wear and tear. The kitchen counter, he told me that it was rotting around the seal when I moved in. And he told me that if I wanted him to replace that down the road, he would. Well, I never asked him to. So it's still the same damage that it's been since I moved in. Maybe a little more because it's 14 years I've been there. I haven't intentionally caused any damage. I shampooed carpets. I provided you photos of that. I made sure every room was clean. I provided you photos with that. I provided you photos of the oven. I provided you photos of the fridge. I provided you photos of the dishwasher. So everything that he's saying is a lie. And I have provided proof of that. The yard is clean. I took photos of that.
What about the door? I heard
The
about it.
front door. So that front door has been repaired 3 times by Richard. He pulls it off, he fills it in with caulking and puts it back on. I still, every winter, the caulking would separate and the cold air would come through. So we put a metal door on so that we weren't freezing cold from the air that was coming through the door, that he continued to repair instead of replace. And he repaired that door 3 times in the 14 years
So
that I
I
lived
see
there.
a heat pump outside. It's like full of pine needles and all
Yep,
that. When was
that's-
the last time that was operational?
That's what I'm talking
No,
about.
I know,
That's
I
the
mean-
heat pump that we haven't been able to use that all winter.
Did
It
that-
was, like I said, it was like the end of spring, beginning of summer, when I noticed that it wasn't working, but I mean, it was getting warm, so I really wasn't worried about it. But I mentioned it to him verbally. And normally when I tell him about things, he'll come and check it out, but he didn't. And I didn't really think anything of it because it was summer, right? But when October came and I mentioned it to him and he sort of brushed me off, that's when I figured I better start putting it in writing. So yes, it's been inoperable all last summer.
All right, give me a couple minutes. Did you ever get notice from the housing authority that they weren't going to be paying their share of the rent anymore due to the state of the property?
No, sir.
So this all just came as a surprise to you?
Say what?
This all came as a surprise to you?
It did.
And the condition of that house, again, there's a number of pictures from the exterior. You're surprised that that house was deemed unfit to rent? Because I will tell you, looking at that picture, I sure wasn't.
Well, they felt it was fine to
I'm
bring,
asking, I'm not talking about them. I'm asking about you, whether you got notice of it or.
I'm not aware of any notice, no. And
So when the housing authority wrote in that letter that they inspected and it didn't pass inspection, you were unaware of all that?
I was unaware of it. I'd like to know where my front door is and where the doors for the washer and dryer are. Like I say, I went by there this morning. The heat worked.
All right.
I was always very good to those people.
All right. I'm gonna need a couple of minutes here, so this,
okay,
we're gonna. Yes, ma'am.
If you'll notice the notices that I provided to you, because I feel like I should address this. I kind of knew that he was going to say this based on our mediation last time,
Say what?
that he didn't receive any notification and didn't know. Some of those notices I got from Kevin and the Housing Authority are the ones that are addressed to him, so that I had proof that they sent notices to him.
Right.
That's all I wanted to say.
Do you have a response to that? And did you hear what she said?
No.
About the notices?
No.
Okay, she said that she provided notices that appear to have been sent to you as well. Which it's, I will say, it surprises me that you never heard any notice from the Housing Authority. If they gave an inspection and said, these are the things wrong with it, you need to fix this, and you're saying, what are you talking about? I'm not really.
Well, like I say, I went down there to meet them and he was walking away from the house.
Okay.
And so he didn't have anything to say to me.
Okay, and you never got any sort of notice from them?
No. I'd like to say something.
Go ahead.
Well, if they felt the house was so bad to live in, my question to them is, why did they have all of these people, little kids and everything, living there with them? You know, there was several of them. I don't even know how many people were living there. There was a bunch of people living there, including a little baby. So my question is, if it was so bad, why did they let all those people live there?
Well, I think it's possible, and I'll let him answer, else he hasn't been sworn yet, I will. I think it's possible that they had no place else. And so could you raise your right hand, sir? You swear and affirm the information that you provide will be the truth, the whole truth, and nothing but the truth? Go ahead.
I did fill out.
To me, you're talking to me.
Take him a paper and he agreed to the $300 for my infant grandson to be moved in. And we had housing approve it, and he's on the housing papers. All three of our boys were on the housing and us 2 adults. So there's
Five
five adults and 1 child, 1 infant. So where he's coming up with all these umpteen billion people, he's wrong. And the water thing out there in front of the house, the spigot, I was standing right there and watched him do the whole thing. I'm in the video, and he told me that I sabotaged it. No, because the pipe that was coming out of there was a rust hole coming from the inside of the pipe out. That's why he's got a $2,500 water bill, is because he didn't fix his issue. And that's all I got to say.
Do you have a response to that?
Well, like I say, they left the water run wide open. And just to cause me problems for me. And like I say, I've been so good to those people all these years, and why they chose to do this, I don't have any idea.
Okay.
I let them slide on the rent.
So a couple things here. First of all, there's a number of issues at law here. First of all, this is an interesting case where both parties, it's not uncommon in small claims, both parties are saying, well, they're looking across the table and say, well, this person's lying, this person's lying. And I wasn't out there. I didn't, I wasn't privy to these conversations. I wasn't there when you were looking at the water pipe. I wasn't there. Never been to the place. I don't know whether the heating works great, as you say, or no, it never really worked, didn't really work right, is what you say. But with regard to, and all I can do, this was part of that speech at the beginning, is listen to both parties and kind of make sense about what's being told to me. And if you can't hear anything I say, I want you to let me know right now.
Okay.
Make sense of what's told to me, because there are certain things both of you are saying, objectively, they can't both be true. And so I kind of have to figure out things and go from there. And so, first of all, with regard to the relocation expenses, I'll make sure the Stevens are citing RCW 59-18-080 for governmental agency responsible for the enforcement of a building, housing, or other appropriate code has notified the landlord that a dwelling is condemned or unlawful to occupy due to the existence of conditions that violate applicable code statutes. And this is an important part. A landlord shall not enter into a rental agreement for the dwelling unit until the conditions are corrected. So I take that to mean that there's a condemned building and then the landlord rents it to someplace, they show up and say, hey, wait a minute, this isn't right. And so I don't necessarily think that particular statute applies in this case, but the statute that I do think applies and is going to be the basis for my ruling is, I had it up here and now I lost it. Give me a minute. Duties of the landlord. Landlord shall at all times during the, because this is a tenant, a long-term tenancy. It's been on for 14 years. And so I don't know what condition, that wasn't where you entered into an agreement into a condemned building. You were in a, you rented something 14 years ago that now has had a bunch of deficiencies in it. But again, the landlord will at all times during the tenancy keep the premises fit for human habitation, and shall in particular, and then it goes through a whole list of things, maintain the premises to substantially comply, maintain the structural components, and all kinds of stuff. And then if And in this particular case, I'm finding that the Lawrences failed to do that. And I can look and see at the, I mean, you could just look at some of these pictures. I'll be blunt with you and tell you that as I see it right now in these pictures, that house is in terrible condition. It's not rentable. It's just not. And you can blame them if you want to, or you can, but I see they did provide documentation as to where they told you these things are going on and you need to fix them. I frankly don't, I have trouble believing that they just left with the water faucet turned on. I just don't, that just doesn't make any sense to me. And combined with, again, the testimony and the pictures that have been provided. With regard to, so there's also the issue of the damage deposit, but one of the remedies in a situation like this is to refund when notice is given about certain deficiencies and they're not addressed. That affects the value of the property. It affects the value of the rent given. And so I can order to refund or a judgment in the amount of rent during the affected period. And in that regard, that's what I'm going to do here. And so I'm going to enter a judgment, which again, just a second, for the portion of rent paid for November, December, and January, 332, because I'll find that notice was given to repair the heater. I find it credible that the heater wasn't working given the state of the situation that I observed through the pictures. So it'll be 332 for, do the math on this. Three months at 332, another month at 825. And then I'm not the damage deposit. I mean, again, I don't find that was improperly held given the amount of time that you had been there combined with the state of the place as I observe it. So I'm not going to make them, I'm not going to offset that. I'm not going to order them to give that back. I'm simply going to order a judgment for the amount of the rent that you paid during the months that you would give notice and it wasn't fixed. And I'm not going to award relocation costs. But a judgment will enter in the amount of $1,821 in their favor. So you're going to owe them $1,821. And the filing fee, which is $50, you'll get that on top of it. And this is going to be one of those situations where, again, as I said at the beginning, no one's going to be happy. You're mad that I'm not giving you exactly what you're asking for. You guys are going to be mad because you're making you pay anything at all. But that's just what I'm going to do here for today. Give me just a moment and we'll give you copies of this. Did you pay a fee to get them served? Did you?
No.
Okay. So the total judgment is 1,871.
Your Honor,
Yes.
were you not going to do the heater or the clothing?
The clothing I can't do. No, is frankly, no. You know, the clothing I can't value that in terms of I need someone to come in here and say, this was lost as a result of that, and this is what the value of it is. And without that sort of evidence, I really can't do that. And the same is true for the heater. If that's a space heater, you keep it and that could still be yours. Do you still have it?
Yes.
Yeah. So, I mean, it's still yours. You still use it. So I'm not going to, you don't get a free heater. I mean, in the sense that if you got it, if you left it there or improved the place somehow, then, and like bought a new stove and left it there, then yeah, you would get for that. But if you bought the heater and you keep it and still use it, then no, I'm not awarding for that.
All right.
Does that make sense?
Yes.
Even if you disagree with it, which you might?
That's fine.
Good luck to you all.
Thank you.
How long does it take for him to have to pay us?
Well, see, that's part of that speech that I would have given at the beginning. You know, it's out of my hands now. The
Okay.
only thing you do at the end of trial is you get a piece of paper that says you have a judgment, and that's it. It's up to
Okay.
you how to collect it.
All
Part of
right.
that speech prior to mediation is, you know, the easiest part of the trial process or the legal process is getting a judgment. That's pretty easy. Turning that judgment into money is a lot tougher.
Yep.
And you're on your own for that. I
All
can't
right.
help you. For me to tell you how to go about enforcing that is giving you legal advice, and
How
I'm not in the
soon can I
advice
get
giving
a
business up here.
transcript of this so I can take it to Superior?
It gets sent to Superior Court pretty much within 24 hours. Is that correct?
We transcribe it after 30 days. and
Okay.
then mail it out.
30 days.
30 days.
Yep.
Awesome, thank you.
And there you go. Miss, you can come up. You can take it.
Thank you.
And then Mr. or Ms. Lawrence, either one of you can come up and get yours also. You can take off the hearing device and you can just leave it on the table.
I guess the question I failed to ask is, what about my front door and door for my,
You go and take a seat there. You go and take a seat. No, I'll answer that question, but you can answer down there. First of all, no counterclaim was filed as far as I can tell. So if you want to get oh, did you hear that? In order for you to get a judgment, you need to file your own suit or a counterclaim, right? And none was filed as far as I can tell. Second thing is, you know, the damage deposit, that's where, you know, you need to show that the expenses of the damages were greater than your expense, and then you're gonna be required to prove all that. But you have to bring a separate suit or do a counterclaim or something like that, and that hasn't been
30
happening.
days to do that, is that
I'm
right?
not gonna be given, I'm not in the advice given business here. You need to, you can consult with a lawyer. I can't tell you what, I'm not gonna tell them what to do about the judgment. I can't tell you what to do, how to conduct your case. So I can't give you an answer to that. Sorry.
Okay,
All right, good luck to you all. I do mean that.
okay, my last question is,
Okay.
when do I have to pay this?
That's again, I can't
Oh,
speak
okay,
to that.
all right.
That's up to you.
Okay, thank you for all your help, Judge.
Good luck.
Thank you.
Want to do those others?
Yeah, there's a stack of the cases there.
Thank you.
I'd hate to be a judge.
I'm sorry?
I'd hate to be a judge.
We're on the record, so I will say this. I do enjoy my job. You may go.
Every day in the USA, people find themselves in court.
Next case on first appearances, State of Kansas versus Mitchell, Gary Tamer, 25 CR 218. Good afternoon, Mr. Tamer. Mr. Tamer, you're charged by way of information, count 1, on or about May 10, 2025 in Butler County, Kansas, with domestic battery as to a Felicia D. Weiss. Count 2, your charge, same date and location, criminal damage to property, a door owned by a Felicia De Weiss,
Those are the only charges pending against you. Do you understand the charges?
I do.
You do have the right to counsel. If you cannot afford an attorney, one would be appointed to represent you. Are you currently employed?
Yes, sir.
And where do you work?
I work for the USPS in Andover.
United States Postal Service?
Yes, sir.
And how long have you been employed there?
5 years.
And what is your approximate income? Your hourly wage?
My hourly wage is somewhere around $29 to $30.
Court finds based on that level of income, you do not qualify for court-appointed counsel. You may retain whomever you wish to represent you herein. The court does schedule this matter before Judge Webster on the misdemeanor control docket. That would be on July 21, 2025 at 9 a.m. July 21, 2025, 9 a.m. before Judge Webster. You do need to be present by Zoom process at that time. Next item of business is to set appropriate bond for you. What is your current address?
122 North Sturgis Street, Potwin, Kansas.
How long have you lived there?
Since June of last year. Felicia DeWeese is my common law wife.
Okay. Do you have any family that reside in Butler County, Kansas?
Other than them, no. Her and my children, no.
And your children? How old are they?
Ages 2, 4, 10.
And do they also reside at that Potwin address?
Yes, sir.
Thank you, Mr. Tamer. Recommendation for bond, Mr. Regier.
Yes, Your Honor. Besides a strict no contact order, the state is recommending a cash or surety bond in the amount of $1,500. The state understands this is a defendant with little to no prior conviction history. However, pursuant to pages 1 and 2 of the affidavit, this is a case where it is alleged that the defendant grabbed the victim by the neck and struck the victim on the other side of the face while after shouting certain expletives at the victim. It is further alleged that the victim locked herself within a vehicle and the defendant kicked the door of the same vehicle, causing the framing to break, as well as law enforcement observing multiple signs of visible injury on the victim's face and neck. For those reasons, the state does respectfully submit that $1,500 cash or surety with a strict no contact order is appropriate.
Pardon me?
I have a different version of that story.
Okay. Thank you, Mr. Tamer. The court does order $1,000 cash or surety bond, $1,000 cash or surety bond, and the court does order no contact as requested by the state. Court does order no contact as requested by the state. And any other matters to come before the court, Mr. Regier?
No, Your Honor.
And Mr. Tamer? Anything further, Mr. Tamer?
I was just trying to take her keys away from her because she was drunk.
Well, that would be an admirable act if that's in fact the situation.
What happens to me now?
Well, you have a $1,000 cash or surety bond requirement. You can either post cash or you can hire a bail bondsman to act in your stead as a surety herein. And the court has ordered no contact between you and the alleged victim.
But it's my home. I don't know where else to go. I have no place else to go. She's my wife. I love her. I love my children.
Well,
I wasn't trying to hurt anybody.
I understand that. That would be, you need to make arrangements in regards to housing somewhere other than at that residence.
And I can't call her or anything?
No, you'd have to work through a third party. You'd have to work through a third party.
I'm a peaceful man. This is ridiculous. Okay, where do I go when I leave this room?
You would go, and I imagine you'd make arrangements for your bond,
I would hope so. But
and then
I don't have
after
phone
that,
numbers.
you'd be return your clothing and you'd be free to go.
I don't have any phone numbers. I have phone numbers in my personal cell phone. Am I going to be able to look at that?
I don't have your personal cell phone.
Oh, no. I don't know what the rules are.
Well, you need to go through a third party. You need to make a list of, for instance, cell phone. Need to make a inquiry through a third party to, I imagine you need to pick up your personal effects such as clothing, shoes,
I had to
that
get
sort
the
of
bond
thing.
taken care of
You
first.
go
Is
from
that
there.
correct?
Pardon me?
I have to get the bond taken care of first. Is that correct?
You do. You have to take care of the bond first. And that'd be the first step.
I don't know why they'd lie on
And Mr. Tamer, any other questions?
No, I didn't know. I didn't know I could get in trouble for forcing entry into my own door. I guess there's nothing else I can tell you, is there?
I need no further information, Mr. Tamer. Do you have any questions of me?
No. Thank you.
Yes, sir. There being nothing further to come before the court is in recess. Have a good day, Mr. Tamer. Next individual before the court for first appearances, Elizabeth. All right, the first case on first appearance docket this afternoon, State of Kansas versus Colton McClure, 25 CR 17. Good afternoon, Mr. McClure.
Good afternoon, Your Honor.
You're charged by way of information in count 1 on or about May 12, 2025 in Butler County, Kansas, with domestic battery, a Class B person misdemeanor. This was allegedly as to Kevin McClure. You're charged in count 2, same date and location, interference with law enforcement, Class A non-person misdemeanor. Those are the charges pending against you. Do you understand the charges?
Yes, Your Honor.
You do have the right to counsel if you cannot afford an attorney. One would be appointed to represent you. Are you currently employed?
No, Your Honor, I'm not.
How long has it been since you were?
It's been since November of 2024. I'm currently going through some mental health issues, and I'm trying to get on the right track so I can get back to work and actually commit to a job.
Do you have any savings to hire an attorney?
So I donate plasma twice a week. That's pretty much my income. It's about $125 a week.
Court finds that you do not have the financial wherewithal to retain counsel. Therefore, the court does appoint Darren Patterson to represent you at all stages of the proceedings. Darren Patterson is appointed to represent you at all stages of the proceedings. The court sets your next appearance date by Zoom process on Monday, July 20, 2025 at 8 a.m. before Judge Webster. Monday, July 21, 2025, 8 a.m. before Judge Webster. You do need to appear by Zoom process at that time. Subsequently, the court does need to set a bond for you. And what is your current address, Mr. McClure?
Thank you. It's going to be 633 South Rutan Avenue in Wichita, Kansas.
And how long have you lived there?
Since February of 2023.
All right. And do you have any contacts, family that reside in Butler County, Kansas?
Yes, my parents both live here. Jolene Nash or Kevin McClure.
Thank you, Mr. McClure. And recommendation for bond, Mr. Regier?
Your Honor, if the court is prepared to order a strict no contact order with respect to the victim, the state is prepared to recommend a cash or surety bond in the amount of $1,500. The state understands that this is a case where where it is alleged that the defendant punched the victim in the face, as well as choked the victim to the point of the victim being unable to breathe. However, this is a defendant who the state understands has little to no prior conviction history. Therefore, that is the basis of the request. It would also appear that when law enforcement was dispatched to the site of the alleged incident, the defendant admitted to the altercation when questioned by law enforcement.
Thank you, Mr. Regier. The court does find that surety bond is appropriate. Court does order $1,000 cash or surety bond, $1,000 cash or surety bond herein. And the court once again does adopt the no contact order as requested by the state. No contact order as requested by the state. And Mr. McClure, do you have any questions?
Yeah, so I mean, I've never been arrested before, so I'm not exactly sure how bond works. Do I have to pay that whole $1,000 or just a percentage of that? Is that something you guys could tell me, or?
Well, that is a contractual matter between you and a bail bondsman.
Okay.
Typically, they ask for 10% of the amount of the bond that's being written. I've ordered $1,000 cash or surety bond. So you may either post cash of $1,000 or obtain the services of a bondsman to meet the cash or surety bond requirement.
Okay, thank you, Your Honor.
Anything further, Mr. Regier?
No, Your Honor.
There being nothing further to come before the court, court is in recess. Have a good day, Mr. McClure.
Hey, you as well.
Just wait for them.
And good afternoon, Mr. Velasquez. This case is entitled State of Kansas versus Randall Rene Velasquez Jr., 23 TR 3180. Mr. Velasquez, you are charged by way of information on or about September 29, 2023 in Butler County, Kansas with expired tag, an unclassified non-person misdemeanor. That is the only charge pending against you. Do you understand the charge?
Yes, sir.
You do have the right to counsel if you cannot afford an attorney. One would be appointed to represent you. Are you currently employed?
Yes, sir, I am.
Where do you work and what is your hourly rate of compensation? And are you full-time employed?
Yes, sir. I am a contractor working for Launch Technical Work Services, contracted to Spirit Aero Systems. I currently make $37 per hour and I am full-time.
Court finds you do not qualify for court-appointed counsel. You may retain whomever you wish to represent yourself. The court does schedule this matter before Judge Webster on Monday, July 21, 2025 at 9 a.m. by Zoom. Monday, July 21, 2025, 9 a.m. by Zoom. You do need to be present by the Zoom process at that time.
Yes, sir.
Next item of business is to set appropriate bond. I show that it appears on January 24 and February 26. There was initially a cash or surety bond ordered. Then there was a no bond hold ordered. Recommendation for bond at this point, Mr. Regier.
Yes, Your Honor, this is a case where it would appear that there were two consecutive failures to appear on January 24th of 2024 and February 26th, 2025. So this case is getting some significant age to it. This is a defendant who the state does consider a significant flight risk. It would appear that pursuant to the summons, after trying to serve the defendant at the last known address, the processor specifically noted, quote, move to Arizona, NFA, which I would interpret to mean no forwarding address. Conversely, the bond previously executed for an appearance on February 26, 2025 would appear to refer to the defendant out of with an address out of another jurisdiction. Therefore, the state does consider this defendant a significant flight risk. The state is not in a position to counsel the court to overturn the prior orders initiated in this case. However, if the court is prepared to take up that issue, the state will request the opportunity to be heard as to an appropriate amount.
May I speak?
The court anticipates modifying the no bond hold. Please proceed with state recommendation, Mr. Regier.
Your Honor, if the court is prepared to take up the issue of bond modification, the state would be recommending a high bond of at least $3,000 professional surety. While the state does acknowledge the level of the charges currently before the court, besides prior failures to appear, this is a defendant who the state understands may have prior convictions out of other jurisdictions. So the state would be recommending at the very least $3,000, and the state would be further recommending a professional surety only bond.
Thank you, Mr. Regier. And further input in regards to appropriate bond, Mr. Velasquez?
Thank you for the opportunity to speak, Your Honor. When the initial stop happened in September of, I forgot what year, I believe it was 23, and then 24, I missed the court date. I actually was contracting at Spirit as well, and I ended up going to, I did leave then before that court date, Boeing San Antonio. I was actually working on the executive program, so I do know that the district attorney did speak on, other jurisdictions. I did hold a security clearance previously. I do have a permanent address here in Kansas, 412 Rudy, which I gave the Andover police officer when he stopped me. And I also told him right away when he stopped me that I may have a warrant. I did miss this court date because my wife got in an accident in San Antonio, Texas, which is what the jurisdiction was on the original, on the new bond paperwork I put up for myself. She totaled out her 23 Armada, so I did leave, totally forgot about it. When I got back to Kansas, which would be probably early March, I did call, and the court told me I needed to call the jail. The jail transferred me to a lady. They said she was off Mondays and Fridays, but I left her a message. I was trying to get it taken care of. I went online trying to get it taken care of. It said it found my court case, but it wasn't able to be taken care of online to contact the courts. I do have a permanent address. I literally spent all my money yesterday on Mother's Day, so I don't get paid till Thursday. My wife doesn't even have a card. She doesn't, I can't even call her. Not all that's irrelevant, but I do have a permanent residence here, and I have Evergy, I have the Kansas gas bill, all that good stuff, sir. I literally will pay you guys on Thursday. I mean, I don't know what else to do at this point. For the bond issue, I would like to be released just so I can go to work tomorrow. I work 90 hours a week, 80 hours. That sounds like a lot. I do 12s, 17 hours a day. They don't let us go over 20. That's my piece. I don't have anything else to say, sir.
Thank you, Mr. Velasquez. The court does order a cash or surety bond, but in the amount of $1,500, $1,500 cash or surety bond. And it sounds like that you are a very high earner with more than full-time employment. So I think you'd be able to negotiate with a bail bondsman to assist you in making your bond herein.
And
yes.
Oh, I was gonna say, I do completely agree with that. The gentleman in the pod here, it's my first time here. He did say that he thought I would have a hard time getting through to the bonds people with a collect call. And I don't have any way to get anyone else on the phone to call them for me. So that's just the reason why I'm freaking out here. I can definitely take care of the money part if I can get them on the phone. So
Court does order the jail to provide Mr. Velasquez with the ability to contact the bail bondsman of his choice for purposes of making bond.
thank you, Your Honor. Thank you.
There being nothing further to come before the court is in recess.
Thank you, sir.
Have a good day.
Thank you.
Mr. Nelson, at this point in time, there have been no charges filed against you. Subsequently, unless there are other holds on you by other jurisdictions or this jurisdiction, you'll be returned your civilian clothing. You'll be free to go.
And Your Honor?
Yes, Mr. Regier.
Your Honor, this is a case which has only recently been brought to my office's attention. The state would request that this matter be set over to the Wednesday first appearance docket.
And the court does schedule this matter for Wednesday by Zoom process at 1:30. Wednesday, 1:30 by Zoom. And the jail can provide you with the links in order to participate by Zoom process Wednesday, May 14, 2025 at 1:30. And Mr. Nelson, do you have any questions about that?
So it has been a very eye-opening week or two at this point. And currently, I was wondering if I could go on maybe a 5-6 month sabbatical and get in shape. And then whenever I come back, I would be able to be sworn in, or if I had to go through this again, I'd be fine with that. But at this point, my body is fairly broken from the battles, and I don't want to go ahead and make it worse early on. And I want to make sure that when I get in, I am as healthy as I can possibly be to be the best I can be. Because I had a standard set for myself, and I realized that through this, my standard was not high enough. But I do believe within 5-6 months, I will have that standard up and past where I expected it to be.
Thank you, Mr. Nelson. You do need to participate in first appearance this coming Wednesday, May 14, 2025 at 1:30 by Zoom.
All right.
And at this point in time, unless there are holds on you by other jurisdictions, you're free to go. Have a good day.
Thank you very much, sir. You as well.
And Vincent Moore.
Yes.
Good afternoon, Mr. Moore.
Good afternoon. Sorry I was having so much trouble getting logged in. I ain't never did this Zoom thing before.
Well, you've made it. You're appearing by way of summons at this time, Mr. Moore. Mr. Moore, you are charged by way of information on or about June 4, 2024 in Butler County, Kansas with possession of cocaine, a level 5 drug felony. Count 2, same date, location, no proof of insurance, class B, non-person misdemeanor. Count 3, same date and location, driving while license is suspended or canceled, class B, non-person misdemeanor. Those are the charges pending against you. Do you understand the charges?
Yes, sir.
Do you have the right to counsel? If you cannot afford an attorney, one would be appointed to represent you. Are you
I do.
currently employed?
No, sir, I'm not. I get disability. So I need
Okay.
I need a counsel for, I need counseling.
Court finds that you do not have the financial wherewithal to retain an attorney. Therefore, the court does appoint Jim Watts to represent you at all stages of the proceedings. Jim Watts is appointed to represent you at all stages of the proceedings. The court does schedule your next appearance on the felony preliminary hearing control docket. That would be on Monday, June 16, 2025 at 2:30 before
Monday,
Judge Crum. Monday, June 16, 2025, 2:30 before Judge Crum. You do need to be by Zoom process at that time. You've already made your bond herein, and the court finds that, well, excuse me, recommendation for bond after appearance by Mr. Moore.
Your Honor, besides the booking and processing, as this would appear to be required, as count one of the information does appear to allege a felony. This is a defendant who it appears is appearing pursuant to summons. I'm showing a summons for today's date and time, May 12th, 2025 at 1:30 p.m. was filed with the court previously on February 6th, 2025. With that being said, the state is not opposed to an own recognizance bond being ordered in this matter. If the court will order all standard conditions with special emphasis on no contact with illegal drugs, which would appear particularly relevant given the charges currently before the court. The state, as far as an amount for an own recognizance bond, the state is recommending a high amount of $15,000. This is a defendant with at least 3 prior failures to appear, as well as a somewhat unusual history of convictions as the state understands it. Besides 2 prior convictions for misdemeanor possession of a hallucinogenic, as well as misdemeanor possession of a stimulated controlled substance, and 3 misdemeanor possession of a depressant. This is a defendant who the state understands has at least 4 prior felony convictions for possession of opiates, 2 prior convictions for felony sale of opiates, 4 felony convictions for no drug tax stamp, at least 8 traffic misdemeanors, at least 2 felony property related convictions, and at least 1 felony person related conviction. So with all that being said, the state does respectfully submit that $15,000 is an appropriate amount.
And the court does order a $10,000 OR bond, $10,000 OR bond. And the court will make inquiry to court security as to date and time for Mr. Moore to appear for booking and processing.
If we just want to put us in a breakout room, Your Honor, I'll get them set up.
Very well. We'll put you into a breakout room immediately after the hearing. And any other matters to come, Miss Al?
I'm, what was his complete name?
I have down his name is Vincent Moore, Moore.
Okay.
Okay, y'all going too fast. It's $10,000 surety bond.
Your $10,000 OR bond, 10,000 OR bond.
Okay.
And the
So I don't
court
need nothing
does,
about that.
Pardon me?
Okay, and June 16th at 2:30?
You're scheduled next before Judge Crum on Monday, June 16, 2025 at 2:30 before Judge Crum. You do need to
Crown,
participate by Zoom process at that time.
Okay.
Immediately after this hearing, you're into a breakout room with court security in regards to the particulars. Anything further, Mr. Regier?
Okay, so I need to get booked in and then booked back out. What is
We're
is
going
that
to
the
take care of
breakout room?
that by Zoom process immediately here in Mr. Moore. Anything
Okay,
further, Mr. Regier?
Not at this time, Judge.
Court is in recess. We'll put you into a breakout room with Mr. With Jarrett.
Okay.
That's the final case on first appearance.
Every day in the USA, people find themselves in court.
We will go on the record in the matters 25 CM 22 and 23, State of Wisconsin versus Zachary Newell. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Newell in person with counsel Daniel Chapman. We're set today in these matters for a plea and sentencing. Mr. Chapman, can you please provide the agreement on the record?
Judge, Mr. Newell will be pleading to count 1 in 25 CM 22. That would be knowingly violating a restraining order. There's a joint recommendation for time served and court costs. I believe he has 30 days credit.
All right, is that
The
stipulated?
other
to?
case is being dismissed and read in.
That's what I calculated too.
All right. Mr. Newell, that's the agreement you've reached?
Yes,
I have in front of me a plea questionnaire waiver of rights form. Do you recognize that document?
yes,
Did your attorney go over that document with you?
yes, ma'am.
Did he go over it thoroughly with you?
Yes,
You understand everything on this document?
I do.
And if you didn't understand something, he did explain it to you?
Yes,
And that's your signature on the second page?
it is.
You're pleading guilty to one count of knowingly violating a domestic abuse temporary restraining order. Is that correct?
Correct.
You are 32 years old. You have 12 plus years of schooling. You can read, write, and you understand the English language.
Yes,
Your attorney went over with you what the state would have to prove your guilt beyond a reasonable doubt, as well as the maximum possible penalties you face.
yes,
No mental illnesses or disorders, no drugs, alcohol, or medications.
no,
Your attorney went over your constitutional rights with you. Is that correct?
yes,
Do you need me to go over those rights with you in any more detail?
no, Your Honor.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes, I understand.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Okay,
Do you understand that?
I understand, yeah.
Do you understand that here, the state would have to prove on or around January 26, 2025 in Burnett County, Wisconsin, you knowingly violated a temporary restraining order ordering you to refrain from committing acts of domestic abuse against the petitioner to avoid the petitioner's residence, except as provided in paragraph AM or any other location temporarily occupied by the petitioner or both, or to avoid contacting or causing any person other than a party's attorney or a law enforcement officer to contact the petitioner unless the petitioner consents to that contact in writing or any combination of these remedies requested in the petition or any other appropriate remedy not inconsistent with the remedies requested in the petition. Do you understand what the state would have to prove?
Yes.
You understand that upon conviction, you do face a fine of up to $10,000 or imprisonment of up to 9 months of incarceration, or both?
Yes.
Do you understand that the recommendation here is for 30 days of jail plus court costs and fees?
Yes.
You understand, I'm not bound to follow that, meaning I could sentence you all the way to the maximum possible penalty if I thought it was warranted.
Yes, I understand.
Do you still wish to proceed and enter a guilty plea?
Yes.
Did your attorney go over that criminal complaint in the probable cause section where it basically says what happened and why you were charged with the crime?
Yes.
For the most part, are the facts accurate?
Yes.
Are you admitting here today that you did in fact knowingly violate the domestic abuse temporary restraining order?
Yes.
Mr. Chapman, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to this charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing today
Yes.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes. Yes.
Has he looked at this matter thoroughly?
Yes.
You're satisfied with his services?
Yes.
Any questions for the court or for your attorney before we proceed?
No.
As to the sole count in 25 CM 22, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of that sole count. The other case will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Thank
First,
you.
are we in victims' rights compliance?
Yes. Thank you, Judge. The core problem here, Mr. Newell needs to stop messaging the victim. That's what the contacts have been. She's told him no, she's gotten the restraining order. I believe for one of these, it was the temporary restraining order. The restraining order is fully granted now. I think that 30 days jail is a lot for somebody doing just messages over the phone. I think it's appropriate in this case. I think that that will communicate to Mr. Newell that if he continues to contact her in the future by phone, it's going to result in jail. Thank you.
Not an assessment, just regular, started them up again.
Okay.
All right, Mr. Chapman.
Judge, there was a messy breakup here, and as Mr. Newell told the cops, he just kind of lost it when she started accusing him of things, and he was upset. He sent a whole bunch of text messages in a row. I don't believe there's been any contact in a decent amount of time now, and I think the relationship is over. He did tell me that he went to alcohol and drug counseling through Aurora since this case has been charged. I think given the fact that the restraining order is in place and he did a month of jail, I think that's an appropriate resolution for this crime. He does have a prior deferred agreement in 2019 and a meth conviction in 2022 that he successfully completed probation for.
All right, thank you. Mr. Newell, is there anything you want to add or you want to state today?
No, Your Honor.
Okay, thank you. This is a more serious case in the fact that it is a temporary restraining order in which an individual went to a court and asked that you stop contacting, you stop having any contact with her, and you violated that temporary restraining order. So it does make it more serious, and especially because it's a domestic restraining order. You did sit a significant amount of jail, and I'm hoping that that was enough time for you to think about your actions, and I think you have.
Yeah.
And you understand that if you do it again, there could be even more severe consequences that you face. There is absolutely no contact with the individual in any way, shape, or form, not even through a third party.
Understood.
Unless it's through that individual's attorney or from your attorney to her attorney. I do believe that this is an appropriate resolution. Even had you not sat the jail up front, this most likely would have been the resolution, but you ended up sitting the jail up front. So you already have that sanction done. I believe that in all respects, the individual is protected. There is now an injunction, a permanent restraining order, and there won't be contact, and you have been punished. So the court will follow the recommendation, 30 days of jail, court costs and fees in the amount of $500. You have that posted. You are good to go. This is a time served. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I do need to order your DNA. Once you're done here, you'll go to the sheriff's department, you'll provide your DNA.
Okay.
And once you're done there, you are free to go. You have the ability to request it be expunged through a written letter to the Department of Justice. That's who you ask, not this court or this county, through the Wisconsin Department of Justice.
Okay.
I believe that covers everything, Mr. Schmidt,
Nothing for me.
Mr. Chapman.
Nothing else, Judge.
All right. Good luck, Mr. Newell.
Thank you.
We will go on the record in the matter 24 FA 55, in re the marriage of Eugene McFeeders and Heather McFeeders. Appearances are, we have appearing in person, Eugene McFeeders without counsel. We have by video conferencing with approval of the court, Heather McFeeders and counsel Ann Schmiege. We're set today in this matter for a contested divorce hearing. We have I'm pulling up the summons and petition at this time. This is a contested divorce without minor children. Mr. McFeeders, it appears that you are the filing individual. You filed this matter. I have a marital settlement agreement in front of me. I'm going to turn to Ms. Schmiege. Can you update me on this matter, and are all issues resolved?
Most issues are resolved, Your Honor. I've gone back and forth between the parties over the last number of weeks. My understanding is that all of the issues are resolved with the exception of a couple of personal property issues. The marital settlement agreement was drafted. It's gone back and forth, and there've been a couple of different revisions to it. And most recently was sent back to Mr. McFeeders end of last week. My understanding is that, and he can speak to that, but that the parties are essentially in agreement, save for under the property division. There's a couple of minor contested issues on personal property, specifically Ms. McFeeders has a list, and that's Exhibit 2 of personal property that she will pick up. Mr. McFeeders agrees on everything except the riding lawnmower. So I think that's a contested issue. And then I don't know whether or not Mr. McFeeders is okay with the pickup times. We had changed it a couple times. I think he's okay with it now, but he would need to confirm that.
All right. So Mr. McFeeders, with regards to all issues and all matters, minus the riding lawnmower, do you believe that you've reached an agreement with Mrs. McFeeders?
I believe so. I'm not really in agreement with me not being able to be at the house while she's there picking stuff up. I believe I have a right to be there.
Okay, okay, so that's an issue too?
Mhm.
Okay.
Both of her brothers will be there. There won't be any argument. I want this done and over with just as bad as she does.
But everything else that is in this marital settlement agreement?
Yes. Now, there is a $60,000 SBA loan through the business that we own. I would like that to be paid from the sale of the house. I understand they've got it in the agreement that we're both responsible for half. But so nobody's got to worry about it. It should be paid from the sale of the house. And that way there's no way it's going to come back on me totally.
And so I have a copy of Exhibit 1, Ms. Schmiege, but it's not signed. So you don't have a signed marital settlement agreement?
No, not
No,
yet.
there's never been a signed one. I submitted Exhibit 1 so that we would have something in writing to go through with the parties. And what I would ask is that with any modifications to the marital settlement agreement, is that essentially it be incorporated into the findings, either by way of me drafting bringing the provisions over from the marital settlement agreement into the findings after the fact, or that it be attached as an exhibit to the findings. But the marital settlement agreement, as indicated, the parties are in agreement except for the personal property, the riding lawnmower, and the pickup provisions. And then with regard to the SBA loan, Ms. McFeeders indicates she's working with the accountant because the parties may be able to get that debt reduced. They may be able to negotiate and reduce it. And so she doesn't want to commit to simply paying it off with the proceeds of the sale of the home, because it may be that the parties can pay less than the full amount on it. But in any event, they would be equally responsible, and, there's hold harmless provisions and everything in here.
All right. Okay. So what I'm going to do is I'm going to have both Mrs. McFeeders and Mr. McFeeders, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. Even though you filed for the divorce, Mr. McFeeders, you're not represented, so I'm going to have Ms. Schmiege start with the questioning. So she's going to call her client and ask the questioning, and then just the basics of the divorce, and then get the basics out for what's being agreed to, and then we'll move on to you, and you can provide your testimony and your answers, and then we'll go from there.
Okay.
Ms. Schmiege, you may proceed.
Okay, thank you, Judge. Ms. McFeeders, please state your full name and address.
Heather Michelle McFeeders, 1015 West 10th Street, Coffeyville, Kansas, 69339.
Did you have an opportunity to review the petition that Mr. McFeeders filed at the time that he filed it?
It was not presented to me. I got to see it through the court docket.
Okay.
So yes.
And since that time, have you reviewed it?
Yes.
And was the information that was in that petition true and accurate at the time it was filed?
Correct.
Okay. Are you in good health?
Yes.
Are you a member of the armed forces?
No.
Do you believe that your marriage to Mr. McFeeders is irretrievably broken?
Yes.
Are you currently pregnant?
No.
You completed a financial disclosure statement that was filed on November 6th of 2024. Have there been any significant changes other than minor bank account balance changes and that sort of thing since November 2024?
No.
And your only income at this time consists of sales proceeds that you're receiving, that you, Mr. McFeeders, had owned a business, Yellow River Saloon. It was sold. You and he are each receiving $354.83 a month. Is that correct?
Correct.
And that's your only income at this time?
Correct.
And in terms of paying your monthly expenses, how do you manage that with your income?
My brother helps me out. My brother, Rick, helps me out.
Okay. Is there any reason why you can't work right now?
No.
So you have the ability to work. You're just taking a break at this time. Is that correct?
Correct.
You and Mr. McFeeders haven't entered into a marital settlement agreement, but we've prepared one and it's gone back and forth multiple times between the two of you. Is that correct?
Correct.
And do you agree with my statement to the court that you and he basically have an agreement on the vast majority of issues, but there's the issue about the SBA loan, and then there's some minor issues with regard to personal property, correct?
Correct.
And with regard to maintenance, you and Mr. McFeeders are both waiving any claim you may have against the other party for maintenance. Is that right?
Correct.
And you're doing that even though at this time you have no income, correct?
Correct.
Do you believe without maintenance, between the proceeds that you get from Yellow River Saloon and the help from your brother, right now you're able to meet your monthly expenses, correct?
Correct.
And if you chose to do so, you're capable of returning to the workforce. Is that right?
Yes.
Okay. And so you're capable of supporting yourself. Is that right?
Yes.
And you understand that your maintenance waiver is final. You can't come back into court in the future and ask Mr. McFeeders for maintenance at any point in time.
Correct, yes.
With regard to property division, the main asset that the two of you own is a residence in Siren. Is that correct?
Correct.
And Mr. McFeeders has been living there during the pendency of this divorce. Is that right?
Yes, correct.
You and he have both agreed to immediately list the property for sale with Christina Whitaker with Edina Realty. You're both going to cooperate and make sure it's listed by the end of the month, and cooperate in terms of communications and staying on top of any communications with Ms. Whitaker. Is that right?
Correct.
You understand until the house is sold, Mr. McFeeders will have possession of the house.
Yes, correct.
And he's to maintain it and take care of the monthly expenses and any minor repairs. But you understand if there's major repairs or improvements that need to be done to the house to get it sold, you and he will be equally responsible for any of those agreed upon repairs, correct?
Yes, correct.
With regard to the other property, you and he are each keeping any bank accounts in your name. He's keeping his retirement accounts and life insurance in his name, which are fairly minor. He's receiving the Chevy Blazer and the Pontiac. You're receiving the GMC Yukon and Harley. Have those vehicles already been divided? In other words, you have the vehicles you're keeping, he has the vehicles he's keeping.
Yes, and he also has a boat, a 96 Lund boat also.
Okay, that he'll be retaining.
Yes.
And then you're each receiving one half of the interest that you have in the Yellow River Saloon, and that's the monthly payment that you're receiving, correct?
Correct.
And the SBA loan that's associated with that business, you understand you're both in some capacity going to be equally responsible for that. Is that right?
Correct.
And you heard Mr. McFeeders indicate he wants to get it taken care of out of the sales proceeds from the house. You don't agree with that approach, correct?
Correct, I do not.
And can you explain to the court why?
Because I'm dealing with the accountant right now that we are hoping that there is a decrease in the amount that is owed, or it could be written off altogether.
Will you continue to work with the accountant, you know, and use good faith efforts to get that resolved in one way or the other as soon as possible?
Yes.
And you understand if the issue hasn't been resolved before the house sells and you and Mr. McFeeders are each responsible for half that debt, you have an obligation to make sure you're paying your half, either making payments on it or paying it outright, so that Mr. McFeeders doesn't somehow end up paying the bill on that, correct?
Correct.
And then with regard to the marital residence, once it sells, the net proceeds would be divided equally between the two of you. Is that right?
Correct.
Okay. With regard to the personal property, you have Exhibit 2 as an email that you sent to me. That's essentially the personal property that you want to pick up at the house, correct?
Correct.
And it's your understanding that Mr. McFeeders agrees on all of those items except the Craftsman riding lawnmower. You'd like to retain that, is that correct?
Correct.
First of all, how did you acquire the Craftsman riding lawnmower?
My grandfather's inheritance money.
Okay, when did you receive that?
April 14th, 2017.
And when did you buy the Craftsman lawnmower?
It was either May or June of that same year, 2017.
How much was the inheritance that you received?
$40,000.
And what was the balance of it used for?
We bought the riding lawnmower, the push mower. I paid off his motorcycle, and it went to other bills such as credit cards and other things like that.
Okay. And what was the cost of the riding lawnmower?
I don't remember, honestly. It was It was under 6,000, I think.
You understand that Mr. McFeeders is responsible for maintaining the marital residence until it's sold. Do you have a proposal in terms of when you would pick up the riding lawnmower that would allow him to retain it until that property is sold?
Yes, I would. Yes, I wanted him to use it. That would have been something we discussed. It would have been him using them till the house sold because the yard needs to be taken care of. Yes.
With regard to the pickup of the property, how did we come up with the times that we have in here in terms of your proposal is that on May 19th, you would come to the house between 11 a.m. and 3 p.m. and again from 7 p.m. until midnight, and again on May 20th if necessary. And that Mr. McFeeders would vacate the premises during those times, except that he could be at the house between 11 and 3 while you moved your items from the garage. What is the reason that you want him to vacate the house, first of all?
I don't want any trouble. I don't want him like causing problems, like staring at me, yelling at me, talking to me. Like I want him in and get out, but that's the whole thing. Like I just want in and out.
There's language in here about you can bring your brother Rick, and the petitioner can have arranged to have your brother Eric be there. Do you think that Rick and Eric will make sure that if you go there without Mr. McFeeders being present, that you're not taking anything you're not supposed to be taking and acting appropriately with regard to the house?
Yes, I believe that would be just fine.
And the idea, he'll be at the house, he works third shift, correct?
Correct.
And so he would likely be at the house sleeping during the daytime pickup on Monday. And at that point, you plan on just going into the garage to get the items in the garage, not into the house. Is that right?
Correct. He should be sleeping about that time, I would assume. So.
Okay. And you just want to kind of stay out of each other's hair, essentially.
Correct.
Okay. Other than the SBA loan, you understand you and Mr. McFeeders are both responsible for any debts that you have, correct?
Correct.
And you have, the debt that you have is as listed in, under the property division, that you have a GMC Yukon subject to the debt thereon. You're responsible for that Yukon debt, is that right?
Yes.
You have you filed your 2024 taxes already?
Yes.
Okay. You understand for 2025, you and Mr. McFeeders will be divorced. You'll file separately without claiming any income from the other party, correct?
Yes, correct.
And you understand you're both responsible for your own health insurance and uninsured medical expenses going forward. Is that right? As well as you'll be responsible for my attorney fees.
Yes.
Okay. Do you believe that the terms of this marital settlement agreement, it hasn't been signed, but do you believe that the terms of the agreement as drafted are fair and reasonable?
Yes.
And you're asking that the court incorporate the terms of the agreement that we drafted, as well as the list that's in Exhibit 2, the list of personal property, that be incorporated into her findings. Is that right?
Yes, correct.
Okay. I don't have any further questions for Ms. McFeeders, Your Honor.
All right, thank you. Mr. McFeeders, you have an ability now to ask Mrs. McFeeders any questions that you wish to ask, if you have any.
It says on her financial statement that she's living with her brother and that he's paying her bills. There is a recorded phone conversation.
Again, this is only your time to ask her questions.
Okay. Why would you lie about that?
Lie about what?
Your financial disclosure and Rick paying all your bills.
It's not a lie.
Okay. Fine.
Any other questions? Okay. All right. Any other witnesses, Ms. Schmege?
No, Judge.
Mr. McFeeders, I'm now going to ask you some basic questions. And then you can provide with some information, opportunity to ask you questions too. You heard the testimony of, well, first, your name is Eugene McFeeders, correct?
Correct.
What is your date of birth?
3/28/70.
And when were you married?
2014.
No, that's
And-
incorrect, Your Honor.
All right,
It's
Ms.
2012.
McFeeders, Ms. McFeeders, you
Oh.
can't answer the questions and you
Sorry.
can't speak. It's his time.
It was 8/31/21,
Okay. All right,
or 12, sorry.
all right. And when were you separated?
She left the state in May of last year.
Okay. And did you, before you filed for divorce, did you live in Wisconsin at least 6 months prior to filing?
Yes,
And did you live in Burnett County at least 30 days prior to filing?
yes.
And you properly served Ms. McFeeders?
I tried to have her serve all except for publicly.
Okay,
'Cause-
but obviously she knows about this. She has an attorney. and She
Right.
accepted service.
Yeah,
And there's no other legal actions affecting this marriage in any other jurisdiction?
not that I'm aware of.
Are you in the military service?
No, I'm not.
Are you able to work or do you have a disability where you're not able to work?
Nope, I work full time.
Okay. And do you believe that the marriage is irretrievably broken?
Absolutely.
And you heard that in Ms. McFeeder's testimony that she is waiving maintenance, which is formerly known as alimony. And are you doing the same?
Yes,
And do you understand that once you waive maintenance, it's forever and you can't come back to court and say, you know what, I've changed my mind? Do
correct.
you understand that if Ms. McFeeders goes out to a gas station right after this hearing and she purchases a lottery ticket, she wins $1 million, you would not be entitled to any of that. Do you understand?
Yes, I do.
And so you're waiving that, their ability to seek maintenance freely and intelligently and voluntarily?
Yes,
And you heard testimony from Ms. McFeeders as it relates to certain property. All property that she testified to, except for the riding lawnmower, you're in agreement with her receiving, is that
Yes.
correct? You just have some contention with that riding lawnmower?
we'll go with her story. Once a house sells, she can have it. I don't care.
Okay, so you no longer contest the riding lawnmower. And as it relates to that SBA loan, do you care if it's the full 60,000 or would you rather have it reduced?
Well, I'd rather have it reduced, but I talked to the accountant twice last week and he said that she hasn't talked to him about it.
But but you would like to have the SBA loan paid out of the proceeds of any sale of the home?
I would, yes. That way nobody's got to deal with anything later.
Anything else you want to add on that?
No,
What other debts of the marriage are there?
we've got the house and that should be it.
No credit cards?
Most of those are gone already.
All right, Ms. Schmiege, questions?
Mr. McFeeders, did you have an opportunity to go through the marital settlement agreement that I sent you late last week?
Yes,
And other than your comments about the SBA loan and about you wanting to be present at the personal property exchange, were you in agreement with all of the other provisions?
yes,
And you understand with regard to the house, because you're living in the house, it'll be your responsibility to make sure it's kept tidy and in a condition that's appropriate to show to potential buyers, correct?
correct.
And you agree to work with Christina Whitaker and cooperate to make sure that the house is listed by the end of this month, is that right?
Yes,
And you'll also cooperate by responding to any communication from Ms. Whitaker within 24 hours, as well as signing whatever necessary paperwork is required within 24 hours. Is that correct?
Yes,
Okay. And while until the house is actually sold, you'll have possession of the house, and you're responsible for making the mortgage payments and property tax payments and keeping insurance on it. You understand that?
yes,
And then you'll be responsible for any normal maintenance and repairs. If there's anything major, any major improvements that need to be done or repairs that need to be done, you'll communicate that with Ms. McFeeders, and the two of you will share the cost of any agreed upon repairs and improvements. You understand that as well?
yes.
Do you agree with Ms. McFeeders that if her two brothers are present at the pickup, Rick and Eric, that they'll make sure that there's no funny business and that she's not removing anything she's not supposed to be removing?
I would think they would, but they don't know what belonged to my parents, my grandparents.
Okay, what is it that you're worried about her taking?
Things that have been passed down in my family for years.
I have a question. If something were to be removed that is not a part of the list of the property that she's taking, would you know? Would that stand out to you?
Yes,
Do you understand? I just want to make sure, do you understand that you could bring that matter into court for contempt?
okay.
Okay,
All
so you
right.
understand that?
I understand that now. Thank you.
All right, so does that ease your mind a little bit?
Yes,
Okay, thank you. All right, Ms. Schmiege, you may continue.
Thank you. So as long as Ms. McFeeder sticks to the list here and her two brothers, I know you prefer to have Eric there to oversee as well. Her two brothers are present at her pickup. Are you comfortable with the way we have it in here as far as the property pickup?
yes.
Okay. I don't have any other further questions, Your Honor.
All right, thank you. Mr. McFeeders, anything else you want to let me know?
No.
Right. All right, anything else, Ms. Schmiege?
No, Judge, I don't think so.
Okay. Well, I have heard the testimony from the parties here today. As to exhibits 1 and 2, I will receive those exhibits. Exhibit 1 would be demonstrative only. As to the financial disclosure statements filed by both sides, I will receive those as well. I believe all necessary residential and jurisdictional requirements have been met and the applicable waiting period has lapsed. The court will find that the marriage between Eugene McFeeders and Heather McFeeders is irretrievably broken and there's no chance of reconciliation. The court will find that the waiver of maintenance by both parties has been done freely and voluntarily and has been done intelligently, that they both understand the nature and the purpose of the award of maintenance and the finality of their decision here today to waive maintenance. The court will adopt the agreement of the parties as stated on the record as it relates to the property and the debt of the parties, and find that the agreement is approximately a 50-50 division of the parties' assets. The court, as it relates to the pickup times, the court will state that as long as if that Mr. McFeeders will not be at the exchange or the property pickup when Mrs. McFeeders will be in the home, as long as Eric is present and her other brother is present, but in particular Eric, Mr. McFeeders understands that if he notices anything is missing of his property that is not on the list, he has court action that he can can take Ms. McFeeders to court for violating the agreement. The court will adopt Exhibit 2 and will order that all assets on and property listed on this will be Mrs. McFeeders' property, including the riding lawnmower, but that Mr. McFeeders will have the ability to use that riding lawnmower. And if Ms. McFeeders is in agreement as well, the push lawnmower until the sale of the home is completed. The court will order that both parties will share equally in the debt of the SBA loan. It is currently approximately $60,000, give or take. Ms. McFeeders is in the process of working to have that loan hopefully reduced or waived altogether. However, the court is going to put the statement in that upon the sale of the home, $60,000 will go into an escrow after the sale of the home to go towards the payment of the SBA loan. If the parties are able to reduce that loan and get some of it or all of it waived, then at least that money will be there to pay off equally what each party it will be responsible for, and then they will have to share any other remaining property or remaining funds in that escrow account. Or if they're unable to waive any of that debt for the SBA loan, at least there will be that $60,000 there to pay off or almost pay off that SBA loan. I do not have the exact amount that is owed, only the approximate $60,000 in that SBA loan. So $60,000 will be ordered to go into an escrow after the sale of the house. The sale of the house is ordered to be at least listed by May 31st, 2025. Mr. McFeeders will keep the home in a saleable condition until that the sale is completed, and the house would be listed at a fair market value to ensure that both parties will receive as much equity in the home and as much profit in the home as they practically can, and they will each receive 50-50 of the profits of that home. The court will now order that Ms. McFeeders may resume her maiden name if she wishes to do so. What is your maiden name, Ms. McFeeders?
It's Krieger, K-R-E-A-G-E-R.
K-R-E-A-G-E-R?
Correct.
All right. If she wishes to do so, but once you start changing your name, you must do so in a relatively quick fashion in all aspects with all accounts and all things. Neither of you are free to marry within the next 6 months if you in any jurisdiction across the world. If you do, it is a void marriage. All right, I believe that covers everything and all the findings that the court needs to make. Ms. Schmiege, please draft the findings of fact, conclusions of law, adopting that is stated on the record as to the agreement of the parties and the additional orders of the court made on the record here today. Anything further that you would like to add or inquire about, Ms. Schmiege?
Points. With regard to the order that Mr. McFeeders isn't at the house at the property pickup, there was one carve out for that, which is on Monday, May 9th between 11 and 3. He's likely to be there sleeping. He can be there as long as he stays out of Ms. McFeeders' way, and she's going to limit herself to the garage. So I just wanted to make sure that was clarified. And then number 2, with regard to the findings, do you want me to draft just sort of one comprehensive findings where I put all of the information that's in the marital settlement agreement into that findings, or can I take the exhibit 1 and attach it as an exhibit to the findings and note that it's an unsigned marital settlement agreement, but these provisions are being adopted into the findings?
Please do in one document. So bring what was agreed upon into the findings of fact. So it's just one document. And yes, with regards to that date and time where you will be sleeping, you're more than welcome to stay and be in bed and sleep so that you can have your proper sleep. Anything from you, Mr. McFeeders? All right, if that's it,
I have something.
then yes, Ms. McFeeders.
How long will be the length of the escrow for this?
Well, until you, well, How long do you think it'll be before you're able to?
Well, the
See
accountant
if-
has somebody that he has 15 years and they haven't even done anything with it for 15 years.
Well, 6 months and 6 months, and then it'll be paid off. I'm sure Mr. McFeeders doesn't want to wait 15 years. So if you can have yours reduced then, and you want to leave your 30,000 in escrow and see if you can reduce your 30,000 of the SBA loan and then go from there. I think Mr. McFeeders would rather have his 30,000 and his 30,000 in the SBA paid off. Correct?
Correct.
Correct. So the escrow will be at least 6 months, and then his portion of the SBA will be paid off, holding him harmless on your half. And if you fail to pay your half and it causes any detrimental harm and damage to Mr. McFeeders and his credit, then he has other avenues through court action.
Thank you.
All right.
And the escrow, I don't know if I'm hoping that the real estate agency that handles the closing, that they're able to escrow those funds. If not, I guess my office can do that. I'm just trying to think through the eventualities and how this works, but basically after 6 months, if the amounts haven't been reduced, if it's not resolved yet, Mr. McFeeders wishes for his $30,000 to be directed, or what one half of whatever the outstanding balance is, to be directed to the SBA loan. And then with regard to Ms. McFeeders' share, is that to remain in escrow until she either directs that it pay off her half of the SBA loan, or
Well, it can be released to her and she can determine if she wants to continue to fight to reduce it or pay it off, but with the understanding that she knows that if she doesn't pay it and it causes detrimental effects to Mr. McFeeders and or his credit, that she could face contempt and or other actions through filings of Mr. McFeeders.
All right. Thank you, Judge.
Anything else?
Not from my end.
All right, then we are adjourned.
Every day in the USA, people find themselves in court.
Court is back on the record in the cases involving Destiny Barker. The court took a brief recess in these cases to allow the defendant prior to sentencing to submit an application for renewal court. This application is for diversion. It's not a diversion application. It's post-conviction is what we're talking about, right?
I agree,
Counsel?
Yes, Your Honor, yes.
I'm going to scratch off with the attorney's permission, diversion, and write in post-conviction. Okay, the attorneys are present. Again, Ms. Barker is appearing along with Probation Officer Benoit, and the defendant continues to appear from the county and city jail. I'll continue, Mr. Martin. Is there anything further you would like to say on behalf of your client before I impose sentence?
Yes, Your Honor, and I just want to make sure it's clear from speaking with My client, she understands that any treatment plan that gets put together, she's going to be ordered to comply with those terms and conditions and recommendations in the plan, and that this isn't a situation for her where she gets to chart her own course. She's going to be working with people who are going to be helping direct her programming and direct her treatment, and that, you know, if she decides to try to do this on her own, that she needs to be prepared. The court would consider that a violation of renewal court and also her probation going forward. So she understands that, and she's willing to work with the providers that she ends up working with here. Thank you.
Thank you. Before I impose sentence, Ms. Barker, is there anything you would like to say?
No.
Okay. Mr. Lewis.
Briefly, Your Honor, with regard to the theft offense, that case, 5 CRB 115, that offense occurred on April 29th of this year. Ms. Barker was in the Dollar General, 5030 State Road, Monroe Township. Ms. Morton was present that day. She observed Ms. Barker take some items into the restroom, some frozen foods and drinks. She took those items into the restroom with her, came back out, did not, and Ms. Morton did not observe the food and drinks, which were that Ms. Barker had placed in her backpack. The surveillance video also verified that she went into the bathroom with the items, came back out of the restroom, and the items were not in her hands anymore. They were in her backpack. Sheriff's deputies were called. They recognized Ms. Barker from the description given by Ms. Morton. Found her where they found Ms. Barker where they expected to find her, and issued her the summons for theft, shoplifting offense. With regard to the possession of drug use instruments, Your Honor, that incident occurred on April 30th. Ms. Barker was arrested on warrants here in Conneaut, near the State Street McDonald's. She was found sleeping on the sidewalk there, and when she was arrested on warrants, the officers found in her possession hypodermic syringes used for the ingestion of illegal substances. Thank you.
Thank you. Any response to any of that, Mr. Martin?
No, Your Honor. No.
Okay, thank you. Officer Benoit, is there anything you would like to say before I impose sentence?
I would just reiterate the fact that, Your Honor, as you are aware, you stated previously, we don't have anything to do with the treatment. But Ms. Barker has left residential one time previously on February 25th, and that was with Signature Health.
Signature Health or Square One?
Square One, Your Honor. My apologies.
Okay, the court does have two reports since I ordered that an assessment be done as conditions of a bond by the Lake Area Recovery Center. I have a report dated May 2nd, 2025, where initially Ms. Barker essentially was uncooperative. She was tired, didn't feel like doing this. She continued to refuse, and her behavior was rude. She says, "I'm not doing this," even though court ordered to do it. She said, "I'm not doing this." The clinician was clear to the client that we would continue if she was cooperative. She still refused. The client was not physically feeling well, and so the assessment was terminated. Subsequently, on May 6th, 4 days later, the clinician went back to the jail, and Ms. Barker did allow the assessment to be completed. As part of that, I'm not going to read each and every, it's a very lengthy assessment report. I'm not going to read all of it, but one of the things that concerns me, as Ms. Barker has had, even at a very young age, she's only, what, 20, how old are you, 23, 24?
23.
23, yeah, 23 years old. She's got an incredible history of drug use. Her drug of choice is methamphetamines. But one thing that concerns me is that Ms. Barker continues to minimize and discuss risky behaviors. She denied ever attending sober support meetings. She has no one in her life she can count on for sober support. And she was upset that the clinician could not take her outside to smoke. Stated her boyfriend is in prison, also struggles with addiction. Client states, after being told that she probably have to go through a mental health assessment, that she will complete treatment if, quote, she has to, but it will just be wasting even more of her time. Ms. Barker cannot identify triggers, continues to use despite current consequences, and minimize, as well as projects blame. She is homeless with no transportation or support. Client states she wants to go back to square one because their treatment program is, quote, faster.
And I know
I can't hear you. You need to speak up.
I didn't say faster. It is a 1 month program, and then I can get a job. And what she told me that it's 90 days, and then I can start looking for a job. And that's what I meant by faster. And I've been to square one. I know the company. I know the people. I just prefer that, but whatever you decide, you know.
Okay. Which I will. She's been in jail since April 30th, 12 days credit. Counsel, any objection to 12 days jail credit?
No, Your Honor.
No objection, Your Honor.
Okay, I neglected to say, and what is your name, ma'am, again? Is there anything you would like to say on behalf of Dollar General before I impose sentence? No. Okay, thank you. On the theft case, 25 CRB 115, 180 days are in jail. Officer, is there a bed available for her?
There is, Your Honor.
Where?
The Care Recovery Center has a bed available. They can either pick her up tomorrow morning at 10 or sometime this afternoon.
Okay, she's going this afternoon. 168 days will be suspended, placing her on 3 years of supervised community control. She's to have no criminal offense for 3 years. As indicated, she will have 12 days jail credit from April 30th to May 12th, 2025, imposing a $100 fine and costs. I'm ordering her to submit to a comprehensive diagnostic assessment at both Lake Area Recovery Center and Community Counseling Center for alcohol, substance abuse, and mental health purposes. She's to do that within 15 days. She's already been through the LARC assessment, but she's got to go through one with community counseling. She's to comply with any recommended course of treatment and execute any necessary releases for probation to monitor. I'm adding New Beginnings, the residential treatment program, to that list in addition to LARC and Community Counseling Center, as she will be required to successfully participate in and complete residential treatment at New Beginnings. She's ordered not to purchase, possess, or consume any alcoholic beverage or drug of abuse or any pseudoephedrine product, or go into any bar or liquor establishment for a period of 3 years. I am ordering her to have no contact with and to remain off the premises of Dollar General, located at 5030 State Road, Monroe Township, Conneaut mailing address, as a condition of her supervision. I'm ordering her to successfully participate in and complete renewal court if she is deemed eligible after the assessments and screenings are completed. This sentence is consecutive to all other sentences. In the 25 CRB 116 case, where this is the possession of drug abuse instruments, 90 days in jail, 78 days will be suspended, 3 years of supervised community control, credit for 12 days served, $100 fine and costs. Same thing. She's to submit to a comprehensive diagnostic assessment at LARC and Community Counseling Center for alcohol, substance abuse, mental health purposes. Within 15 days, comply with any recommended course of treatment, execute any necessary releases for probation and monitor. She's not to purchase, possess, or consume any alcoholic beverage, drug of abuse, any pseudoephedrine product, or go into any bar or liquor establishment for a period of 3 years. She is to successfully participate in and complete renewal court if she is deemed eligible. Also, new beginnings will be added to the list of, she's ordered to successfully participate in and complete new beginnings, the residential treatment program. This is consecutive to all other sentences. On the probation violation case, that being 24 CRB 246, I will extend her community control for 6 months. I will also extend it for an additional 168 days of tolling. I'm going to add, as a condition of her probation, I will give her 20 days jail credit. I will suspend the balance. Actually, let me be more specific, because she was convicted of 3 specific dog charges that were to run consecutive. So I will give her 20 days jail credit in the subcase A case. With the added conditions, she's to submit to a comprehensive diagnostic assessment in all 3, subcase A, B, and C, with LARC and Community Counseling Center for alcohol, substance abuse, mental health purposes within 15 days, and new beginnings, comply with recommended course of treatment and execute any necessary releases for probation and monitor. And she is to successfully participate in and complete renewal court if she's deemed eligible in all 3 cases. I'm going to, having looked at that and understanding the court's limitations on how I can sentence, in the other cases, 25 CRB 115 and 116, I'm going to order that these sentences be served concurrently, not consecutively, but concurrently with all other sentences. I'm advising the defendant of her right to appeal, without cost, of her right to have counsel appointed on appeal without cost, of her right to have documents provided her necessary to file an appeal without cost, and of her right to have a notice of appeal timely filed on her behalf. Is there anything further, Mr. Lewis?
Nothing further, Your Honor.
Mr. Martin?
No, Your Honor.
Okay, Officer Benoit?
No, Your Honor.
Okay, here's how it works, Ms. Barker. You're going to be transferred to a residential treatment facility known as New Beginnings this afternoon. Hopefully there's still a bed available this afternoon, since we just started the afternoon. And you're going to follow all recommended course of treatment, and you're going to stay there.
Yes.
And you're going to do everything they tell you. And you're going to, look, you are 23 years old, and your life is a mess. It's a mess.
I know. And I have babies.
Yes, and you have children. And guess what? This program, this court, is coming to your rescue. But you can only be successful with all the tools that we're going to give you as long as you cooperate.
Yes, I know. I'm going to. This is my last chance. I know. To turn my life around.
And we're going to give you all the tools that you need. But I have to advise you that if you fail to comply with all of the conditions I've just told you, you do face a probation violation complaint being filed against you, and if you're found to have violated your probation, I could sentence you up to 1.5 years in jail. And you're messing with the wrong judge, because I will. And I don't think you sitting in 1.5 years in jail is really going to benefit you. But I will. I'll put you in jail for as long as I can keep you there if you mess up again. You understand that?
Yes, I understand.
I could also extend your probation from 3 years to 5 years, and I could also impose more restrictive community control sanctions. But just know that if you violate your probation, you're probably going to jail for a long time. Okay? If you're found to be eligible for renewal court, you and I will have another hearing. And this time, you'll come right from New Beginnings to my courtroom. And if you're doing everything you're supposed to do, I will welcome you with open arms into our program. We'll formally welcome you. And then you'll get to see this ugly mug every week while you're in this program. Okay? And I will, along with our treatment team, we're going to hold your hand to recovery.
Thank you.
Okay.
And to get my life together.
Okay. This matter is
Thank
concluded.
you so much.
Thank you. Thank you. Thank you, everyone.
Thank you, Your Honor.
Sorry.
That's okay.
When you get
Hold
the
on,
chance,
just-
can you check my name, Judge?
Guys, hold on. I can't have a whole lot of interruptions. Hold on, just a minute.
This motherfucker on Look. You ain't got motherfuckers on the file. You don't know what the fuck you do. You all over the fuck. So as I lay down, clearance road, clearance road, clearance road. I ain't get check in. I ain't get check in. I ain't check in either, nigga. I ain't do nothing but log on to there. They call you.
Mr. Broach, please. Really. You gotta keep your mouth shut, okay? I've heard plenty enough. Okay? Just remain quiet. Just remain quiet. Oh, let's see. How about can you hear me get this? Shantara Johnson?
Yes.
Apparently for some reason at 8:30. Okay, just get that done for me, okay?
Okay, I sure will.
All right, and we'll send you a new notice and you're all set.
Okay, thank you.
All right, you're welcome. Bye. Charmel Green?
Yes.
Miss Green? Well, I've got two great. Charmel, that's what
Yeah.
one of. Okay, there you are. You're being offered an amended charge to disorderly person, carries a penalty of up to 90 days in jail and a fine of up to $500. It's alleged to have occurred in Flint Township on March 27th, 2025. Do you understand that charge?
Yes, but it was because I didn't have my meds. I was drinking a little bit, but I was off my meds for 30 days. That's why I had the hallucinations and stuff like that. It was due to a mishap with my insurance that had my copay unaffordable for me at that
Okay.
time because I was on a marketplace.
Okay.
Trying to get some insurance through them. And because they put my copay so high, it took me 30 days to even get it together with the marketplace back and forth with DHS trying to get my medical back so I could get my medicine. And I felt it kind of coming on because it was days that I wasn't feeling all the way good. And I apologize for not going the hospital sooner. But when I start having those visions of me on fire, I was going over my friend's house to have her call and calm me down when I ran into the police officer. So I asked them for help. And that's how all of that started. I'm
Okay.
not a violent person at all.
Okay. So what we can, let's just get through this then and we'll see
Okay.
where we're at then. So, did you hear the rights that I went through at the beginning?
Yes.
Do you understand those rights?
Yes.
Okay, how do you wish to plead then to disorderly person?
Guilty. I do
Is
believe
it?
I was a little disorderly. I
Yeah.
also have my appointment with my psychiatrist at CMH, not CMH, on what is it, Bristol Road tomorrow
Okay.
at 4:30 p.m. And then I
Okay.
also have a doctor's appointment the same day.
Okay. So let's just kind of get through this then and we'll figure out what we're gonna do. Is it
Okay.
true that on this date, March 27th, 2025 in Flint Township, you're guilty of disorderly conduct by acting disorderly in public? I understand that some of it may be because of your medications, but at one point you pulled away from the officer after having an order I guess, stay where you were
I
at.
might
Is that
have
true?
tried to pull away, but that might have happened because of the type of hallucinations I was
Yeah,
having. I thought I was on
sure.
fire. So yeah, I was
Yeah.
scared. Yeah.
Yeah, and that says that, yeah, it's got that in there as well. So do you
Okay.
understand if I accept your guilty plea, you won't have a trial of any kind, give up all the rights that you would have a trial, and you may be faced with those penalties.
Yes, I
Has
understand.
has anybody made any threats or promises to cause you to plead guilty other than what we've discussed?
No.
No? No? Okay. I'll accept guilty plea to disorderly person. You know, it might be even easier. Did they take you to the jail at some point?
Yeah,
Okay. Did you spend the night in jail?
I stayed 4 days.
Okay, so you were there for a little bit. Okay, so let's do this. We'll just order 4 days jail credit for 4 days and we'll close this file for you. Okay, so that'll take care of it. But
Thank
it
you.
sounds like you're talking to your doctor, so on a regular basis.
Yes.
Okay. Make sure you do that so we don't get into another position like this, okay?
Yes, yes. I always take my medicine. It was just that one time because of the
Yeah.
medical issue, and I'm sorry.
Okay, well, I appreciate that. And I just don't want you to get hurt either, you know?
No, sir. I know. I don't want to hurt anyone. That's
Yeah.
why I take my medicine and stuff. I got grandchildren, and my daughter, she looks out for me all the time, and she wouldn't allow me to be around the kids off my medicine.
Yeah, sure. And that's good reason to be on them for sure. So
Yeah.
so get things straightened out for me and then we'll just call it good for today, okay?
Okay. Thank you so much.
All right, you're welcome. Just
Okay.
stay in contact with your doctors.
Thank you. I will.
All right. Good luck to you,
Have
ma'am.
a good day. Thank
You
you.
too. Yeah.
Bye-bye.
Bye now. Bye.
Bye.
Let's see, how about Jacob White?
Yes, sir, Your Honor.
Mr. White, let's see. Boy, you got a number of them here. Let's see.
Yeah. Yeah.
Looks like we're leaving them for a jury trial anyways. Let's go through them and just make sure we get everything. You're being charged on one file with resisting obstructing a police officer. That's on file 871. That carries a penalty of up to 93 days in jail and a fine of up to $500. This is alleged occurred April 1st, 2025 in Flint Township. Also being charged on file 874 with having in your possession a drug implement. That carries a penalty of up to 90 days in jail and a fine of up to $500. It's alleged occurred on the same date, time, and location. On file 872, being charged with larceny. Larceny carries a penalty of up to 93 days in jail and a fine of up to $500. That's alleged occurred on that same date, time, and location. On file 870, being charged with driving while license suspended. That carries a penalty of up to 93 days in jail and a fine of up to $500. This is alleged occurred on that same date, time, and location. And then on file 873, being charged with failing to identify self. That carries a penalty of up to 93 days in jail and a fine of up to $500. This is alleged occurred on that same date, time, and location. First of all, do you understand these charges?
Yes.
Okay. And did you hear the rights that I went through at the beginning?
Yes, sir, Your Honor.
Do you understand those rights?
I do.
Okay. So we'll enter a not guilty plea on each of these matters for you. And we'll set order court appointed attorney, leave on for jury trial date, June 5th at 8:30. See if we got any judgments we got here. We'll set $3,000 personal recognizance bond on each file. And we'll just actually just look at one file for you. Let me just look here. File 874, we set a $3,000 personal recognizance bond condition that you're not using the alcohol or illegal drugs. Submit to random drug and alcohol testing on that file. They're all left on for that same date, jury trial date, though. Okay, and then file 873, $3,000 personal recognizance bond. File 871, $3,000 personal recognizance bond. File 872, $3,000 personal recognizance bond. And file 870, $3,000 personal recognizance bond. So just other than the one with the conditions, no alcohol or illegal drugs, we just entered personal recognizance bonds, okay? Just make sure you show up on June 5th for me. It's in person in my court downtown Flint, all right? Mr. White?
Yep, I can hear you now.
Okay, do you understand?
Yes, sir. I didn't hear the last little bit you said there.
About the personal recognizance
Oh, yeah,
bonds?
I got they're all personal recognizance bond. I
Yep,
heard
they
that
are
part.
all, yep, other than, and there's one condition, you can't use any alcohol or
Oh,
illegal
that's good. Yeah,
drugs.
it's not a problem.
Okay. Other than that, you're all set, and we'll send you the information.
All right. I do have one question, Your Honor.
Okay?
My truck is impounded. Is there any way I can get that out? I don't have, like it was, I don't know if you can see, and I know you're not, it's set for trial, but I had submitted, I gave them the approval that had to remove the property that I removed. And it was, I tried to give it to the police that night, but they would not accept it. That I had approval to take, which all stemmed from the 911 call for the larceny.
Okay.
And I don't have my truck, which means I can't really work or anything. And they took it, which from something that I wasn't guilty of anyways. But I mean, we'll find that out later, I guess.
Yeah. Well,
but-
the best I can tell, I can't do it loud without everybody here. If you want to file a motion with me,
Okay.
you can do that and I'll consider it for you. But actually, and if you, I know you're trying to get it sooner, but if you show up on this date, we can address it on the June 5th date too, either way.
Yes,
Okay?
sir, Your Honor. Yes, sir. Thank you.
You're welcome. Either way, I'll do it for you though.
Okay,
Okay?
what do I gotta do to get to file a motion? Do I just,
I say I can't give you advice on doing that. You can.
okay. Yes, sir, Your Honor. I'll figure it out. Thank you.
Okay, all right. You just gotta bear with me because I'm gonna be making the decision, so I can't tell you what to do for me.
Yes, sir.
Okay.
Yes, sir, Your Honor.
All right. Other than
Thank
that, you're all set, okay?
Yes, sir. Thank you.
You're welcome. Bye. Bye now.
But
Every day in the USA, people find themselves in court.
TP in Maryland Monroe business.
Pardon me?
There's no TP.
I cleaned it out.
Good. Oh, master. Oh, I hate it from here. So.
All rise. We're CNA District Court for the County of Washington, State of Michigan, now in session. The court draw near, the Honorable Judge J. Cedric Simpson.
You may be seated. Court does call the cases, Arbor One West versus Rico McGuire.
Ellis Friedman for the plaintiff.
Thank you, sir.
Layman here as well. For the plaintiff.
Angela Jackson here on behalf of field management.
All right.
He was just here, but we don't know where he went.
Okay. There you go.
Alex Henry on behalf of the defendants.
All right. Hey, folks. Thank you. I think we had a little mix up in time, but I think everybody's here. And I'm almost afraid to ask, where are we?
Yeah.
Go ahead, Mr. Friedman.
I was just going to say that there has been significant progress made. There's been some, I guess I'll say, stumbles along the way, but significant progress is being made, I think, on schedule. The fire doors that were in question did arrive, are being installed. There are some issues with inspections and building permits that need to be ironed out. I don't believe any due to any fault of the property manager, but my co-counsel has been very actively involved dealing with the property manager, communicating directly with the property manager, and I think is better prepared, informed, I should say, really, to address the issues that are still remaining. But that being said, we do believe we can meet that schedule that was set previously.
Yes, Your Honor. As Ellis indicated, fire doors are ordered. As you know, we submitted the plan to you at the last hearing.
Yes.
There were a number of permits that the city was requiring the property manager to pull. Those have been pulled. My understanding is on May 2nd, there were 13 building permit inspections scheduled. 12 of them were passed on that day. There was one that did not pass due to, I believe, the drywall not being painted at the time. But the
drywall not being painted.
Yes. The drywall. Yes, so the 13th one failed because the drywall was not primed yet. FDIC, the vendor, had a hard time getting the mud to dry with the tenant taking a steamy shower. So it was not able to be painted. They requested to have a photograph of it being primed, sent to the city within maybe, I believe it was like 30 minutes after, and they were told that they could not do that. So they had to reschedule it for a new inspection, which I believe, Stuart, was that new inspection done?
It's on for this week.
Okay, so that new one is scheduled for this week. There was the scope testing that was to be done on areas. They received proposal from TEK Environmental. The proposal was executed by the ownership, and they're just waiting for scheduling for that from TEK. So that is in the works to be completed.
Okay.
There were 2 items with electrical permits for 2 of the units in 721 Clark. The property manager is hiring LR Rolls Mechanical to pull electrical permits and schedule those inspections. Similarly, with a ceiling fan that was in a unit within 721 Unit 206, LR Rolls is being hired to pull the electrical permits for that as well.
But those electrical, they haven't been pulled as of yet, but you've hired somebody to.
Yeah, so the idea is that the company comes in and pulls the permits during that process. So they're working on hiring LR Rolls to do that. There was also, there's this boiler boiler letter and baseboard covers. There was a request by the city that we provide them with a boiler letter. Basically, that would attest to the fact that boilers are in working condition. The boiler letter had previously been sent to the city on March 17th, April 8th, and April 29th. We received a correspondence from the city on the 29th saying that the letter needed to be signed and dated per building, and that the letter did not have the building addresses on it. And so a new letter was provided to the city, and it was indicated that the signature was not a wet signature on the letter, and that the person doing the inspection is not the license holder. So we're trying to get in contact with the contractor so that they can communicate maybe with the city directly to get them what they need. But it seems like.
So the 3 boiler letters, are those for 3 separate boilers?
Yeah, I believe that the company came in and looked at all of the boiler covers, or maybe Mr. Beal could speak better to this. Can you speak about the boiler letters and what that is?
Yeah, this is one of the last remaining issues that are going to cause a problem on May 20th. The city is requiring a letter from a licensed boiler contractor to say that the boilers are operational. We provided that letter 4 times over the last 45 days, and it still has not been accepted by the city. And so we're asking the city to accept it in its most latest iteration. But one of the problems is that the boiler system is very expansive and complex. It has 24 apartments in each building, and there are radiator covers in each apartment that Jerry, the inspector, says if they're damaged, they need to be replaced. But
well, I don't need to know what the problem is. What I'm trying to figure out is the letters that were sent. Were those encompassing all of the boilers for these particular units, or what were they encompassing?
So one boiler per building, and we've provided 1 letter per building now.
All right. Okay.
So as Mr. Beal indicated, this is going to potentially be an issue coming on the 20th. Because the position is that they want all of these base board covers that deal with these boilers replaced. And that is going to be approximately, I believe you said about $20,000 of building. And so to the extent that this letter is saying that these boilers are operational, the property manager and the owner are saying that they will replace the boiler covers that are the most damaged, obviously, but to the extent that they're still working properly, it doesn't seem reasonable to require them to replace every single baseboard cover in order to pass this inspection on the 20th.
And to be clear, the city is not requiring us to replace every baseboard cover, but they're not telling us which baseboard covers they actually want replaced. So that's why it could be an issue on the 20th. So the city should either let that go or tell us.
Why don't you sit down?
Thank you.
You don't need to tell them what they need to do. All right. Okay, go ahead.
Also, the city was requesting a letter regarding pest control. It's my understanding that we have that information, and if it hasn't been provided to the city, the instruction is to provide it today. I believe I saw it at the end of last week, so that letter will be provided to the city.
Indicating that somebody's been hired to do it, or that it's been completed.
It would be the contract for the pest control, letting them know when they're coming out, how often, services, things like that. So that'll be provided to the city as well. And then as Mr. Beal, I think, indicated as well with regards to inspections that are happening at the property. Another issue that we've run into recently has been scheduling the inspections and having the city come out to do the inspections. We're requesting inspections for several buildings on certain days, and the communication that they're receiving from the city is that you have this window, we're not calling, we're not going to the office, we're not asking for anybody, somebody be at where they need to be when we arrive. And if we've got 15 buildings scheduled for inspection one day, we don't know where the city is going to come up. So we're dealing with those kind of issues where they're refusing to communicate, and time is of the essence at this point. Everybody at the property is valuable. So having, multiple employees camp out for a 4-hour window potentially to see whenever the city arrives, as opposed to, a brief phone call, I'm on the way, it's becoming a bit problematic. So we're hoping that permits, to the extent that any additional need to be pulled and inspections need to be done, that this is not going to delay the process. So that's just something we wanted to bring to the court's attention as well, because that was specifically occurred with regard to those 15 that we had scheduled for May 2nd. So.
Okay.
Outside of that, I think that those were the main issues that we wanted to point out with regards to the plan and the progress. There also has been a request for 2 special inspections to occur this week with regards to drywall that needed to be removed. So just in the process of getting the work done, drywall was removed that, they didn't anticipate being removed. So they're requesting special inspections to occur this week so that we can ensure that we're on track for the timeline. There has been no response to that request as of yet, but that request has been made to the city. That would be the primary things we would want to flag for the plan. We do have a copy of the most current list of items from the correction order that were ongoing from the city, which we can provide to your clerk via email.
Yeah.
It gives a layout of what's been done, and then also kind of a plan for getting those things done by the 20th. I just received those, so I don't have a printed out copy, but if that's something the court would like, we can make sure that
Yes, that
emailed to you all. And that is the ones for 720 and 721. So we can make sure that the court has those.
wonderful. All right.
Yes, Your Honor, I had a chance to speak with Mr. Myers about all this, and it does sound like there's some progress being made, but it sounds like because of the fact that they're inspecting the other buildings at the same time, as well as other properties that Beal owns, that they haven't had the chance to get to where they need to be, where they think they're actually going to be on time to make it to the original schedule. I think about half the inspections they've been
What
doing
is that?
about half the inspections they've been doing on the Beal properties or on the Arbor 1 properties have been for other buildings that aren't these 2 buildings in question. So for that reason, they haven't been able to meet all the requirements that they have to for all the inspections. But I think Mr. Myers should probably speak better about this than I can. Come up, Judge.
Yeah.
Yeah, over the last 3 weeks, we have done about 73 inspections at Arbor 1. 38 were on these 2 buildings, so roughly half. 16 were approved, canceled, or not ready, disapproved, so they're failing a little over 10% of all of these inspections. They're scheduling inspections for other properties that Mr. Beal owns and not these buildings, which is taking up our inspectors' time away from being able to inspect these buildings, to where next week we have 5, or this week we have 5 open inspections, 1 on Tuesday, 1 on Thursday, and 3 on Friday. The special inspections that they requested on Friday at the end of the day are for times that we don't have inspectors working or that we don't inspect. Because they asked for 1 on Friday at the end of the day at about 4, I think, and then Monday at the end of the day when we don't have an inspector. So we have 8 permits scheduled for this week to be done. There's about 20 that needs to be done. And so we have done whatever we can to make this happen. As far as the inspection, we give everyone a window. We have been told that we treat people differently, but we give everyone the same 4-hour window for inspections. And then we've also said on several occasions that we're going to always start at 721 Clark. It's the first address. That's not good enough for them, but that's really what we can do. But yeah, it's very concerning that out of
What's not good enough? What do you mean that's not good enough?
so they would like the exact time that we're showing up when we really don't know when that is because the inspections happen all throughout the city. But yeah, so this week we have 16 or 14 inspections scheduled for Arbor 1, but only 8 of them are on this building, these 2 buildings. So seems like they're prioritizing other buildings over these 2 buildings.
Why do you say that?
Because if these 2 buildings are the only concern, which we have been told in an email from Mr. Beal that the city's only concern is approving these inspections, they're prioritizing other buildings in the complex
Yeah, but
permits.
what's gonna happen is that if they don't, I don't know if that's a prioritization. It's that this is sort of an ongoing concern. So if I'm working over here, because that may be my next phase that I'm going to try to get some things done, then I would be trying to do them both at the same time.
But we only have a limited number of inspections we can do in a day. And so by taking them away from these 2 buildings, we're being pulled from those 2 buildings.
Okay. Regarding that.
Sure, if I may, I find that statement incredibly problematic because if we weren't doing work on other buildings, I mean, property's actively being cited by the city and other buildings as well. So we're splitting time and I don't see that as a problem, but as Mr. Myers indicated, majority of those requests were for these 2 buildings. So also last hearing, Your Honor, you were inquiring with the city with regards to I guess the third-party contractor that comes in and does certain permit inspections and things of that nature. So since that hearing, we have spoken with one of their representatives, Jeff Schaefer, individual who does the building permit inspections typically for Arbor 1. And he's indicated to us that he's having to find other work because the city is not keeping him busy enough. And because Jerry Dunham is now doing all of those inspections. And he's a little.
Hold on a second. So this is a third-party person to do inspections. That's at least telling you that he could do more, but that he's not being requested to do more.
Correct. He's Jeff Schaefer.
Stop there for a second. What do you know anything about that? Huh?
No.
Okay. Go ahead.
Yeah, our property management team spoke with Jeff Schaefer, who is an employee of Code Enforcement Services, CES, the company that the city contracts to do the building inspections. Jeff indicated that he's not being kept busy enough with do work now and has to reach out to others, get work from other municipalities because Mr. Dunham is now doing the inspections that he previously did. This is, on top of the scheduling, this has been an issue for us as well because working with Jeff, the process was, streamlined. We would do the inspections. He would give us yellow cards, letting us know the inspection results, and we would be able to, continue on from there. We now have Jerry doing those things. We're running into we're not answering the phone. We're not letting you know when we're coming. We're not calling, as well as you're not giving us inspection cards. So we have no verification at a certain point to establish whether or not we passed or not, which is problematic from a property management perspective. With the city coming out, we want to be able to verify when an inspection is passed and when it's not. So at this point, their position has been that they're not required to give them, but up until this point, we have always received them from CES. So just something we wanted to flag with the court as well, because these are things that are.
Well, hold on. Can this guy do more inspections?
So there are, per our contract, and
Whose contract with who?
the city and CES,
Okay,
we can do 6 inspections a day. We have done more than that over the last 2 weeks, and we have yet to,
with this company?
with both with Jerry and this company, to make sure we get the inspections done.
All right, get on the phone right now, find out how many inspections he can do in a week. Let's do it right now. Because this doesn't make any sense to me. If somebody can do the inspections, then let's get them done.
Another issue I was hoping to bring to the court's attention.
Sure, go ahead.
So some of the tenants that have been relocated both in and out of court to the township side, they've continued to escrow their rent. And now they're receiving 7-day notices to evict them. One of those people, Miss Natasha Drake, is in court today.
So she's receiving a 7-day notice. But they're on the township
On the
side.
township side, but she's been escrowing her rent
Here.
in this case, yeah.
Okay, and she's escrowing it on her case, right here, right? Okay, so, just so that you know, and we haven't quite worked it out. Judge Washington is aware who would be handling the township cases. She's aware that the escrow is being paid here. How exactly that financial mechanism is gonna work? We're not sure. Is the rental amounts the same? Or, well, that's gonna be the part of the issue. The other part of the issue is who's going to be paying for that relocation, which is another issue, so.
That's a twofold issue because of course we had our hearing with Judge Conkey last week on our preliminary injunction motion presented by the city prosecutor. That has not translated into an order yet for various reasons. However, she addressed the issue of rent payments, relocation of tenants. She's made clear that tenants who are requesting relocation assistance can speak before her on 3 days' notice.
Can do what?
Can appear before her with a motion on nearly 3 days' notice.
Okay.
She did reserve the issue of various things like emergency repairs, health and safety related repairs for a hearing. Was originally scheduled for 6/6 inexplicably. It appears that hearing's been moved to 6/20. Any tenant desiring to be relocated is to receive a 100% refund of all of their escrowed funds and all of their paid rent from 9/17. So that would affect obviously the escrow order of this court once her order is entered, and also the escrow.
They're to receive what?
They're to receive a refund of all of their rent paid from 9/17 if they paid rent.
From 9/17.
9/17 of 2024, which was the date of the suspension of the certificates of compliance. And that they would be prohibited from seeking to collect rent while there are no certificates of compliance, because that's explicitly what the order or what the ordinance requires. It also prohibits leasing of buildings at the Arbor One property on the city side. Also prohibits all rent collections that I believe I just said. And so she's looking at relocation on a case-by-case basis and addressing the
Has the
return of a refund of escrows on a case-by-case basis.
Well, I'll wait to see her order on that. Then deal with
There's a
her.
lot going on, obviously. I'm not sure what you were aware of.
Mr. Henry, so what's gonna end up happening is even if it's gonna be a bit problematic returning escrows because the escrows may need to be paid, or at least these people could end up being relocated to the township side. And now you've got basically 3 courts with their hands in it, trying to figure out what to do. So I think between the 3 of us, we'll be able to figure it out.
You said Miss Drake was.
Miss Drake is one. I believe it was also Mr. Blankenship. Then there was some that were not in court, like Alina Jordan, Lawrence Grove, and Weena Harris Freeman.
And these individuals have all been relocated to the township side?
They were all originally on the city side, relocated to the township side.
Okay. Township side has COCs. So
Correct.
Why are they still escrowing their rent when they are in a?
Because they wouldn't be on that side, but for what's happening on the city side.
I think another issue is they were relocated, given new leases, so they don't know if they have an increase in rent, a decrease, or if it's the same as previously. Some of them have leases that are ongoing, some the lease expired, so they've just been escrowing the same amount that they would pay either to the court or to the city.
And I mean, that's.
I don't need, Mr. Beal, I don't need your comments. Go ahead. What were you gonna say?
So the court has ordered that even if they're on the township side with COCs.
I've ordered them to comply with my escrow order.
Okay.
And where they can either do it to the court or to the city. Because the question really is going to be, if they've been relocated, do they intend on coming back, or should they be paying for where they are? And I guess maybe the way to look at it is, it's one thing if they're in a new apartment and one can look at that in one way. Or you look at it from the standpoint that if they were placed in a hotel, then would they be paying the hotel bill? No. Right? So is this temporary? And I think and Mr. Henry, you can correct me if I'm wrong, but the real question is there relocation to the township side a temporary solution, or is that a permanent solution that at some point that's where that person's going to be?
Right, and I think that would kind of speak to the answer to his question, is he's speaking with all these individuals to see if they intend to stay in the township side, or if their intent is to, again, be relocated back to their unit. If they intend to stay, then I think that conversations to be had about whether or not they should be paying rent.
Well, and whether or not they have a lease.
Right, and then,
I mean, I would agree with you in that respect, but remember how this all started. It all started because the units on the city side were not in compliance, so these people had to be relocated. The people get relocated, and some of them are put in hotels, some of them are put in other units, with no clarification as to the permanency of any of that. So.
If I may, Your Honor, it seems if somebody's been relocated to the township side in a certified unit, they are certified, that and they wish to stay there, they like the accommodations, and are willing and able to sign a lease or a lease extension, that rent should resume. It's there's no health, safety, or certification issues that would preclude the landlord from requesting rent for a certified unit that the person intends to reside in.
If they have a lease.
Yes.
But I don't know if any of these people have leases.
That's my understanding that they don't have leases. Ms. Drake, is that correct, that you don't have a new lease?
I'm sorry,
That's correct.
you don't have a new lease. Yeah, so, I mean, ultimately, the real issue is, are they intending on staying there? Have they moved? Or have they, I guess, for lack of a better term, have they relocated or have they moved?
Right.
That's really gonna be the issue, as far as I'm concerned.
And we can, obviously, I can communicate with legal services about having those conversations to see if some of these issues could be resolved. Because I think that, this turns on a few of those questions that I don't think anybody has a clear answer to at this moment, so. What the intent of the tenants would be.
Do we get an answer regarding the inspection?
So not quite, but I have an answer that I think will satisfy. We have not denied any inspection at this point. We are running out of time for the 20th, but we have made it work. We might not be able to make it work with the timelines that they want, like end of day Friday and Monday when we don't have any inspectors. But we have yet to deny one inspection. And so
I don't know that that's what I asked.
and I have not been back to our company that does it. And so
Pardon?
I have a call in and a message to call me back because I'm in court, but I have not gotten a call back from CES.
Wouldn't that really dictate in certain respect whether or not the 20th is gonna be able to happen?
If their boots on the ground are telling our boots on the ground, the 20th isn't gonna be happening.
What?
So even our boots on the ground are hearing from their people that they're not likely to make the 20th. They're only pulling permits on certain things. Even last week, as you've heard from them, there's certain permits that haven't even pulled, they haven't hired the person to pull them. And that's been 2 weeks ago that they agreed to pull those. So with issues, the city's not the problem here ultimately, Judge.
Well, I think everybody's a problem. Because what I'm hearing is I don't think people are communicating. I think people are getting in certain ways for whatever the reasons are. And that's fine if everybody wants to act that way. I mean, I certainly will let Judge Conkey know what I am seeing on my end regarding that. But, if I mean, just by way of example, if one side is hearing that somebody can do more inspections, but for whatever reason, those inspections can't be done, that doesn't make any sense to me. I mean, it's like we're talking everybody's talking two different scenarios here, which makes no sense to me.
Meeting we had here a couple of weeks ago, they asked us to attend. And one of the items that came out of that was insistence on our part and agreement with theirs. There would be a single point of contact. So we didn't have this, he said, she said folklore, from whoever it's being spoken to. We identified who we wanted to have as our single point of contact. And it was our understanding that they would do the same. And, when there's a disconnect like that, again, that we try to address.
How many inspections on 7/20 and 7/21 are there this week? That
8.
That's all that's been requested.
Yes.
Is that correct, Council?
That's accurate.
Yes. 8 have been requested. 8.
You said you had the punch list of what needs to be done.
Yes, I have 2 documents that are the rental inspection correction notices, one dated April 3rd, one dated March 31st. And this appears to be the most recent list, and it's laid out by what's been done, and then notes from the property management team as to plan to get those things done by the 20th. So yes, I can email that to Ann.
Okay. And I guess my question is, that list, is everybody operating off of the same list?
Yes.
I think so, yes, Your Honor.
Really? Are we?
I think it's the city's correction order list, so we're working, yes.
Is that the latest one? All right. And so the object is to get what's on that list done by the 20th.
Yes.
All right. Mr. Henry, was there anything else?
I don't believe so, Your Honor.
So the issue regarding the working out who's going to be where, how's that? Are you just going to reach out to legal services and try to resolve some of those things?
I'll communicate with legal services, and we can see what information they can provide us regarding the tenants as to their intent to stay or go, and then from there, I think we can have conversations on leases and things of that nature.
And if you have a list of we received those 7, 8 notices, we could probably try and reach out to many of those we can to see what their preference is or what their plan is going forward.
And I'll just make a note to, I don't know that I'll see her this week, but I'll touch base with Judge Washington just so that she's, or Magistrate Bailey, just to make sure they're aware what potentially could be coming down the pike on those. Those, and I don't know if you can, if anybody can answer this, those cases would be filed in the name of Arbor One or the village. How would those cases be filed in the township? Mr. Friedman, do you know?
Mr. Beal's using his other his regular landlord tenant attorneys for that, Your Honor, and I'm not involved.
Got it.
I'm not aware of it either.
Okay, then I'll let her know that I have no idea, but they're there. Okay.
Once we establish whether or not tenants intend to stay on the township side, to the extent that they have been escrowing their rent while on the township side, is that rent then being released as rent to the property?
Say that again.
So tenant A been on the township side, been relocated for a month. There's a COC over there. We set up a lease with this tenant just to kind of establish what's going on. She escrowed her rent for that month. Is that rent now being released to the property?
Okay, so here, that's going to be a complicated answer because theoretically, if there's a case filed at 14B, okay, on the township side, my preference would be to release the funds to 14B court and then let Judge Washington make that determination. If there's been no case filed, and this is where it's really going to get sticky, my feeling would be that once all of that's worked out, then somebody would give me the numbers to just figure it out what needs to go here and what needs to go where. That would be my preference. But what's now being indicated is that there may be an order coming down from the circuit court that all the money's to be given back to the tenant, which means that anything I then have would have to go to the tenant to do with what they need to do. Now, I would seek, quite frankly, to try to get a clarification from the circuit court, or have somebody do that, get a clarification from the circuit court as to, in those instances, what should be done.
I think the circuit court order also is a caveat that these monies are being returned if the tenant decides to break their lease and leave. So.
Oh, well, that's wholly different.
Right, so.
What?
That was the point that Ed brought up.
So, okay, but let me ask this, because I'm not sure how one would interpret the order. Is relocating, but then the tenant makes the decision, I'm going to stay where I'm going to stay now at this new place. Based upon what's being said, that money, the monies that would be held here go to the tenant and not to the landlord. Or is that not your understanding?
I don't think that would be my understanding. I think the tenant relocating. I think we're confusing two issues right now. So.
Oh, I'm not confused, but go ahead. No.
I think that there are some things with Judge Stunky's order that are very clear. I don't think there's any dispute that it was decided that if a tenant decides they want to leave and break their lease and leave, that they can do that. There's no issue with them breaking their lease and leaving.
And that's really the breaking of the lease.
Right. So.
But a relocation does not fall in that category.
Right. That's where I was meeting. We were confusing two issues. So a tenant can decide they want to leave. They can break their lease. Harbor One is not going to object. If that happens, they can be refunded money that they paid in escrow.
Got it.
They can be refunded rent that's been paid since the CFC period until the time they vacate. And then I believe that they would be returned a security deposit if they paid any. If they decide to vacate and leave.
Got it. Okay. Was there any?
Is that your understanding as well? I just want to make sure. That seemed very clear.
So it was more of a emergency motion, so as to help the people that were still located in the condemned units to get out as soon as possible.
Correct.
I think that's why it was specific to those people.
Got it. That makes sense. Okay, so now to people who, and again, I'm going to have to see the written order, but to people who are relocated, but then elect to stay, which was basically what Mr. Henry had brought, elect to stay where they've been relocated to. What's supposed to happen with their escrow? And please don't tell me it's silent on that.
I mean, the order did not speak to individuals receiving any funds back unless they were electing to break their lease and leave. So if somebody was relocated, I don't think that this order spoke to whether or not they would be entitled to any of those monies back.
Okay, and let me just say this. Based on what's explained to me, that makes sense, right? However, and I'm just talking technically, but it's not my order, so I don't know how to interpret it. Somebody being relocated, and then the conversation occurs, I'm gonna now stay where I've been relocated. By definition, they then break that lease or that tenancy that they had. And so if that's the interpretation of that, then they fall into that same category. Just thought I'd throw that into the mix. But I don't know if that was the intent of what Judge Kunke was ordering.
And not speak for Judge Kunke, but my understanding of the hearing is that was not the intent. It was only specifically pertaining to individuals who are currently at the property on the city side who want to break their lease and leave the city side.
Got it. That may be a fight for another day. It just, because it just has to be some clarification on that, and that's gonna part of, as I see it, somebody somehow or another there's gonna have to be some clarification of that, because what's gonna end up happening is at some point the folks on the township side are gonna file a case. And then it's gonna be sort of one court, 14A may have the money. 14B has a case looking for the money. And the circuit court has issued some order. So somewhere along the line, that has to get clarified rather than everybody scrambling around trying to, at the last minute, trying to figure that out. Bless you, it seems to me. So, anything else we need to, now that I have this update, anything else we need to do prior to me giving the next date?
Your Honor, Todd Ryan appeared by Zoom. Permission to speak briefly?
Yes, go ahead.
So Todd Ryan, P81848, representing plaintiff prosecutor in the circuit court matter, not a party, speaking as a friend of the court, and informed the court regarding that recent conversation about the scope of the order. That is going back before Judge Kunke as to what exactly was ruled and was not ruled. Both plaintiffs and defendants have submitted proposed orders to the court for the court to finalize. But it was very clear on the record that it did not involve township properties, that the judge was focused, because that's what we presented, on the city side. And for the city side, the judge did orally rule that there wasn't a basis for escrow on the city side with the lack of the CFC. But that was purely for the apartments, and that was kind of a necessary precondition to not ordering escrow on the city side alone. Again, that'll be going back before the judge on some other hearings on Wednesday, so it's very possible the judge
Not ordering escrow on the city side. I don't. Okay, that's fine.
And so with the unusual procedural posture here, with plaintiff prosecutor not being a party before your honor, and their separate claims for the prosecutor than for the tenants, I understand trying to get ahead of it and making the order as consistent as possible. But as I believe Counsel Henry said earlier, this was in the context of a preliminary injunction for emergency relief. And we're going to have a more protracted presentation regarding where the money should go out of that emergency context.
Okay. So are you telling me the circuit court has vacated my order?
No, Your Honor. the circuit court orally found that she would not order escrow on that, and there wasn't a basis to do that for what was presented to her. And she did orally say that the tenants could submit this to district court and to the city of Ypsilanti for that court's consideration. But Your Honor, that may not be reflected in either proposed order.
Of course.
And I do have a recording of the hearing available, but to the extent, just thinking out loud here, to the extent Your Honor had questions to present to the circuit court because they impact your case, I wouldn't make a suggestion on that for Your Honor.
That what? You do what?
Oh, I'm I don't want to make a suggestion to Your Honor about what would be helpful for you. I was thinking of the context of like a certified question, but you know, this is a very different kind of procedural posture with a district court and a circuit court with different parties before each court.
I just called Judge Cookie if I had to try to figure it out. And then once I see a written order, I mean, I don't think on either end, and I would hesitate to say, not speaking for them necessarily, but with Judge Cookie, Judge Washington, and myself, I don't think anybody's trying to make anything complicated. It's just we need to know what to do. And so that everything is consistent. So, and sometimes that may not be the attorney's objective, but I think it would be the judiciary's objective. So, all right, thank you. All right. Did we get a call back on that inspector? Okay. So prior to our next date, I want an indication regarding these inspections so that, and if the, who is it, CES, if they're willing to put something in writing saying that they can do more inspections, I'd like to see that. And I guess I should clarify, are they willing to do more inspections and how many can they do a week?
And what's the cost?
Well, we'll figure out the cost. I mean, if somebody's got to put some money in there, what? But if somebody's got to put some money in there, look, folks, here's where I'm at with this. And just how I am. I don't like people coming here telling me why you can't do something. Find a way to get it done, and then let's figure out the nuts and bolts to achieve the objective. Because I'm hearing a lot of sort of naysaying coming from both sides about why we can't do something. And that doesn't make any sense to me. Right. So you guys are looking to have this done by the 20th, which is a Tuesday. Let me ask you this. There would likely be, you're trying to get everything done by that Tuesday. There would likely be inspections that would be happening that day. Is what I'm thinking. Right. So I don't. Maybe the next day would likely be the 23rd, which is a Friday, but what do I have on that?
Let me run.
I mean, I could, if I, it's Friday.
You're correct. There's 70. second hearings this week on Friday.
Say again.
We have 70 second hearings on Friday this week.
Okay, so, but the 1 week. The 1 week adjournment from the 16th is gonna happen, but those have become second hearings. So here's my thought. And it's just a guess. Is, have we set 23rd first hearings done?
Yes, yes, we have.
What do those blocks look like?
And 15 second hearings at 10 a.m.
No, those aren't second, those are first.
Yes, 15 first hearings at 10 a.m.
All right, so here's what we're gonna do. Set this on the 23rd at 11 a.m. Okay. And council, so that you know, I know we had a bit of a delay, but I'll set it at 11 a.m. on that day. Oh, that's not gonna work for Mr. Friedman.
Well, Your Honor, I finished.
Oh, okay, fantastic. Okay.
I got a certificate of completion.
Fantastic. Congratulations on that, my friend.
Thank you.
All right. So we'll set it at 11 on that day. Okay. And then that way we'll see, and I will just let council know you'll be here in person. I will have Zoom hearings going all over the place that morning, but I will try to get them out of the way and make it as least inconvenient for you as I possibly can and get you in and out. Okay.
I will be back in town.
Pardon?
I will be back in town for live hearings.
Yeah, I'm seeing that nice sunny sky behind you.
Yep. It's real.
Okay. All right. Was there anything else from either side then?
No, Your Honor.
All right, thank you. You're gonna get that list to me.
Yes.
We can see where we're gonna go. And I want an update sent to Ms. Weidling regarding that CES inspections.
Okay.
All right. Okay, thank you, folks. 14A stands in recess. All right.
Every day in the USA, people find themselves in court.
Who do I have now? He's ready on. Stephen Thompson? Yes, sir.
He's in front of me.
He needs to come in front of us.
And we sent it to you.
And right, Kashan Washington?
Yes, sir. Probation.
Yeah. Well, that's, and then I have David Tovar.
Yes.
That is all.
Thank you, honey.
Yeah, right, come on up, please. On, Keyshawn Washington. Do we need him out? Or is he here? Oh, is he supposed to be here? Yeah. Okay, Keyshawn Washington. Keyshawn Washington, 16-26375, no answer in the courtroom. No answer in the courtroom. I asked the bailiff to call into the hall for Keyshawn Washington, please.
He should be in jail.
Oh, he's in jail?
Yes.
Did you know that?
I think we requested a bond.
Okay.
Nathan, that's been.
Okay, you were Mr. Washington? Sir. Here in cause number 16-26375. You were here with your attorney, Mr. Kimler. You recognize him? Vaguely, huh? When was the last time you saw him?
I don't know.
Years ago or
We're trying
a decade?
We're trying to get a bond. So,
Okay, there's a. For what? This first amended motion to revoke probation?
yes, sir.
It was filed 4 years ago.
I know, we'd like to get a bond.
He just got arrested on it?
We are arrested.
Yeah, I'm asking this stuff. Well, who's the prosecutor on this?
When we arrested.
It's
April 7th is when we went to custody.
Mike Laird.
Yes, sir.
Okay, you were placed on probation in 2018 for 5 years, deferred or unadjudicated probation, which is now 7 years, going on 7 years ago. This first amended motion to revoke unadjudicated probation was filed September 17th, 2021, which is going on 4 years. We're almost 4 years. Have you been an absconder?
Objection, Your Honor.
Has he?
Yes, yes.
Your objection to what? My
That
question?
That might require.
I'm asking the probation officer.
That's a legal conclusion.
When was the last time he reported?
The last,
Bond
his
reduction
last
no
court
worries, yeah.
date was June 2nd.
June 2nd of 2021? Okay, okay,
But he was arrested April 7th of 2025.
yeah. Okay.
And last note I had on my file was October 14th of 21. There was a warrant because it was a no-show for court. So I don't know what happened since then.
It's deferred adjudicated.
Yeah. Okay. Anybody want to say anything?
Well, I think he's entitled to say, given the length of the delay and him returning to custody, there may be a due diligence issue as well. So, but we are requesting a bond.
Okay. Anything else? Okay, we'll state.
Dude, since he's not been able to be found probably until this time, and he hasn't reported, hasn't turned himself in. We'd request the bond be extremely high, and if he gets a bond, that he get a GPS monitor as part of it.
Anything else?
There you are.
Okay. Anything?
We just
Okay.
want to request a speedy.
Nothing else?
Request a speedy hearing.
Okay, we'll have it here. Your bond is $250,000. If you post that bond, you must be in home confinement. You must have a GPS device. You cannot leave home for any reason except for medical or food and any other necessary needs that have to be approved by the court first through your bondsman and the probation
He'd have
officer.
to report.
And-
obviously, the probation.
That goes without saying. You're under probation rules that here. See your signature right there? That you signed 4 years ago. I agree to follow all the conditions imposed upon me, and I know that this community supervision can be revoked for any violation. I will remain in the legal custody of this court and hereby waive extradition if I am charged with a violation and arrested in another state. And there's your signature. You made that promise. And we hadn't seen you in 4 years. If you don't report, you're not really on probation. It's just a joke. And we don't find it anything but serious. We find it serious because that's the only way we can supervise folks. The ironic thing is you were placed on deferred or unadjudicated probation, which gave you a chance. And that was on 2018. And you were really toward like you had done 3 years. But you got to run through the tape, you know?
Yes, sir.
You run track in school? Okay. You let's say you're running a 100-yard dash, you go 50 yards and stop and walk off. You get a participation prize even No, you're not, and certainly you don't get first place. All right, you gotta run through the tape. We all do. Even when we don't win, you still gotta put the effort and complete the task. All right, I want this. Look, there's not a substantive crime here, is there? No, sure. But it's all something that I'm sure the probation office is probably can be ready to testify to. I want this in a few weeks, please.
Yeah, they destroyed a lot of stuff.
When can you be ready, right, on this, on a hearing? You've been working on it for 4 years.
Speak your mind if you want to put it.
No, it'll probably be a couple of weeks, but not long, okay?
I can do 2 weeks.
2 weeks, all right, let's do it then, thank you. All right. Anything else? I see David Tovar, I believe, correct? Is that it?
Yes, Your Honor.
Mr. Tovar, thank you. We'll need David Tovar, please, thank you. All right, we now call clause number 24-CR 857, the state of Texas versus Chadston Brightson. You were Mr. Brightson?
Yes, sir.
And you were here with Mr. Adams, your attorney and the state's attorney. Earlier, you pleaded guilty to the third-degree felony of unlawful possession of a firearm by a previous convicted felon. And hold on. And the agreement was whatever sentence shall not exceed a cap of 8 years in prison. So we are looking here, if the court decides to sentence you to prison, you are looking at no less than 2 nor more than 8 years confinement in prison. You could be sentenced to no less than 2 nor more than 8 years confinement in prison. And then that could be suspended and you could be placed on regular probation for up to 10 years. You could also be placed on deferred or unadjudicated probation. I think those are the 3 options available.
Yes, Your Honor.
And have the parties had an opportunity to review the pre-sentence report? And are there any corrections or changes to it? State.
We reviewed it and we have none, Judge.
And defense.
No, I don't have any, Your Honor.
All right, then.
I have 2 brief witnesses, his mom and his dad, Judge. If you don't mind, can you please come?
Hold on. And then we had a report earlier prepared by Dr. Edgar Pine of the court's insistence that the defendant be analyzed for competency and insanity. And that report had been received on September 11th, 2024, which states the defendant is competent, stand trial, and is not suffering from a mental illness that would make him ruled insane and unable to stand trial. Any objections to us calling this court's exhibit number 1 on this date and putting it into admission in this court for all purposes for sentencing?
None, Your Honor.
None, Your Honor.
All right, then it will be made a part of the record for all purposes. Okay, we're calling it court's exhibit number 1. It is made a part of the record for all purposes without objection.
No objection.
All State, would you like to go first? Or do you want to defer till later?
Let's defer, Judge.
Okay,
I
you may.
understand he's got some live witnesses.
All right, defense may go forward. Thank you.
All right.
One at a time.
That's
Yeah, we don't do it as a group.
No problem. I can.
That's why we only have one chair in the witness stand over there.
All right. Would you state your full name for the records?
My name is Terry Eugene Burks.
That's who you're calling, Terry Eugene Burks.
Terry
Okay,
Burks.
the witness has introduced himself as Terry Eugene Burks. And raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Okay, you may lower your hand. Go ahead.
And to my right and your right, that's your son, right?
That's correct.
And he
Who is?
Chasten Wayne Bryson.
We have to do it for the record. So the court reporter's notes show exactly who you were referring to.
And just briefly, tell us about yourself and how you employ.
My name is Terry Eugene Burks. I'm 51 years of age. I reside in the city of Beaumont, Texas. I've been here for a little bit better than 19 years. My wife and I have been married 19 and a half years, and I presently work at a company called Hennef Transportation LLC as a hazmat chemical driver.
All right. And you understand that your son, Chasten Bryson, is charged with unlawful possession of a firearm by a felon. We got a chance to look at the pre-sentence investigative report, right?
Yes.
And you understand that the court has a cap of 8 years, meaning that judge just said you can go as low as deferred probation, straight probation, or as high as 8 years in jail, right?
I understand.
So with that being said, and you're also familiar with Dr. Rapon's report, as well as when we had him evaluated for psychological conditions, right?
Yes.
So what I want you to do is, I don't want to feed you with what to say or not to say, put words in your mouth. Directly talk to the judge and ask him, why do you want him to have probation, deferred probation in this case?
Thank you. Again, thank you, Judge Stevens, for allowing me to address the court.
Yes, sir. Go ahead. Thank you.
Again, I'm Chad's stepfather. I've been in this life ever since he was 6 years old, 6 years of age. And so for approximately 20 plus years. And the first part of our relationship was a beautiful relationship, teaching him how to tie a tie, even ride a bike and so many other things, our fishing trips and stuff. But as time progressed, the neighborhood that we lived in, he got hooked up with the wrong crowd and ended up gravitating to a lifestyle that wasn't conducive of the household that we tried to project. We come out of a Christian home. And so things began to spiral down for Chad and for our family. He began to get in trouble and we had problems with him at school. But one thing that I promised myself, and I married his mother, I also married him. I said that even though I grew up in a home without a father, I said that I would never, ever forsake my family. I would never, ever give up on the family that the Lord blessed me with. And so I've always been there for him. I've always tried to love him. As a father, I've never looked at him as my stepson. Whenever I would meet people out in the public and they would say, "Is that your son?" I would say, "Yes, that's my son." And I've always loved him. And I'm not going to sit up here and say that Chad is not without fault. We've always tried to hold his foot to the fire. We've always tried to hold him accountable for his actions. I never made excuses for the things that he has done or the activity that has led us here today. I've always been one, as the saying goes, that drove with tough love. And we have rules in our house, and Chad knows that if you can't abide by these rules, then you can't stay at this house. Home is what home has always been, and Chad is always welcome to come home. And as long as he's home with us, he does right. You know, we tell him what to do. We take him to the places that he needs to go. I've even started trying to teach him how to drive when he was with us, you know, so that he could get out and become a civilized individual, be productive in society. And I believe that that's still in him. I believe that there's some good that's still left in him. He just needs to have that robust supervision, that oversight that will keep him grounded. His mother and I have already pledged our love for him and our support for him. We have a structured home. We have reliable transportation. We have a big family, and all of our family have pledged their support to help us and help Chad in any way possible to become successful in life and to turn the trajectory of his life around and begin to be the father for his son that he needs to be, to have that respect given back to him that he has to earn. And I believe that if he's afforded that opportunity this time around, I believe that what's been the norm for his life up to this point will begin to take a 180 turn, and he'll be able to become that person that he needs to be in life. And we're going to help him to become that person if Your Honor in this court sees a possibility for him to be placed on supervision.
Okay. Any questions from the state?
A few, if I may, Judge.
Go ahead.
So, Mr. Burke, you and I visited before the plea last time, didn't we?
Yes,
shortly.
Yes, sir.
So I want to be frank with you and ask you a couple of questions.
Yes.
When I read through your stepson's report here, his problems have been existing all the way from when he was a juvenile. He was running away from home. He even got as extensive trouble as being in possession of some drugs within a drug-free zone. So, I mean, we're already having problems when he was a juvenile.
That's correct.
And right when he turned 17, he ends up with a felony offense that gets him a 5-year sentence.
That's correct.
Right. So you were in his life. When did he get out of TDC? From that 5-year sentence that he got on the burglary habitation?
I want to say that he got out in 2020.
So anywhere between 2020 and 2022, right?
Yes, sir.
And you don't remember that yourself today, right? But the same thing that you're telling the judge, the family and the structure, you and your wife have been there for him through that time frame, haven't you?
Correct.
Right. So I'm going to tell you, I'm concerned with that. And the other thing I'm concerned with is that after he gets out of prison, he ends up committing multiple offenses in 2022 that I was a stepfather too. It's just shameful to even see this on a piece of paper. He was convicted twice of family violence. That's not something you taught him.
What was that?
Yes, sir.
What was it?
His mother of his child. They were trying to live together, and I'm assuming they got into an altercation, an argument of some kind, and which resulted the authorities coming. And I'm not sure all that played into that, but he wasn't living with us in our home at this particular time.
When was the last time he lived with you and your one?
With us? I know that he came right after he got out of prison the first time. He paroled to our home. And
so we know he was convicted in 2016.
And it's in 2020.
5 years in prison, so he gets out in about 2020.
Yes, sir. We picked him up from the Clemens unit there in Rosario County.
You know, he was given probation for those misdemeanor offenses, but he didn't complete that. He got revoked.
Right.
Is there anything you can tell the judge that it can exist differently about this probation that you're asking for to try to turn this young man around?
And just before you answer that, what concerns me is, all of us make mistakes. All of us make mistakes. Welcome to humanity. We're all in it. But it's how you deal with your mistakes is the real test of character.
Right.
And
yes, I'm sorry.
the defendant goes to prison after some problems as a juvenile that apparently in 2014 did not work out for the extended period of time, because he gets arrested, a date of offense for these 2 burglaries in 2016. He gets imprisoned, and in 2016 he is 17 years of age.
Right at 17, yes, sir.
And he just turned 17, which so right into being responsible as an adult in 17.
Yes,
he goes and commits burglaries of homes, which if he was shot by the homeowner would, of course, that's an absolute defense. And that's why those laws are so strict. And it's dangerous to be burglarizing somebody's home.
Absolutely.
Anyway, but he gets 2 convictions, so he serves a 5-year sentence and he's released. And then thereafter, he goes to live with y'all.
Yes, sir, he paroles to our home.
But he's in March of 22, he picks up family assault and also a violation of a bond or protective order. So that's a law. Family assault, that's another criminal law. And then a violation of a bond or protective order, which is a court's order that you're asking for probation here, and he would be on court orders. But he's proven that he can't follow court orders in the past. And so he was revoked and sentenced to confinement on those 2 matters. Thereafter, in in fact, before that, he commits escape, and I'm not really clear about what happened on that, but he was convicted of that and sentenced to confinement, looks like jail confinement for that misdemeanor. So he's picked up 1, 2, 3, 4, 5. On 5 crimes, 5 misdemeanors, he was convicted, including assault, family violence, assault, 2 assaults of family violence, among other things. Then 2 felony convictions of burglaries of habitation. But it was after he got out and was living with y'all that he picks up those 22 assaults and violates his bond, escape, while he's kind of under y'all's more supervision. So we know that the previous supervision with you, as well intended as you are describing it, you can't live his life. It's his choices and your choices. You seem to be articulating that you're a good choice maker. And why your stepson has not, is that right? It's your stepson, not your,
Correct.
Mother, you're married. But nonetheless, you came into the family, so you're a role model. I presume his actual father is not much in his life.
Right.
Okay, so you sound to be a good role model, and the question is, what's your problem? Who can you blame but you? But you have you may have had a role model in your family before that failed. Your natural father, I don't know, but it sounds like that he did make good choices as a parent. But you knew better, that's not right. So you rebel on that, but you've got a good father figure now. You hadn't had one for 2004, since 2004. So why would you make poor choices when you've got a good example? And you also know that when you make bad choices, you get your hands back like we all do. We get punished. Why would you want to get punished again? It has consequences. And so we're talking about violations of law here. Just as an adult, 1, 2, 3, 4, 5, 6, 7. 2 of those are felonies. The others are misdemeanors. And I'm not even counting the juvenile problems that you have, which amount to now adding over 10 criminal matters that you were held responsible for and punished for separately. So why is it that you should get a 12th second chance?
Commissioner Speaker.
Go ahead.
Time I sat in there, I had time to really reflect on my life. And it's not the life I want to live anymore. It's getting old to me. And parents I got, they love me. They love me, And I shouldn't hurt them. In order to love them the way I should love them, or the way they love me,
I should love myself enough not to hurt them by coming to jail doing drugs, hanging around the wrong crowd. I also got a son now that loves me, and you know, in order to love him back, I have to love myself. And I'm gonna start by having some self-love and walking down the right
How old
path.
is as your child?
3. He's gonna be 3. It's gonna be 3 in August. And
what is his date of birth?
August 18th, 2022.
Okay. So, the lady was pregnant with your child 9 months before that, I guess, the first of 2022. And yet you knew that, right? You knew she was pregnant. So your charge, you then, after learning that news, being a family, a responsible person now, as a father figure, a role model, you committed 5 crimes there within the few months after learning that. So how is it that a child in your life made a difference? That is going to make a good difference when you went out and went on a crime spree, knowing that you had another life that you were responsible for, other than yourself.
I was still kind of young-minded. I was still finding myself young, but now that I feel like I have found myself. I feel like I truly have found myself now. I'm not getting any younger. My son isn't getting any younger.
How long have you been in jail now?
I've been in jail for a year now,
How's that working out? Families together, unit? No, it's not when you were in jail. And plus, they're in jail with you. Okay, okay, I understand.
And then, Judge, I had this.
All right. Thank you, sir. All right. Raise your right hand, ma'am. Do you solemnly swear or affirm the testimony you are about to give shall be the truth, whole truth, and nothing but the truth, so help you God? Okay, go ahead with introducing this lady. Thank you.
All right, would you state your full name for the record and tell us briefly about yourself?
My name is Sandra McFeeders. I'm 49 years old. I have 3 children, 2 girls, and Chad, and our grandson, Charlie.
And are you employed?
I am, we'll be working at Baptist Hospital on the 27th. I was working for Dr. Albert for Albert. But I'm on my 2-week notice thing, so I'll get back.
So basically what you have here is husband, wife, middle class family, pretty much middle class jobs. And you heard one of the major questions of the judge is that, hey, your son has all of these situations where he's becoming involved in law enforcement, whether it is the family violence. The judge mentioned about going to the prison in his adult history. Let's get straight to the point, all right? He's hit the wall several times, right? And judge is asking a good question. Okay, well, hey, he hit so many times. Why should I give him a chance today, looking at what has happened in the past? Do you follow his argument, right? Line of thinking.
Yes.
All right. So what I want you to do is to answer him directly on that question, which is, considering all that has happened in the past, why should we give him that deferred adjudication shot today? And you can answer him however you want to answer. You can look at him and tell him what you think. Go ahead.
Okay, yes, all of these things happened with Chad when he was really young. He was very young minded. He actually started doing drugs in the 6th grade. It's when they, he said he was having a bad time, a bad day. And one of the kids told him, hey, I got something to help you. And ever since then, we've been trying to help him, ever since he was in the 6th grade. Now, I do believe that he has learned his lesson. I do believe that he was very young when all these things was happening to him, having had time to really think about his life.
Why do you think he's learned his lesson?
Well, I guess.
Because really the only thing different is he's been in jail. He's been in custody. Nobody likes that. So they're going to say anything to get out. Oh, okay. I don't like this. This is punishment. I don't like this. Only sociopathic people enjoy being punished. So we know he's not mentally ill that way, so. He's just, it's just natural for him to say, I'm tired of here, this is punishment, I don't want to be here anymore, let me out. That's just normal. But what is it that we can say that's specific that is different in his life that would reflect success?
Yes.
Because he's got an environment that has success as a potential. He just didn't care to choose that, and then committed all these offenses and mistakes. What did we say, 11 times? Well, yeah. 12. My goodness.
Well, I believe that, we have more of us, like back then, just me and my husband mostly, we have more family involved. That they expect that with us and help with him, and getting himself together, and I just chose to believe that he's gonna change this time.
What's different about the role modeling in the family than before? By the role modelers, what's different? I don't see anything different. It's just him that's different. He just does not accept or decide to take part in the family unit as a responsible person. And he had role modeling in the household. So it's your fault, your choice. Everybody else is rowing the boat. You want to ski. Roll fast so I can ski. I just want to avoid committing crimes. Y'all do all the heavy lifting. That's not fair. Would you agree? Go on.
Well, we do have our pastor involved with it. And
I'm sorry.
We have our pastor involved as well.
What's he doing? Or she?
He.
Who's your pastor?
Pastor Perez came to.
Okay. Well, what would that man do?
Well, excuse me. Yeah, he would come to the house, talk with him, and will help us with him trying to get jobs together. Just really consoling with him and spending time with him and trying to get him on the right path like we are.
At the end of the day, all of these things sound great, but at the end of the day, it boils down to one thing. It's your choices that are leading, not the pastor, not your mom, not your stepfather, not the attorney, not all of these other people who are trying to help you, that you're rebelling against yourself on, working against yourself. It's all boils to you. And you've made a series of bad choices up to now. Series. And then now there's nothing that's been changed. You've had more than your fair opportunity to make the right choice. But you do. And you stick your hand on the hot stove, it's going to burn you. But you're now embracing the stove. You're just not touching it. You're grabbing it and hugging it. Because it's like, I enjoy being burned. No, who does that? Nobody likes that. But that's the way it looks in this thick document. Okay. All right, I think I know where we stand. Anybody else has anything else to say?
No questions of her, Your Honor.
Anything else you would like to say, sir? Thank you, man.
My name is Section Small. I feel like I really have, I know it may seem like just because I'm in a bind that.
Yeah, everybody's going to say, you're going to try to tell me something that I want to hear. Because you're in a bind. The thing that bothers me is you've had far more chances than the average person in this, as a defendant in this court, to make the right choice. And you have failed miserably up to now. So there's nothing that's really changed except you're getting tired of being in jail. That doesn't help me in making a decision that takes you out of confinement, because the community is a lot safer with you in jail. It's been proven now. When you get out, you go and commit crimes.
I like to be around.
What's different about it other than, are you saying you're finally maturing?
I am,
Okay.
I'm finally maturing. And it took a while, but I'm finally maturing. I promise this is the last time. This is the last time I can ever go through this. Last time.
Well, the last time should have been several,
I understand,
11 times ago.
I understand this,
Anything else?
Just,
Yeah.
one of the biggest things is the probation department, at least from one of the things I read in the report, where they said defendant's positive attributes suggest potential for
Successful probation if adequately supported.
And I think the adequate part, which is the condition of the statement, is I think we've demonstrated the adequate support side in the sense of he got middle class parents.
I know, but he's had that adequate support available for him several bad mistakes ago. They've been available in the household, and yet he still rebelled in his decision making. Right? Wouldn't you say? I mean, the man's been in the house since 2004 as a role model.
I think one thing that Dad brought out was it's like the girlfriend incident. He had moved out of the house, but I think if you give him probation, they're going to keep him in the house, and with him in the house, that adequate support will be there. He won't be out of the house. Yeah, actually live with him, right? He's gonna live with y'all, right? That's correct. And I think under their roof versus being outside of their roof, it'll be a tremendous difference in his behavior and adaptation to
all right,
society.
If nothing further, the court has taken all that into account, and in reviewing the pre-sentence report that's been made a part of the record. Does any of the attorneys wish to add anything else? I think I know your thoughts on it.
Yes, sir. Go ahead.
If nothing further, I'm going to find that earlier in this case, the defendant had pleaded guilty to the third-degree felony of unlawful possession of a firearm by a previously been convicted as a felon. And he did that voluntarily, knowingly, intelligently. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt. That's another felony conviction. I am following this agreement, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 8 years. You will be given credit for all time you have served in accordance with this charge. Do you understand what has happened here today, sir?
Yes, Your Honor.
Oh, all right. You will be given credit for all time you served. Anything else you want to say?
No, Your Honor.
And nothing else? How'd that sink in with you? Like something fell on you?
It's all right.
Like a car falls on you?
Hurts. It does hurt.
All right. The court is going to further suspend the sentence. You will be placed on 10 years probation.
Thank you, Your Honor.
There will be terms and conditions of probation. Number one, you will be required to undergo a comprehensive mental health evaluation by a licensed psychiatrist. And maybe Dr. Gopon has fulfilled that in his September 11th report in determination of competency. But we want to make sure that you don't have an excuse for any failures. You will be subject to a substance abuse evaluation, and you will enroll in and complete any substance abuse treatment program that the probation office deems is appropriate.
Yes, Your Honor.
You will complete some cognitive intervention programs that are available for such offenders, including the moral reclamation therapy program, which helps you make better choices than you've been making. You will be required to complete your education, your high school equivalency, and any further vocational training that helps you become a responsible person to yourself and to your family. You will be ordered to refrain from possessing or accessing firearms, other weapons, any illegal drugs that have not been properly dispensed and diagnosed as something you should take for your assistance by a licensed medical physician.
Yes, Your Honor.
You will perform 600 hours of community service, and you will be on high intensive reporting plans that the probation office will monitor and control. Here's the other thing. One failure away. One mistake. And everybody makes mistakes, but I'm talking about from these intention, any knowing and or intentional failures to follow these conditions, which are strict, will result in you coming back here real quickly. And I don't know what else you could say. It's not going to be anybody else's fault but yours.
Right.
Unless it's somebody else's fault that made you do it, which seldom happens. But if it is, we'll take that into account. Otherwise, if it's your decision, you've been on notice that you are on thin ice, and 8 years in prison is where it will end up if you fail to follow these terms and conditions of probation. But I know a judge went over all of these one time before and you failed. But you understand what the court has tried to convey to you today, that failure is not an option for you.
Yes, sir.
Anymore. I don't see a problem. I didn't hear one. Now, the probation office, which has a 90+% success rate for probationers, is going to review all of this with you here in a little bit, make sure you understand everything. Because if you're back here, you're going to have a hard time. You have to explain